Tabling of documents. Pursuant to Section 79.22 of the Parliament of Canada Act, it is my duty to present the House a report from the Parliamentary Budget Officer entitled Supplementary Estimates A 2018-19. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you. Mr. Speaker, pursuant to Standing Order 36(8), I have the honour to table in both official languages the government's responses to 11 petitions.
Introduction of government bills. Mr. LeBlanc, seconded by Mr. Sohi, moves for leave to introduce a bill entitled An Act to Amend the Mackenzie Valley Resource Management Act and the Canada Petroleum Resources Act, and to make consequential amendments to other acts. This motion is deemed adopted. Mr. LeBlanc, seconded by Mr. Sohi, moves the bill be now read a first time and be printed. This motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
Is it in? Is it? When shall the bill be read a second time? At the next sitting of the House. Very good. Fine idea.
Statements by ministers. Reports from interparliamentary delegations.
Committees. The honourable member for Malpeque.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour to present in both official languages the 24th report of the Standing Committee on Finance entitled Confronting Money Laundering and Terrorist Financing, Moving Canada Forward. Pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to this report. This report, Mr. Speaker, accomplishes the 5-year statutory review of the Proceeds of Crime, Money Laundering and Terrorism Financing Act, and I have to send a heartfelt thanks to all members of all parties of the committee for their hard work in producing this report. This was a study within which partisanship really did not intervene, and I also want to thank the Library of Parliament staff who worked long hours to produce this end product. And a second report, Mr. Speaker, to table. I have the honour to present in both official languages the 25th report of the Standing Committee on Finance in relation to Supplementary Estimates A 2018-19. Thank you, Mr. Speaker.
The honourable member for Yukon.
Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Present in both official languages the 75th report of the Standing Committee on Procedure and House Affairs entitled Approval and Updating of the House of Commons Electronic Petition System. As members know, a couple of years ago, Parliament had the idea to add electronic petitions as an option to paper petitions, and so they did a provisional, test project for a couple of years that Procedure and House Affairs had to review. After that time, we reviewed it and have made suggestions that it be permanent, made some improvements to it, to the petition system. So, Mr. Speaker, I think when this report is implemented, if this report is implemented, it'll make the electronic petitions permanent and more efficient. Thank you.
Mr. Speaker, I have another report pursuant to our mandate. I have the honour to present in both official languages the 76th report of the Procedure Committee. I'd like to propose the adoption of this report, tabling private members' bills, first reading of the Senate public bills. Motions. The honourable member for Yukon.
President.
Mr. Speaker, if the House gives its consent, I propose that the 76th report of the Committee on Procedure and House Affairs be adopted. Does the honourable member for Ashilaga has a question? Yes, He was talking about the 66, and it should be the 76.
76e.
76e.
Yes, the 76th report. I thank the honourable member for Hochelaga for clarifying this. Does the honourable member have the consent of the House? Thank you. Agreed. The House has heard the motion. Is it the pleasure of the House to adopt the motion? Adopted.
Présentation de pétition
Presenting petitions.
for Algoma, Manitoulin, Kapuskasing.
Thank you very much, Mr. Speaker, and I'm pleased once again to rise in this House to table petitions concerning a pan-Canadian strategy on eating disorders. Mr. Speaker, eating disorders such as anorexia, bulimia have the highest mortality rate of all mental illnesses. However, the sooner someone receives the treatment, Mr. Speaker, the better the chance of recovery. Mr. Speaker, currently there are children as young as 7 who are affected by eating disorders and have been diagnosed and are being hospitalized for these eating disorders, and more than 1 million Canadian sufferers and families have been negatively affected physically, emotionally, financially by these struggles. And I'm just wondering, Mr. Speaker, that the petition, I should just say that the petition is actually calling upon the Government of Canada to support motion 1117, which happens to be 117, which happens to be my petition, Mr. Speaker, and they're asking that it be initiate discussions with the provincial and territorial ministers responsible for health and all stakeholders to develop this comprehensive pan-Canadian strategy for eating disorders, and that it should include prevention, diagnosis, treatment, support, and as well as research, Mr. Speaker. Thank you very much.
Member for London Fanshawe.
And I have a petition in support of postal banking because nearly 2 million Canadians desperately need an alternative to payday lenders whose crippling lending rates affect the poor, marginalized, rural, and Indigenous communities most. The petitioners are pointing out that 3,800 Canada Post outlets already exist in rural areas where there are few or no banks at all. And Canada Post has the infrastructure to make a rapid transition to include postal banking. And so they asked the Government of Canada to create a committee to study and propose a plan for postal banking under the Canada Post Corporation. And a second petition, Mr. Speaker, and this is timely in light of Remembrance Day on Sunday. The petitioners, citizens of Canada, draw the attention of the House to the fact that at one time the Government of Canada issued the Canadian Volunteer Service Medal, to recognize Canadians who serve voluntarily in the Canadian Forces. Now this medal stopped in 1947, but the undersigned citizens call upon the Government of Canada to recognize by means of the creation and issuance of a new Canadian Military Volunteer Service Medal to be designated the Canadian Military Volunteer Service Medal for volunteer service by Canadians in the regular forces, reserve military forces, the Cadet Corps, support staff, all who have completed 365 days of uninterrupted, honorable duty in service to this country. And they wish that this be presented in perpetuity. Thank you, Speaker.
L'honorable député d'Hochelaga.
The honourable member for Hochelaga. Thank you, Mr. Speaker. Today I'd like to table a petition signed by residents of my riding of Hochelaga who ask the Parliament of Canada to work with the provinces, territories, municipalities, and organization to come up with a national strategy on aging which would guarantee high-quality care for all seniors, to guarantee the availability for seniors of appropriate housing which will meet their needs, and to help design programs that will ensure a better quality of life for seniors and create a post of ombudsman for seniors. Thank you, Mr. Speaker.
Strathcona.
Mr. Speaker, I have the privilege today of presenting a petition from more than 150 Edmontonians. Those petitioners are reminding that the Canadian government has publicly committed itself to the defense of human rights internationally. and that the Magnitsky Act was passed a year ago, allowing for restrictive measures to be taken against foreign nationals responsible for gross violations of internationally recognized human rights. And they remind that to date the Canadian government has taken no action against Russian authorities responsible for the unlawful imprisonment and brutal ill treatment of 3 Ukrainian hunger strikers, Oleh Sentsov, Alexander Shumko, and Volodymyr Baluk, and approximately 60 other Ukrainian political prisoners. The Magnitsky Act has not been invoked against Russian officials responsible for these violations. They call on this place, on the House of Commons, to demand the release of those political prisoners and the dozens of others illegally detained by the Russian government, and to employ all possible sanctions, including measures under the Magnitsky Act. Thank you.
The honourable member for Nanaimo Ladysmith.
Thank you, Mr. Speaker. Because marine plastics are spreading all over BC's coast, entering salmon, littering beaches, a lot of it actually based from British Columbia, but some also coming from overseas. Petitioners from Nanaimo, Parksville, and Lanceville have asked me to convey to the House their strong call to this government to develop a national strategy to combat marine plastic pollution. It would particularly involve regulations on the single use of plastics to prevent plastics from entering the marine environment in the first place, and also to fund in a permanent and ongoing way some of the pieces that we've been unable to tackle, like ghost nets, which move across the ocean, capturing fish and dolphins and so on. It's a terrible emergency. We call on the government to act. Thank you.
Presenting petitions. Présentation de pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, the following questions will be answered today. Question 1931 and question 1932. And then furthermore, Mr. Speaker, if I may, I ask that the remaining questions be allowed to stand.
Hear, hear. Is it agreed? Agreed, and so ordered. I am now prepared to rule on the point of order raised on November 1st, 2018 by the Honourable Member for Berthier-Masquinongé concerning the response to the New Democratic Party Vice Chair of the Standing Committee on Agriculture and Agri-Food during oral questions. I would like to thank the member for Berthier-Masquinongé for having raised the matter, as well as the members for Cowichan, Malahat, Langford, Perth, Wellington, and Durham for their observations. Essentially, the member is asking for clarification on the Speaker's role with respect to oral questions, given that the NDP Vice Chair was not permitted to finish his reply about committee business.
As I reminded members when this point of order was first raised, questions about committees are quite restricted. House of Commons Procedure and Practice, 3rd edition, at pages 512 and 513, is clear in this respect, stating, and I quote, "Questions seeking information about the schedule and agenda of committees may be directed to chairs of committees. Questions to the ministry or to a committee chair concerning the proceedings or work of a committee, including its order of reference, may not be raised." Unquote.
On May 20, 1970, which can be found at page 7126 of Debates, explained, "The only questions which are acceptable when directed to the chairman of a committee are questions which relate to procedural matters, whether a meeting is to be held, whether a committee will be convened, at what time a committee will be held, and so on. Les réponses aux questions de cette nature."
The answers to such questions about committees must fall within these same prescribed limits. As indicated at page 1041 of Boskin-Gagnon, quote, "During oral questions in the House, a committee chair may answer questions provided they deal with the committee's agenda or schedule and not with the substance of its work," unquote. The Speaker has the authority to judge the admissibility of questions, including those put to a committee chair. Deputy Speaker Blakey informed the House on April 3rd 2008 at page 4406 of debates that, and I quote, "In future, when considering the procedural acceptability of such questions, the Chair intends to demand strict adherence to the intended practice, namely the scheduling and agenda of committee meetings," unquote.
However, it is not up to the Chair to judge the quality or content of answers, save for unparliamentary language. The constant challenge for the Chair is, on the one hand, to uphold the limits placed on questions asked about committees, and on the other hand, to refrain from judging the quality of the answers. Perhaps it is this that explains, at least in part, the approach of the Chair in according chairs and vice chairs the benefit of the doubt. It is an approach that the Chair will uphold going forward. The rapid pace of question period, given the 35-second limit on both questions and answers, requires the Chair to make quick decisions, and it is always within the intent of respecting our rules and practices. It is in this context that I, as Speaker, look forward to working with all members to ensure that our practices are followed in any exchanges of information about committees. I thank members for their attention. Orders of the day.
Government orders, government bills, comments.
Page on Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts.
Or lower. Order. Sorry. There are 14 motions and amendments standing on the notice paper for the report stage of Bill C-75. Motions numbered 1 to 14 will be grouped for debate and voted upon according to the voting pattern available at the table.
I will now submit motions 1 to 14 to the House.
Mr. Sohi for Ms. Wilson-Raybould, seconded by Mr. LeBlanc, moves that Bill C-75 be amended by deleting Clause 22. Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 61. Excuse me. Those are motions number 1, motions number 2. Motion number 3, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 87. Motion number 4, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 89. Motion number 5, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 90. Motion number 6, Mr. Cooper.
Motion number 6, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 106. Motion number 7, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 107. Motion number 8, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 108.
Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 109. Motion number 10, Mr. Cooper, seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 186. Motion numéro 11.
Motion number 11. Mr. Sohi for Ms. Wilson-Raybould, seconded by Mr. LeBlanc, moves that to Bill C-75 in Clause 294 be amended by replacing lines 10 and 11 on page 120 with the following. Monmi given by a police officer as defined in Section 183 in presence of an accused during a war.
Seconded by Mr. Sorensen, moves that Bill C-75 be amended by deleting Clause 310. Motion number 13, Mr. Sohi for Ms. Wilson-Raybould, seconded by Mr. LeBlanc, moves that Bill C-75 in Clause 389 be amended by replacing, in the French version, line 6 on page 183 with the following. modifiant le Code criminel, la loi. Monsieur Sohi for Madame.
Mr. Sohi for Ms. Wilson-Raybould, seconded by Mr. LeBlanc, moves that Bill C-75 in Clause 407 be amended by deleting lines 23 to 32 on page 197. Debate.
The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Mr. Speaker. I'm very pleased to participate in the report stage debate in support of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments thereto. As a lawyer, I'm all too familiar, Mr. Speaker, with the effect that delays can have on all Canadians, and particularly those involved in the criminal justice system. I'm proud to be a member of a government that is taking a meaningful and significant approach to promote efficiency in our criminal justice system, reduce case completion times, and contribute to increased public confidence, while respecting the rights of those involved and ensuring that public safety is maintained.
I believe that the aspects of the Bill C-75 will contribute to creating a change in culture necessary and to strengthen the ability of the justice system to resolve disputes in time prescribed by the Supreme Court of Canada under the Jordan decision. It is recommended by the Senate Legal Affairs and Constitutional Affairs Committee in its report entitled Justice différée.
Justice and Human Rights for their hard work in studying Bill C-75. Though there are many important aspects of this bill, Madam Speaker, that I believe will contribute to a more efficient criminal justice system, I would like to focus my remarks this morning on preliminary inquiry reform, enhancing judicial case management, and facilitating remote appearances. I would also like briefly to touch on the amendments brought forward by the committee and consequential technical amendments thereto.
As the Minister pointed out in her remarks, C-75 includes the two proposals on preliminary investigations. The bill limits this procedure for 63 of the most serious criminal code offenses leading to life imprisonment, such as murder, for example. It would also, Madam Speaker, strengthen the position of the judges to limit questions and the names of witnesses to be heard during the investigation.
Jordan and the Senate Legal Affairs Committee, in its final report on delays, recommended that preliminary inquiry reform be considered. Madam Speaker, we acknowledge that the issue of preliminary inquiry reform has been the subject of lively debate for literally decades. Some have said that restricting preliminary inquiries will have little impact on delays, given that they are held in only 3% of cases. However, this impact, which is important to underscore, this impact will be greater in those provinces where the preliminary inquiry procedure is widely used, such as in Ontario and in the province of Quebec. Also, we cannot overlook the cumulative impact of all of Bill C-75's proposals that seek to streamline the criminal justice system processes. Les avocats Laurelie Dale.
Two lawyers have stated at the Justice Committee that limiting preliminary inquiry, as the bill proposes, could cause additional delays and hinder the offender's right to a fair trial. The head of the Police Association indicated in his written remarks that the reforms were supported. Daisy Clare and Elizabeth Sheehy stated, Madam Speaker, that these changes were a step in the right direction and reminded us that a requirement to appear twice at a preliminary inquiry and at a trial would contribute to re-victimizing a victim.
At the second reading of Bill C-75, the proposed preliminary inquiry amendments are the culmination of years of study and consideration in various fora, such as the federal, provincial, territorial meetings. These reforms represent a balanced approach between the opposing views put forward before both committees and those expressed before this very chamber. They will make this procedure more efficient and more expedient while respecting the accused's rights to a fair trial and preventing some witnesses and victims from having to testify twice. A very important impact, as I just mentioned, on women litigants in the criminal justice system. Bill C-75 would also allow for the earlier appointment of case management judges, which recognizes their unique and vital role in ensuring that the momentum of cases is maintained and that they are completed in an efficient, effective, just, and timely manner, Madame la Présidente. Le projet de loi
Bill C-75 also proposes to broaden recourse to remote appearances under the Criminal Code to enable all people to participate in criminal issues. The accused, witnesses, lawyers, judges, justices of the peace, interpreters, and others to participate by audio or video conference throughout the process, provided that the criteria are complied with.
Allowed remote appearances for many, many years. These amendments seek to broaden the existing framework with the possibility of using technology to promote access to justice where the infrastructure exists and as permitted by the rules of court. These optional tools in Bill C-75 aim to increase access to justice, streamline processes, and reduce system costs, for example, the cost of accused transport, the cost of witness attendance, without impacting existing resources such as those through the Indigenous Court Worker Program. They also respond to the Senate Committee's very own recommendation to increase the use of remote appearances for accused persons. Madam Speaker, the proposals in Bill C-75 in relation to preliminary inquiries, judicial case management, and remote appearances, together with all of the other reforms in this bill, will ensure that our criminal justice system is efficient, just, and in line with the values of our communities and all Canadians. As a product of the extensive study of this bill and the compelling testimony from witnesses, the Standing Committee on Justice and Human Rights amended the bill with regards to routine police evidence and some reclassifications of offences. As a result of these amendments, 4 technical and consequential amendments must be moved to ensure coherence in the legislation. So these amendments follow therefrom from the proper amendments made by the committee at committee stage. The first of the technical amendments would involve the consequential amendment to Clause 294 of Bill C-75. That clause, Madam Speaker, deals with the admission of police officer transcripts as evidence and currently references the definition of, quote, a police officer in the proposed Section 657.01 of the Criminal Code. As Section 657.01 was amended and deleted at committee, an amendment is now required to Clause 294 to remove that reference to that previously proposed section. The second and third amendments that are being put forward today, Madam Speaker, respond to the committee's intention to keep the offences of advocating or promoting the commission of terrorism under Section 83.221 of the Code as a straight indictable offence. Accordingly, the Second Amendment today will delete Clause 22, and the Third Amendment will delete Clause 407 sub 5, which is a coordinating clause in accordance with Bill C-59, Madam Speaker. Again, consequential technical amendments that follow from the important and extensive study by the committee of this bill. The Fourth Amendment presented before you today in this House, Madam Speaker, corrects a drafting error resulting from an amendment to Clause 389, which includes a mistake in the French version of the title of Bill C-75 and describes Bill C-75 as, en parenthèse, loi modifiant, ouvrez les guillemets, Madame la Présidente,
An act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts to make consequential amendments to other acts.
Madam Speaker, that follows therefrom from the important amendments made at the committee stage. Madam Speaker, in my final 2 minutes, I just want to highlight what we are dealing with in this law. We have a situation where access to justice is critical. We have a situation where court delays are preventing justice from being rendered. We have the Jordan decision that was presented by the Supreme Court of Canada. Following the results of the Jordan decision, the minister, the parliamentary secretary, went around the country and heard from stakeholders. They heard from people in the system. They heard from federal and provincial and territorial partners. And as a result of that collaboration with the provincial and territorial partners, we put forward a bill, Bill C-75, to this House. That bill was then studied at the committee stage, and the committee, after hearing robust testimony from a number of stakeholders from right around the country who were involved in the criminal justice system, properly and rightfully took forward the initiative to amend the bill in the right direction with respect to the key areas I've mentioned. That is the way our system is meant to work collaboratively. That is what we are doing with this bill. This bill will ensure that women are not re-victimized through the preliminary inquiry process. This bill will ensure that we no longer have the overrepresentation of Indigenous and other marginalized communities in our justice system by changing the way we select jurors and changing the tools that judges have to ensure a more diverse and representative jury in committees. Very importantly, this bill will ensure access to justice. It will treat administration of justice offences through a separate model, a different model that allows things to be dealt with in a more general manner, in a manner that speeds up the proceedings and does not overly criminalize people that are interacting with the justice system. These are important initiatives. It's an important bill. It is in the right direction, Madam Speaker, and that's why I would urge all members of this House to support it. Merci beaucoup.
Thank you very much.
Then comments. The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker. And the Parliamentary Secretary to the Minister of Justice noted that at the Justice Committee, Liberal members did the right thing in supporting our Conservative amendments to amend Bill C-75 so that serious indictable offences, namely terrorism and genocide-related offences, would not be reclassified to be hybrid offences. And in so doing, they listened to the testimony of, among others, Shimon Vogel of the Center for Israel and Jewish Affairs, who said that to reclassify such offences would, quote, send a clear and unacceptable signal diminishing the inherently grave, even heinous nature of these crimes, unquote. Similarly, the member for Edmonton Centre said, let's be serious, these are serious offences. Unfortunately, Madam Speaker, they decided to double down on the reclassification of such offences as impaired driving causing bodily harm and kidnapping a minor under the age of 14. What kind of message does that send?
The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Madam Speaker, I thank the member opposite for his question and for his contributions at the committee stage. I also thank him for referencing Mr. Shimon Vogel from CIJA, who I'm very pleased was here yesterday to hear the Prime Minister apologize for historic anti-Semitism in this country and for the continued fight against anti-Semitism now. Apropos of that very apology, apropos of that very serious issue in this country, what the committee members took, the step that they took is a step that we agree with as a government, that when you take seriously the fight against racism, take seriously the fight against discrimination, take seriously the fight against hatred, then you must demonstrate significantly and strongly that instances and crimes such as advocating genocide need to be denounced in the strongest terms. And those types of offences need to remain and will remain as straight indictable offences. That's a result of the hard committee work that was done at committee, and that's committee work that we agree with full vigour. Thank you, Madam.
Questions and comments? The honourable member for Edmonton Strathcona.
Thank you, Madam Speaker. Madam Speaker, I'm deeply concerned, and I share the concern that has been expressed in the House and at committee by my colleague, the NDP Justice Critic, the member for Victoria, and that is that despite the Minister of Justice's mandate letter, which directed that she would remove minimum mandatory sentences, and despite the fact that the Criminal Trial Lawyers Association of Canada called for that because of the delays in court proceedings. One of those reasons is many matters are going to trial because of the fear of this minimum mandatory sentencing. I'm wondering through you, Madam Speaker, if the member can speak to why they did not deliver on the instruction of removing the minimum mandatory sentences. Why did they refuse to do that? They could have done it within this 300-page bill.
The Honourable Parliamentary Secretary.
Madam Speaker, the member opposite raises an important point, and she references the mandate that was given to the Minister of Justice. The mandate that was given to the Minister of Justice was to do a comprehensive review of the court system and the criminal justice system and to propose methods of reform to speed up the processes and make it more efficient. That is exactly what we were doing with Bill C-75. Bill C-75, by creating administration of justice, or an administration of justice regime, will speed things up. By reducing the reliance on preliminary inquiries to a more circumscribed set of the most serious offences, will speed things up in the criminal justice system. The issue of mandatory minimums was raised at committee. It is an issue that the government is seized with. It is an issue that requires a broad and sweeping analysis and study. That is something that the departmental officials indicated requires more further consultation and study in order to get it right. A piecemeal approach to something in the nature of mandatory minimums would not be appropriate in this bill or otherwise. Thank you,
We
Madam
have
Speaker.
time for a brief question. The honourable member for Battle River Crowfoot.
Just very briefly, Madam Speaker, thank you very much, and thank the Parliamentary Secretary for his speech. He talked about this speeding up the court system and access to justice and access to court times, believing that turning some of these very serious offences into summary offences or hybrid offences, that would somehow speed it up. I guess my question to him is, there is another option, and that is that the minister fill the vacancies, hundreds of vacancies of judges across this country, so that there's access to a judge. And right now, that is another area that she could do very quickly. Why doesn't she?
A very brief answer from the Parliamentary Secretary.
The brief answer, Madam Speaker, is that we are appointing judges at a rate that has not been seen in this country for over 2 decades. The minister has appointed 230 judicial appointments around this country, and we're doing those right around the country, and she's also doing it in a manner that is commensurate with what the bench should reflect, which is the Canadians that they serve and the Canadians to whom they render justice. By promoting the number of women, visible minorities, LGBT community, persons with disability, we're not only appointing judges, we're appointing judges that look like Canada.
Resuming debate. The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker. I rise to speak on Bill C-75, legislation that the government has introduced that purportedly is aimed at dealing with the backlog and delay in Canada's courts. The only problem, Madam Speaker, with Bill C-75 is it does next to nothing to deal with the backlog and delay in our courts. Indeed, more than likely, what Bill C-75 will do is do the opposite of reducing delay and actually increase delay in our courts. This bill was studied before the Justice Committee, and I attended all of the Justice Committee meetings in which we heard from a wide array of witnesses. And I can say that in the 3 years that I have been a member of Parliament, I have never been at a committee in which a bill has been as exhaustively and as comprehensively panned as Bill C-75 on virtually all aspects of this massive 300-page omnibus bill. This bill, Madam Speaker, does nothing to deal with delay. The government came up with this brilliant idea that so-called routine police evidence could go in by way of affidavit. The only problem with that is it would require a whole new application process that defense counsel would inevitably use, resulting in more delay, not less delay. Now, it's good the government has backtracked from that aspect of Bill C-75. They then came up with the other idea that preliminary inquiries should be limited to only those cases in which the maximum sentence is life behind bars. Madam Speaker, when I asked Justice Department officials whether they had any data, any empirical evidence to back up the assertion that preliminary inquiries were resulting in delay, their answer was that they had none. But Madam Speaker, I can point to empirical data that demonstrates that, in fact, preliminary inquiries do speed up the process and do reduce delay. Indeed, 86% of cases are resolved following a preliminary inquiry. That's statistical data. The government has none to demonstrate the contrary. And, of course, preliminary inquiries do provide an opportunity for counsel to clarify issues, to narrow issues, to test evidence, as well as there is an important discovery aspect to a preliminary inquiry. Moreover, it's unclear how the government decided to arbitrarily create two streams of cases. One where the sentence is life, in which an accused would be entitled to a preliminary inquiry, and then another stream applying to all other cases, notwithstanding that in many instances the sentencing guidelines or the sentencing ranges would be similar, but in certain cases the accused would be entitled to a preliminary inquiry. In other instances, they wouldn't. It speaks, Madam Speaker, to, I think, the very sloppy and haphazard way that Bill C-75 was drafted. But the biggest problem, Madam Speaker, with Bill C-75 is that under the guise of creating efficiencies in Canada's justice system, it waters down sentences for the most serious, among the most serious indictable offenses. What sort of offenses is Bill C-75 proposing to water down by reclassifying them from indictable to hybrid? Well, Madam Speaker, we're talking, among other things, about impaired driving causing bodily harm. Impaired driving, Madam Speaker, is the leading criminal cause of death in Canada. Administering date rape drugs, kidnapping a minor under the age of 16, kidnapping a minor under the age of 14, human trafficking, arson for a fraudulent purpose. Madam Speaker, the government is moving ahead with reclassifying those offenses. What is the effect of reclassification? Well, instead of a maximum sentence of up to 10 years, the maximum sentence would be 2 years less a day if they were prosecuted by way of summary conviction. Now, the Minister of Justice has repeatedly said, don't worry. Don't worry, this has nothing to do with sentencing. After all, the sentencing principles are the same. Well, Madam Speaker, of course the sentencing principles are the same, but when you're reducing the sentence and taking away the discretion of a judge to fashion a sentence from up to 10 years to 2 years less a day, I say, Madam Speaker, that that has everything to do with sentencing. And so, too, do apparently the Liberal members on the Justice Committee, because among the package of offences that Bill C-75 would reclassify included terrorism, related offences, as well as the offence of inciting genocide. I mean, it's just shocking to think that those types of offences would be treated or lumped into a class of offences such as a minor property offence, but that's Bill C-75 for you, a terribly drafted bill. But they, fortunately, at least in the end, listened to evidence saying that it would send the wrong message, that, as Shimon Fogel said, it would send a clear and unacceptable signal diminishing the inherently grave, even heinous nature of these crimes. He's from the Center for Israel and Jewish Affairs. The member for Edmonton Centre said, quote, and I'm quoting the National Post, "Let's be serious. We're talking about very serious offences," unquote. So much for the minister's assertion that reclassifying doesn't have anything to do with sentencing, doesn't have anything to do with diminishing the seriousness of an offence. It absolutely does, and the member for Edmonton Centre acknowledged as much. And Liberal MPs on the Justice Committee agreed when they voted with us on our amendments to remove the reclassification of terrorism and genocide-related offences. So I say, Madam Speaker, what kind of a message does it send then when we're talking about reducing and watering down impaired driving offences, or administering a date rape drug, or kidnapping a minor? Madam Speaker, it sends exactly the wrong message. It diminishes the seriousness of those offences, and it makes it possible that individuals who are charged with such offences could walk away with literally a slap on the wrist. Such offences have no business being reclassified. They have no business to be left to a prosecutor somewhere in some office to make the call without any level of transparency, without any level of consistency, Madam Speaker. It is absolutely the wrong way to go. And by the way, Madam Speaker, in closing, it will do nothing to reduce delay. Why won't it? Because 99.6% of cases are already before provincial courts. We know summary offences are before provincial courts. It means more downloading onto overstretched and overburdened provincial courts. It won't reduce delay, but it will water down sentences, undermining victims and undermining public safety. Madam Speaker, this bill needs to be defeated out of hand.
Questions and comments? The Honourable Parliamentary Secretary and the Minister of Justice and Attorney General.
So one comment and one question, Madam Speaker, and I thank the member opposite for his work at the Justice Committee. He talked about delays, and what I would put to him is that when you take administration of justice offences and you no longer apply criminal charges to those issues, but you instead create a judicial referral hearing, you avoid clogging up the criminal justice system, which is a goal that the member opposite and I would both share. But the question I have to him is that he put forward a lot of important comments with respect to victims and how victims are treated under this law, and what does this bill do for them. What I would say to him is about those very women that he referenced, what we are doing in this legislation. Would he agree that what we are doing in this legislation, by defining intimate partner violence to include dating and former partners, by increasing the maximum sentences for intimate partner violence, and by enacting a reverse onus on bail for repeat offenders, does that not protect the very victims who are women that the member opposite seeks to advance in terms of his own position in this House? Thank you.
Our member for St. Albert, Edmonton.
Thank you, Madam Speaker, and I do support the parts of Bill C-75 related to intimate partner violence, and we supported that at committee. But unfortunately, much of the rest of the bill is a mess, and the members spoke about AOJ offences, administration of justice offences. The bill seeks to do something about those, but the reality is that administration of justice offences actually take up very, very little court time. Why is that? Because in almost all instances, if someone, for example, breaches bail, there's a substantive charge underlying that. And so typically someone is not brought back into court until the main charge, the substantive charge, is dealt with. So while there was a lot of talk about administration of justice offences, the reality is very little court time is specifically devoted to them, and that evidence was clear before the committee.
Questions and comments? The
Honourable Member for Joliette.
Excuse the Jean.
No, sorry. The Honourable Member for Jonquière. Thank you, Madam Speaker. Now, concerning consultations with stakeholders, the Minister of Justice recognizes that social factors are largely responsible for the fact that our justice system is overloaded. Nearly all of the members at the round table expressed the same major concerns. They said that nearly everyone who has been involved with the criminal justice system are vulnerable or marginalized people. A lot have mental health problems, substance abuse problems. So I'd like to get my colleagues' opinion about whether the government should invest more in dealing with some of the fundamental causes of social inequality instead of penalizing people who need help.
For St. Albert, Edmonton.
Well, what, Madam Speaker, this government should do is invest in Canada's justice system by giving the actors within the justice system the tools and resources that they need to deal with the backlog, including the prompt appointment of judges. The parliamentary secretary can talk all he wants about how the minister is now appointing judges. Well, the reality is that under this minister's watch, she failed to appoint judges for 6 months upon being appointed as Minister of Justice. She has seen judicial vacancies reach record levels. It is the responsibility of the minister to fill judicial vacancies in a timely manner. her failing to do so in the face of Jordan, upon which cases are at risk of being thrown out of court and indeed are being thrown out of court as a result of this minister's inaction, it is not just inexcusable, it is negligence on the highest order.
Reprise de débat.
Resuming debate.
L'honorable député de Belle.
The honourable member for Belleuil-Chambly. Thank you, Madam Speaker. I'm pleased to speak about Bill C-75 today. It's a fairly complex and broad bill that touches on a number of issues within our justice system. And these are important issues. Of course, in the speaking time that I have today, I won't be able to address all of the aspects that are touched upon, but I'll focus on a few things that interest me in particular. But first, I'd like to talk a little bit about how we got to this bill and how my constituents are affected by it. Because C-75 is a response to a decision. So the courts said that there were unacceptable delays in the justice system, and they said that essentially there would have to be a deadline. And I think my constituents are particularly interested, and members of parliament, particularly from Quebec, are interested in this because there have been a number of cases in Quebec where people were accused of heinous crimes who were then freed because of the Jordan decision. So a lot of people had been involved in quite sordid stories, and now, of course, the Jordan ruling does change a lot of things, provides more services to Indigenous peoples, for example, but there's also the whole aspect of the administration of justice that needs to be solved if we want to maintain the public's trust in the justice system. And a lot of citizens got in touch with me following some of these highly publicized and highly concerning cases. And that's extremely important, Madam Speaker, because the justice system can only work properly if it has the public's trust. Now, if I can just put on my hat as the public safety critic for a moment, in a lot of cases this has to do with public safety. So there's the correctional system as well as the justice system involved. And all of the organizations working on this, including law enforcement, national security enforcement, are involved. It's very important to maintain that public trust. And so we had to make sure that we would study this bill in detail. So I want to congratulate the member for Victoria, who was a finalist for the Parliamentarian of the Year award because he worked so tirelessly on these issues. And with a bill that's so complicated, clearly we need to do very rigorous study of all of the issues involved. That's also a prudent approach because we don't want to apply a partisan approach to this study. I think it's worth saying again that we don't want this to be partisan if we do want to maintain the public trust, which is so important. Madam Speaker, in this context, the bill aims to reduce delays in the justice system. There are some positive aspects here, but there are also failures. And I'd like to talk about a few of them with the limited time that I have. Now, the first and most important failure has to do with mandatory minimum sentences. This is something that was a very acute problem under the last Parliament, under the majority Conservative government. It's really a failed policy, not just here in Canada, but also in the U.S. There are Republican right-wing legislators in the U.S. who have even admitted that this didn't protect public safety. Minimum sentences allow legislators to impose minimum sentences on judges, to force judges to give these minimum sentences. And that's problematic for a number of reasons. First of all, because the judge's discretion is being taken away. And that doesn't just harm our justice system, it also means that in a number of cases where minimum sentences apply, there are actually other social factors that may be entering into play. So what happens is that you're really expanding a very troubling social problem. For example, there may be more racialized people or Indigenous people in the correctional system. There are also certain crimes, such as drug possession, the use of drugs. Now, I don't want to minimize the importance of these issues, but they really are more public health issues than criminal justice issues. So if we look at the facts before us, not just here in Canada, but elsewhere, there are two things that we can observe, three things rather. First of all, there's a social impact that I just described. Secondly, in a number of cases, the courts rejected the provisions of many bills from previous parliaments that were put forward by the Conservatives, notably, such as mandatory minimum sentences. And third, in terms of public safety, in terms of keeping dangerous criminals behind bars, and in terms of lowering repeat offenses, mandatory minimum sentences don't help at all.
Now, why am I raising this point, Madam Speaker? Well, we could talk about the government, the last government, and we can compare what they did with what has been proposed by this government. And there are Liberal candidates who, before the election, spoke out loudly with us against this policy. They said that we had to deal with this issue quickly. But what are we seeing, Madam Speaker? We see a bill that we've been waiting for far too long, and C-75, and this after 3 years in power by the Liberals, does nothing to deal with the issue. My colleague, the member for Strathcona, mentioned this earlier. We have examined the issue, and there's a trend we see with this government far too often. We knew what had to be done. Before this government came in, we knew that this was a policy that was doomed to failure, that would not solve the things we want it to solve. So this is a missed opportunity, Madam Speaker. It's a missed opportunity to deal with this issue, this problem that's been with us for so long. Now, in the red states, where there are a lot of Republicans, they, when they have midterm elections, they have various propositions that are voted on, and they have been looking at this issue. Now, when we know that there are reforms in the justice system that are long overdue, we would have hoped to see something in this bill, but unfortunately it's not the case. And often with this government, there was an excellent bill on minimum sentences put forward by a senator, but the government's conclusion was unfortunate, and again, another missed opportunity. I'd also like to talk about hybrid offenses. This was very important in the bill because we observed something very disturbing. This was supposed to allow for a more rapid administration of justice, but it puts a heavier burden on the provinces. The Quebec Bar, before committee, said that it was very concerning because Quebec and the provinces are responsible for administration of justice. Quebec already has a very robust system in place. Their prosecutors are empowered to do a great many things. Now, what this shows me is that you have to depend on the goodwill of the provincial government. And I salute what Quebec has done in this area, but the federal government has not done its work. There are other elements I would have liked to address, but this is a bill that is vast and complicated, and where the Liberals missed an opportunity to bring in necessary reforms for our justice system. Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice. Thank you, Madam Speaker, and I appreciate the comments made by my colleague across the way. He said in his speech that we don't act directly, that we consult too much, and then we don't finally act.
We had a decision in this country, Madam Speaker, with respect to the death of Colton Boushie. The death of Colton Boushie was the individual involved was acquitted in that case of the death of Colton Boushie, and he was acquitted by a jury that was entirely unrepresentative of that community. There wasn't a single Indigenous person on that jury. Why? Because peremptory challenges were used as a sword by counsel in that case to ensure an all-white jury in that case. We've acted quickly in respect to that decision, in respect of what we've heard in Manitoba and with Justice Iacobucci, and what we heard by Aboriginal witnesses and Indigenous interveners at the committee who said, do away with peremptory challenges because that will ensure and help ensure that we have more representative juries in front of our criminal system, which will hopefully cure the overrepresentation of Indigenous people in the justice system. That overrepresentation of Indigenous persons, of racialized persons, is something that I believe the colleague opposite and myself both share as a preoccupation, as a priority of the highest demand. I would elicit the member opposite's comments on whether those provisions of this legislation are things that he agrees with.
To allow for other questions, the honourable member for Belleuil-Chambly.
Thank you, Madam Speaker, and I thank my colleague for his questions. Now, we do welcome this legislation. The devil is in the details. But we have to say that there are clauses that have to be dealt with that are very disturbing. The overrepresentation of Indigenous and racialized people in court and the makeup of juries. Now, when we talk about overrepresentation of vulnerable persons in the correctional system and also in the judicial system, this will not be entirely addressed in this legislation. I appreciate my colleagues' goodwill and good faith, and I appreciate the importance of consulting people, but after a few years in power, I think they could have done more to help to end the perpetuation of these social injustices.
Questions et commentaires. The honourable member for Nanaimo, Ladysmith.
Thank you, Madam Speaker. As the Vice Chair of the Standing Committee on Status of Women, we heard a very disturbing testimony about the impact of mandatory minimums, particularly on single mothers, particularly on Indigenous women, that in the past where judges had the discretion to say you can serve your sentence on weekends and your mom can look after the kids during the week. You know, it's broken families and kids have been forced into foster care because there is no longer that flexibility. So I heard the Parliamentary Secretary say we need more consultation on this. I'd like to hear my colleagues' view of whether there's any clearer direction than the several court rulings which have asked the government to move away from this practice, and whether we need more consultation or whether the government should have acted in this legislation to carry out on the instructions from the Prime Minister in their mandate letter to end the practice of mandatory minimums.
L'honorable député de Belleuil-Chambly.
The Honourable Member for Belleuil-Chambly. I thank my colleague for her question, and it is very disturbing when we see that there are women who can lose their children because of a legislation which has been judged by certain courts to not be appropriate. But also, as she very well pointed out, there's the fact that this needs more consultation because besides the rulings of courts, we have the facts before us. We have a policy which has not achieved the desired results, which has not brought down the rate of repeat offences. It's, in some cases, done the contrary. The facts are clear. All interveners in civil society would agree with us, and this is why the Prime Minister had the wisdom to put in the mandate letter that they wanted to implement a new policy and put an end to the provisions created by the Conservative government.
In the Islands.
Thank you very much, Madam Speaker. I am pleased to participate in the debate of Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. I would like to begin today by acknowledging the contributions of all members of this House, and in particular the members of the committee, for their hard work, engagement, and debate on Bill C-75. It is clear that members of all parties learned a great deal from the testimony that was heard, and I think that the country as a whole benefited from the committee's in-depth consideration of this transformative bill. The committee heard from roughly 95 groups and individuals covering a broad range of issues, in addition to reviewing 58 briefs. I would like to take a moment to share some of the different perspectives that they heard and read on Bill C-75 as it relates to the potential impacts of Indigenous peoples and persons from vulnerable populations. Madam Speaker, the committee heard significant praise of Bill C-75's proposal to codify a principle of restraint that would guide police and courts in making bail decisions. The principle dictates that police and courts will be required to give primary consideration to releasing an accused at the earliest opportunity and apply the least onerous conditions that are appropriate in the circumstances. Police and courts will be required to ask if the conditions are responsibly practical for the accused to comply with and necessary for public safety to ensure the accused's attendance in court. The proposed principle of restraint aims to remove unnecessary strain on the criminal justice system and reflects the principle set out by the Supreme Court of Canada. The Canadian Civil Liberties Association, the Canadian Bar Association, the Society of United Professionals, the Canadian Alliance for Sex Work Law Reform, Aboriginal Legal Services, and the Ontario Federation of Indigenous Friendship Centres are just some of the witnesses that came forward and expressed support for these measures. Madam Speaker, I think the sheer diversity of support that this proposal has received speaks volumes about the significance of the reforms, which are long overdue. The Ontario Federation of Indigenous Friendship Centres in particular noted that the principle of restraint would benefit Indigenous persons who often have to travel away from their communities to get to court, far from their family and social support systems. Bill C-75's proposal to codify the principle of restraint further requires police and courts to give particular attention to the circumstances of Indigenous and vulnerable accused who are overrepresented in the criminal justice system and disadvantaged in seeking bail. According to the 2016-2017 data from Statistics Canada, the proportion of Indigenous adults admitted into the provincial or territorial correctional institution is roughly 7 times higher than the rest of the Canadian population, and this figure has been steadily increasing since 2007. For Indigenous women in federal correctional institutions, the proportion is 8 times higher than for non-Indigenous women. And in 2012, Statistics Canada reported that individuals suffering from mental health disorders were 4 times more likely than those without a disorder to report being arrested by the police. Moreover, Indigenous people and vulnerable persons tend to be disproportionately impacted by onerous and unnecessary bail conditions, more likely to be charged with breaching minor conditions, and more likely to be caught in the revolving door of the criminal justice system. These facts are indicative of a systemic problem in need of comprehensive reform. While some witnesses, such as Professor Marie-Eve Sylvester from the University of Ottawa, suggested that the law should define vulnerable persons, we are confident that the current broad approach will allow for this meaning to evolve over time and to be interpreted on a case-by-case basis and avoid certain groups from being excluded. I would also note that the existing provision provides direction in terms of which types of vulnerability are relevant by specifically targeting these groups who are overrepresented in the criminal justice system and are disadvantaged in obtaining bail. The proposals relating to administration of justice offences have also received broad support from witnesses during the committee's review of Bill C-75. These proposals would evolve an alternative process called judicial referral hearing, which is essentially an off-ramp for minor breaches that do not involve harm to a victim or witnesses. These breaches would not result in criminal charges, but would instead be referred to bail court so that a judge can review and reassess the bail status and conditions of the accused. The committee heard moving testimony from Dr. Rebecca Bromwich from Carleton University. She reminded us of the tragic case of Ashley Smith, who was just a teenager when she died on suicide watch at Grand Valley Prison in 2007. According to Dr. Bromwich, Ashley was in custody as a youth and had over 150 convictions for administrative justice offences, many of which did not involve harm to the public and would not have been offences had she not previously been involved with the criminal justice system. This is precisely the type of situation that the administration of justice reforms proposed in Bill C-75 seeks to address. The judicial referral hearing is a new tool that police and courts may use in addition to the principle of restraint to streamline minor breaches out of the court system and free up resources for more serious cases. This proposal drew strong support from organizations such as the Ontario Federation of Indigenous Friendship Centres, Legal Aid Ontario, Aboriginal Legal Services, the Canadian Bar Association, as well as academics and private practitioners. Lastly, I would like to speak to a proposal that didn't get as much attention, but which some organizations and individuals acknowledged would have a positive impact for Indigenous peoples and persons of vulnerable groups. Specifically, Bill C-75 would amend the plea provisions of the Criminal Code to require that courts be satisfied that the facts support the charge as a precondition of accepting a guilty plea. Legal Aid Ontario noted that the new process for guilty pleas would help to streamline these pleas and reduce subsequent challenges on appeal, thus contributing to reducing delays. I am confident that this proposal would provide an important mechanism for ensuring that guilty pleas are not used to further marginalize already vulnerable accused. Madam Speaker, I believe the committee's review of this bill and the vast testimony heard strengthened an already robust piece of legislation and clarifies how it will respond to the systemic issues. I am proud to say that we now have an even more comprehensive bill aimed at reducing delays. I strongly support this bill, and I believe that it will make the criminal justice system a more efficient and effective tool for all Canadians, including Indigenous peoples, persons from vulnerable populations, accused, and victims. I urge all members of this House to support this bill. Thank you, Madam Speaker.
Questions and comments? The honourable member for Battle River Crowfoot.
Well, thank you very much, Mr. Speaker and Madam Speaker. And I just want to quote very quickly, our Auditor General says in regards to this government dealing with First Nation Indigenous programs, he says, it is an incomprehensible failure of the federal government to influence better conditions for Indigenous people in Canada. And it talks about a number of programs. This member now stood and said he likes C-75 because it incorporates a principle of restraint as it relates to the circumstances of Aboriginal accused or other accused from vulnerable populations when interim release decisions are made. In other words, if a police officer sees that it's a Indigenous individual, it's a long record, they can have a lesser charge, or they can have a quicker and maybe in some regard more compromised response to it. And then he cited all the different groups that supported that, which were typically Indigenous groups. None of them were victims organizations. None of them were victims groups that have real concerns about this part. And again, does he believe that this is another indictment on the government in that they're looking for ways to benefit, the high, or to deal with the high Indigenous population in prisons at a cost of the victims?
The honourable member for Kingston and the Islands.
Thank you very much, Madam Speaker. I mentioned in the beginning of my speech that there were numerous different organizations and groups that came forward. Those that represent Indigenous communities, those that represent various different fields of law throughout the country. And what became very clear, and through the information from Statistics Canada, is that Indigenous peoples are more likely to be enter into the criminal justice system, and it becomes a revolving door. I strongly believe that the provisions that are put into this bill are going to further strengthen the ability of the court to help deal with the lesser offences, so that we can stop that cycle and we can seriously have an impact on how our Indigenous peoples are the impact that they are feeling as a result of this system.
Comments? The honourable member for Nanaimo, Ladysmith.
Thank you, Madam Speaker. The Status of Women Committee did a study last year about the experience of Indigenous women in the justice system and incarceration. We really hoped that C-75 was going to bring in some of that advice. The government calls it a bold bill. I'm afraid it's not. So here I want to read from my colleague, Jonathan Rudden, Program Director for Aboriginal Legal Services, said in December of last year to the committee, quote, mandatory minimum sentences prevent a conditional sentence from being put in. What happens then is the person goes to jail. If they don't have someone to look after their kids, they will lose their kids. Even if the person gets their children back, they will have been removed from their families. The experience of being taken from your family and being put into foster care is incredibly damaging. End quote. And he also said, first thing we urge the committee to recommend and try to at least do is have the current government bring in the legislation they have promised to bring in to restore to judges their discretion to sentence people without the burden of mandatory minimum sentences and the restrictions on conditional sentences. End quote. So why is that not in this bold bill?
Honourable member for Kingston and the Islands.
Thank you, Madam Speaker. As we heard from the Parliamentary Secretary to the Minister, or to the Attorney General earlier, it was in the mandate letter of the Minister to review and to provide reforms to speed up the criminal justice system. And I think, and based on the evidence and testimony that's been coming forward through the committee process and to this House, that is exactly what this bill is accomplishing. There is a time and a place to have a discussion about mandatory minimum sentences. I'm personally very interested in having that discussion. I don't believe that the place for that is in this bill, but this bill does strengthen the manner in which our courts are tasked to conduct certain offences, so that we can have a stronger court system that does make sure that the most serious criminal charges are the ones that are dealt with the most attention that they deserve.
Resuming debate, the honourable member for Battle River Crowfoot.
Thank you very much, Madam Speaker. A real pleasure to speak on Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to the act. I have real concerns about this piece of legislation, as do many stakeholders, including the Canadian Association of Chiefs of Police. First of all, Madam Speaker, this is another omnibus bill containing 302 pages of major reforms to our criminal justice system. For our constituents, that means that for us to study a bill, it's 302 pages of legalized legislation. Similar to many other Liberal promises, this is another promise that's been broken as they promised not to bring forward this type of legislation. It also signals very clearly the Liberals' reluctance to follow for a thorough review and debate on the modernization of the criminal justice system, including reducing court delays in judicial proceedings, an extremely important debate given the current congestion within our courts that is resulting in serious offenders having their cases thrown out. Second, it somewhat undoes the mandatory victim surcharge our Conservative government imposed in 2013 under the Increasing Offenders Accountability Act for victims. The federal victim surcharge is a monetary penalty that is automatically imposed on offenders at the time of sentencing. Money collected from offenders is intended to help fund programs and services for the victims of crime. We made this surcharge mandatory in recognition that many judges were routinely deciding not to impose it. And while we did recognize that they were doing so as some offenders lacked the ability to pay, we believe it should be imposed in principle to signify the debt owing a victim. Like any penalty, fine or surcharge, if a person does not have the means to pay, they don't pay it. But, Madam Speaker, it is the principle of the matter, and many times there are crimes where the accused and the guilty party does have the ability to show some retribution to the victim. Conservatives strongly believe that the protection of society and the rights of victims should be the central focus in the Canadian criminal justice system rather than special allowances and treatment for criminals, which is why we introduced the Victims' Bill of Rights and created the Office of the Victims' Ombudsman. On that note, Madam Speaker, I would like to thank Sue O'Sullivan for her tremendous efforts on behalf of victims. Ms. O'Sullivan, who retired as the Victim Ombudsman in November 2017, had a very distinguished career in policing before being appointed to this extremely important position in 2010. We created the Ombudsman's Office in 2007 to act as an independent resource for victims to help them navigate through the system and voice concerns about federal policy or legislation. And while we place such high regard and importance on this office, the prolonged vacancy in fulfilling the position after Ms. O'Sullivan had retired demonstrated very clearly what the Liberals think of the office. In April of this year, more than 4 months after Ms. O'Sullivan retired, the CBC revealed the frustrations of many victims and victims advocates, including that of Heidi Illingworth, former executive director of the Canadian Resource Centre for Victims of Crime. Ms. Illingworth said, and I quote, "The community across Canada feels like they aren't being represented. Their issues aren't being put forward to the government of the day. Victims feel that they're missing a voice. The people we work with keep saying, why isn't somebody there? Isn't this office important? Who's speaking for victims? Who's bringing their perspectives to the minister?" Unquote. And I would like to congratulate Ms. Illingworth, first of all, for those sentiments that I think maybe perhaps influenced the government, but also for her recent appointment on September 24th as the third Victims Ombudsman for Canada. Thirdly, Madam Speaker, Bill C-75 effectively reduces penalties for a number of what we on this side of the House and many other Canadians deem serious offences. The Liberals are making a number of serious offences that are currently punishable by a maximum penalty of 10 years or less. Now they are being created as a hybrid offence. Making these hybrid offences mean that they can be proceeded in court by other indictment or summarily. Summary offences are tried by judge only, are usually less serious offences, and have a maximum of 2 years imprisonment. These hybrid offences will now include causing bodily harm by criminal negligence, bodily harm, impaired driving causing bodily harm, participation in activities of criminal organizations, abduction of persons under the age of 14, and abduction of persons under the age of 16. As pointed out in their testimony before the Standing Committee on Justice and Human Rights, the Canadian Association of Chiefs of Police expressed significant concern about the proposal to hybridize the indictable offences. They said, and I quote, "These 85 indictable offences are classified as secondary offences under the Criminal Code. If the Crown proceeds by indictment and the offender is convicted of one of these 85 offences, the Crown can request that the offender provide a DNA sample for submission to the National DNA Data Bank. If these 85 offences are hybridized and the Crown elects to proceed by summary conviction, the offence will no longer be deemed a secondary offence and a DNA sample or order cannot be obtained. And the consequence of this will be fewer submissions being made to the National DNA Data Bank. The submission of DNA samples to the data bank is used by law enforcement to link crime scenes and to match offenders to crime scenes. Removing these 85 indictable offences from potential inclusion in the National DNA Data Bank will have a direct and negative impact on police investigations, unquote. Madam Speaker, I do realize that due to the pressure exerted by the Conservatives, last night, I believe, 2 offences, primarily the terrorism offences, have been taken out of this, and it is now 83 offences with the 2 terrorism-related offences being removed. But according to the Canadian Association of Chiefs of Police, the uploading of DNA taken from 52 indictable or secondary offences, which are among those initial 85 to be made hybrid offences, resulted in get this, 221 matches to primary offences, including 19 homicides and 24 sexual assaults. At the very least, the Canadian Association of Chiefs of Police is recommending that this significant unintended consequence of Bill C-75, hybridization, be rectified by listing these 85 indictable offences as secondary or primary offences, so DNA orders can be made regardless of how the Crown proceeds. Madam Speaker, we watch CSI and other programs. We see the importance of this new type of science, this new type of technology. And now the Liberals are saying these 85 are no longer important for the DNA database. Lastly, Madam Speaker, before my time runs out, I would like to talk about the intent of Bill C-75 to incorporate a principle of restraint as it relates to circumstances of Aboriginal accused and other accused from vulnerable populations when interim release decisions are made. Section 493.2 places an unreasonable onus on police officers at time of arrest to make a determination on whether an offender falls within this classification. Furthermore, and more importantly, it wrongly uses the criminal justice system to address the problem of overrepresentation of Indigenous peoples within the criminal justice system. Instead, the government should be dealing with the socioeconomic and historical generational factors that are contributing to this problem. I unfortunately do not believe that the Liberal government has any intentions of redressing the plight of our Indigenous people in any meaningful way. And they will continue to fail in this regard despite their promise of reconciliation and renewed relationship. And I take that as chair of the Public Accounts Committee. Our Auditor General came with 2 reports this spring. And the objective of one audit was to determine whether Employment and Social Development Canada managed the Aboriginal Skills and Employment Training Strategy in the Skills Partnership. Madam Speaker, to make a long story short, as I see my time is out, the Auditor General said that when this government is dealing with many of these programs for Indigenous, it is an incomprehensible failure. It is unfortunate that this government is taking C-75 and using this one part of it to help address overpopulation of Indigenous in our penitentiary system. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
And I'll keep it short this time, Madam Speaker. I thank the member opposite for his comments, and I'll confess to being surprised that he's raising the plight of Indigenous people in light of the previous government's track record in terms of Indigenous reconciliation. I find it peculiar that he's criticizing our commitment to reconciliation in terms of the billions of dollars we've committed, in terms of our commitment to the calls to action. But what I would put to him is that when he raised the question about how does this address victims' rights, here's how it addresses victims' rights, to my honourable friend. When you stop the cycle of perpetually criminalizing individuals by perpetually piling charge upon charge on them, you stop the cycle of overrepresentation. That is what this bill tries to do. That is what the member from Kingston highlighted in terms of the administration of justice offences. By taking people out of the cycle of criminal charge after criminal charge, penal sentence after penal sentence, you avoid overcriminalizing individuals, including Indigenous and marginalized communities, and you avoid the types of crimes that the member opposite is so concerned about in terms of the victims he rightfully defends. We stand by those victims, as does he. I put it to you, sir, do you not see a link between addressing the over-incarceration and the overrepresentation of Indigenous people in our system and the very crimes which you would seek to stop occurring?
And the Honourable Parliamentary Secretary knows full well that he's to address his questions to the Chair and not to the individual members. The Honourable Member for Battle River Crowfoot.
Madam Speaker, I think it's a very sad question coming from that member. What he stated was, look at look at how we have helped Indigenous people. And then he said, billions upon billions upon billions of dollars we've put into it. And that's it. And again, Madam Speaker, we have a government that believes that by throwing billions of dollars at a problem, it's going to solve a problem. It isn't going to solve a problem. So what does the honourable member suggest? Well, the honourable member suggests that when there's charge after charge after charge after charge, and we see Indigenous offender, that we don't charge him for all the offences. Again, Madam Speaker, with all due respect to him and to the government and to you, I see that as an affront to victims, an affront to those people who have been victimized by those charges, by that crime. Now being saying, we're going to whittle this down because we just think there's too many First Nations in our penitentiaries, and you know, we don't want them to have quite so long a record. Unfortunate.
For Edmonton Strathcona. I'd like to thank the colleague from Alberta for his speech. I wonder if he speak to this matter. His colleagues have been standing in the House frequently and calling on the government of the day to fill the vacancies of judicial appointments. And as he is aware, he was in the last Parliament with me. His government also failed to fill those vacancies, and in fact failed to respond to the pleas by the former Conservative Attorney General of Alberta. I wonder if he could speak to that there has been a languishing problem in that area for a long time. But I wonder if he could also speak to the matter that the previous government's decision to impose minimum mandatories has, in fact, as the Criminal Trial Lawyers Association has pointed out, been one of the major causes for clogging the courts. Why then is his party completely opposed to any kind of reform to that measure? The honourable member for Battle River Crowfoot.
Well, Madam Speaker, I sit here, I have the former Attorney General of Canada sitting right here. Very clearly, in the 10 years that we were in government, we filled those vacancies, and we filled them regularly. Yes, there were always openings coming, and we filled them as quickly and soon as we could. We see hundreds of vacancies now, and we see very serious crimes and criminals walking away because of a lack of those positions being filled. And so, Madam Speaker, that is one of the things that we took pride in. Now, the Parliamentary Secretary this morning explained to us why they have not filled those positions. And he said because we do not have enough of a diverse population. We want to have our top courts be indicative of Canada's population, a worthy goal. But it sounded to me a lot like these are not being positions filled because we can't find Indigenous people to fill them. We can't find people, and I think he used the LGBTQ community to put them into the judge position. I think that's exactly what he used. And, Madam Speaker, that's the reason that we have so many vacancies.
Resuming debate, the honourable député de Mont-Royal.
Merci. The honourable member for Mount Royal. Thank you, Madam Speaker, and thank you to my colleagues. It's with great pleasure to rise and to speak to our work on Bill C-75. I'd like to thank the members of the Justice Committee for their hard work, and I'd also like to thank the many witnesses that appeared before us. More than 60 came out to give their views on a bill. I'd also like to thank the member for Saanich Gulf Islands because she submitted very interesting and constructive amendments to committee, amendments that we debated.
I think overall, C-75 is a good bill, and it is a bill that the committee made better by its study. I want to talk to you for a little bit about the amendments made by the committee. The first amendment that I am very pleased the committee made is to delete from the criminal code the provisions related to keeping a common body house and vagrancy. These provisions, as we heard from witnesses from the LGBTQ2+ community who came before us, my friend Robert Leckie, who was the dean at McGill, Tom Hooper, others, told us that they had been disproportionately used in the 1970s and the 1980s to charge and to send to prison and to fine members of the gay community. In order for these convictions to be expunged under previous legislation that this House and the Senate adopted, we would need to have the offense under which they were charged repealed from the criminal code. We at the committee, and I salute that all members of all parties listened to these witnesses and determined that it was only right that while they are still alive, while they are still with us, while they can still understand that we are taking action to restore their sense of fairness, their sense that they were charged with something that they never should have been charged with in the first place, that the members of the committee amended the bill to delete these provisions. And I'm very grateful, and I hope the government, if this bill is adopted, which I imagine it will be, will move forward quickly to adopt an order in council to allow these men to have their records expunged. Secondly, we deleted the provisions of the bill related to routine police evidence. Routine police evidence was a proposal to allow testimony to be entered from the police by affidavit as opposed to the police officer showing up in court. We heard from virtually all sides that this provision of the bill could easily be misunderstood, could harm those people who were trying to represent themselves in court and didn't understand how to challenge the submission of the routine police evidence by affidavit. And we felt that since any lawyer on almost any circumstance would challenge the idea that the police officer did not need to show up to be cross-examined on their testimony in all matters other than the most simple ones, we felt that this should be removed from the bill, and we have proposed to the Commons in this reading, Madam Speaker, to remove it from the bill. We also listened carefully to those people who said that we should not hybridize the offenses related to terrorism and genocide. And I want to say, Madam Speaker, just to correct the record from what my colleague previously had said, this was not done because the NDP and Liberal members of the committee were pushed into it by a Conservative amendment.
Order. I just want to remind the members of the opposition that they're to wait till questions and comments to make any comments or put any questions forward. And I would just ask the member from Mont-Royal to continue with his speech.
As my friend from St. Albert, Edmonton, Madam Speaker, well knows, the committee had discussions long before amendments were submitted about these issues. And the committee members had all put forward the proposal that genocide and terrorism be deleted. And rather than vote against the clauses, which is what the committee had originally talked about doing, the Conservatives put forward amendments to retain other language that had been amended in the clause and to delete these provisions. I wholeheartedly agree that genocide and terrorism are easily distinguishable from the other offenses that are hybridized, not because necessarily they're more serious offenses, although they're incredibly serious offenses, but because they are offenses against groups as opposed to offenses against individuals. They're easily distinguishable from ordinary charges under the criminal code. They are ones that impact society in a way that individual cases do not. And I strongly supported removing them from the list of offenses to be hybridized, and I am pleased that the committee did that. I also would note that when you talk about moving forward justice, one cannot argue that the handful of terrorism and genocide offenses that go before our courts actually are ones that will stop the court system or slow down the court system by remaining solely indictable offenses. So I wholeheartedly supported that. But what I did not agree with was the conclusion that by hybridizing an offense, you're automatically judging that offense to be less serious. Madam Speaker, when you hybridize an offense, you give the prosecutor the discretion to choose to move forward with either an indictable or a summary type of conviction. It is true that the summary conviction carries a maximum sentence that is generally, although in some cases only 1 day, less than the indictable one. So it is true that if you choose to proceed by summary conviction, your maximum sentence is less than what if you had a maximum sentence under indictable prosecution. But presumably any prosecutor looks at the facts of their case, determines whether or not the facts of their case warrant a jail sentence over 2 years less a day, and if they believe the facts of their case warrant a jail sentence higher than 2 years less a day, they proceed by indictment. And by allowing hybridized offenses, and by the way, Madam Speaker, there are many serious offenses in the criminal code, such as assault, that are already hybridized. There is no weakening of the offense. There is no saying an offense is less serious by the fact that you agree that this type of an offense can have different facts leading to a need to hybridize. And I'll give an example. An incredibly serious offense in the criminal code, one that I think we would all agree is incredibly serious, is kidnapping someone under the age of 16. That is one of the offenses that is being hybridized under this bill. But we also understand there can be people, terrible people out there, who try to kidnap or solicit a young person under 16 for the purposes of trafficking or for the purposes of seizing them away to commit crimes against them. And there can also be a situation where a non-custodial parent takes their own child to visit grandparents against the will of the custodial parent. That is still kidnapping a child under the age of 16. And that warrants, even though serious and a crime, to me, a very different sentence than the person taking the 16-year-old for trafficking. I would also note there were other offenses where there were conservative amendments saying that we should not dehybridize on issues such as branding of cattle, stealing timber. And those offenses clearly are offenses which don't carry the same type of consequence, yet in the same way that we couldn't distinguish between one and the other, we're saying we shouldn't dehybridize these either. Fourth, Madam Speaker, we also made an amendment to protect students. One of the things that we did, as opposed to weakening sentences, we enhanced summary sentences so that instead of a 6-month average summary sentence, a 6-month maximum, the maximum is changed to 2 years less a day. So we actually strengthened sentences for many, many more offenses in this country, and set a summary maximum, a general summary maximum sentence of 2 years less a day instead of 6 months. But that would have had the negative impact on students and agents who only could appear on cases that were 6 months or less. So we moved an amendment at committee to allow provinces to set general order in council rules that allow for different classes of agents to appear for periods of over 6 months, and I think that was important. Madam Speaker, we listened to witnesses. There were many issues on this bill that are clearly very, 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 very debatable and have good points on both sides, but I think the committee came back with a better bill than it got. Thank you very much, Madam Speaker.
Questions and comments? The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker, and I thank the member for Mount Royal and appreciate the good work that he does as chair of the committee. That being said, I take issue and respectfully disagree with his comments respecting the hybridization of offenses. It is true in reference to certain offenses, such as stealing cattle or branding cattle or whatever he referred to, that yes, we oppose the reclassification simply on the basis that we said the government has taken a whole series of offenses without any real consideration as to why Parliament treated them in the first place as indictable. Other than a handful of offenses, there was really no evidence before the committee, and we took the position that if the government wanted to reclassify certain offenses, then introduce legislation focused on the reclassification with a basis or justification for doing so. Unfortunately, that's not what the government did. They just took a bunch of offenses, which is why genocide and terrorism-related offenses got into the mix. They should never have been there. I think the member would concede that. But the member mentioned that there were witnesses that did appear who called on the committee not to reclassify those offenses. It's true, and they gave very impactful evidence, but also victims of impaired driving appeared before the committee, and they pleaded with the committee not to reclassify the offense of impaired driving causing bodily harm. And we heard from witnesses that reclassifying does send a message, and I was wondering if the member for Mount Royal could speak to that issue.
The honourable from Mount Royal.
Thank you very much, Madam Speaker, and I want to thank and share my colleague from St. Albert, Edmonton's compliments. His intellect and his work at the Justice Committee is always very much appreciated. And I know what he said about the government taking groups of of offences and making them hybridized. I would note as well that the amendments offered by the Conservatives did essentially the same. As he notes, there were certain offences in there that were much less serious on the face of them than others, and they proposed not to hybridize them either. On the issue of impaired driving that he asked about, I agree. It's an incredibly serious offense, and those whose families are affected, the victims of impaired driving, there is nothing you can say to console those people. But again, my view is that prosecutors will determine, based on the facts of the offense, whether they proceed indictably, which they will no doubt do in most cases, or whether it should be proceeded with summarily. And I'll again give an example. Somebody who, for the third time, has taken alcohol, gone on the road, and drank, and then impacts someone, hurts them very severely, and puts them in the hospital for weeks, is very different than the person who takes cold medication, isn't aware of the cold medication's effects, and backs out of a parking lot slowly, injuring someone's ankle. And they're the same offense. Thank you.
Questions and comments? Questions et commentaires? The Honourable Member Peace River Westlock.
Speaker, and I'd like to thank my honourable colleague for his great speech. I know I have had some interactions at the Justice Committee with him, and I know that he runs a fair and honest ship over there. One of the things that I'm interested to hear him out on is the fact that Clause 106, which is material benefit from trafficking, Clause 107, which is the destroying of documents due to trafficking, both of those have been turned now into summary offenses or hybrid offenses. I'm just wondering the logic on that to some degree. He said, well, there's a range. I'd like to see what his opinion on the range of issue could be with those. Material benefit from trafficking, Madam Speaker, seems like a very serious offense to me. Thank you.
The Honourable Member for Mount Royal has 50 seconds to respond.
50. Oh, thank you very much, and thank you to my honourable colleague. And I just want to say that one thing that was desperately missing at the committee was the member for Niagara Falls, who always added great weight to the committee. As I come back, since I only have a short time, Madam Speaker, I do want to say again, the intention of hybridizing an offence, there are many serious offences in the criminal code today, such as assault, that are hybridized. It is not to diminish the offence, it's simply to give the prosecutor a range of options with respect to the particular circumstances of the offence. It does not diminish the seriousness of the offence to hybridize it. Thank you, Madam Speaker.
Resuming debate, reprise de débat, the Honourable Member for Niagara Falls.
Thank you, Madam Speaker, and I want to thank the member for Mount Royal for those comments here, and certainly I enjoyed my work on the Justice Committee these past 3 years, and it was very rewarding and very, very insightful. With respect to Bill C-75, there are sections of the bill that we on this side are in favor of them. One of the is the intimate partner violence reforms, basically reversing the bail on somebody, the onus of bail on someone who has been convicted of assaulting or other crimes against their partners. That I like the idea because it does give better protection. There are a number of procedural changes with respect to preliminary hearings and jury selection, and again, we will continue to review those changes here and listen to get input from people. But as you've heard, Madam Speaker, and you've heard from my colleagues on this side, we are continue to be quite concerned about the hybridization of some very serious crimes. And I think most Canadians would agree with us in the Conservative Party that these are serious crimes that are currently listed as indictable offenses with a maximum up to 10 years. And I think most Canadians would agree with that that does reflect the seriousness of these crimes. Now, some of those offenses include but are not limited to punishment of a rioter and concealment of identity, breach of trust by a public officer, municipal corruption, selling or purchasing offices, influencing or negotiating appointments or dealing in offices, prison breach, assisting a prisoner of war to escape, obstructing or violence to or arrest of an officiating arrest for somebody who threatens a member of the clergy, keeping a common body house, causing bodily harm by criminal negligence, bodily harm, impaired driving, causing bodily harm, failure to provide body samples that are blood alcohol over the legal limit, material benefit from trafficking, withholding or destroying documents, abduction of a person under the age of 14 or under the age of 16. Madam Speaker, I think most Canadians would agree with us. These are very serious offenses. Marriage to someone under the age of 16, arson for fraudulent purposes, and participation in the activities of a criminal organization. Madam Speaker, the government has backed down on a couple of these issues, and they were the ones related to terrorism and genocide. The problem I find, Madam Speaker, with the government is that we told them a long, long time ago that Canadians aren't going to agree with hybridizing and reducing the possible penalties for criminal activities like genocide and terrorism. And we told them, and we were very clear to them, that it's a mistake going forward on this, and it took them a long, long time, approximately a year, before they would back down on these things. And one of the bits of advice I would give to this government is just because an idea comes from the opposition doesn't mean it's a bad idea. I mean, just recently, we, some time ago, started pointing out that a person who was convicted of murdering, torturing, and raping a child shouldn't be then transferred into a healing lodge. That was what we told them. We told them that this is a huge mistake here, but all we got was pushback from the government and the ministers or something. No. Well, I just find out, Madam Speaker, a few minutes ago that Terry Lynn McClintock has been transferred out of the healing lodge and back into a prison where she should be. And all I can say to the government is, this isn't any better idea than it was when we told them a long time ago about these things. Just as I said about the genocide and the terrorism, it was a mistake to put those in as hybrid offenses, and again, we were right. I remember in June of 2017, the government came forward with another omnibus justice bill, and one of them was to remove the protection for members of the clergy and the protection of people disrupting a religious service. We told them there was a mistake. I remember standing here telling some of my colleagues, say, please go home this summer and ask them, even if they don't go to a religious service, ask them, do they think it's a good idea that we would repeal this section here? Well, it took about a year, but then finally what happened was the government did agree with us. And then, unfortunately, I see that this is one of now the threats against a member of the clergy are now part of the hybridization, so they've reduced the penalty of this. Again, I believe this is inconsistent. When we hear the Prime Minister and others saying we have to protect religious institutions, we have to protect synagogues, we have to protect churches, temples, and mosques, we have to protect them, but at the same time, their record is, now on 2 occasions here, to reduce or, in a sense, eliminate the specific penalty dealing with that. That's completely inconsistent, and I think it's a mistake. But, Madam Speaker, I think, and I will say this again, that if they ask I was going to ask my colleague here when he spoke, I was going to ask him, since he gets overwhelming support in the number of elections, he's very in tune to what his constituents are saying, are any of your constituents say we should open up the possibility of a lower sentence for people who traffic and children under the age of 14? Did anybody say that to you and say, come on, we got to go easier on these people here? No. The honourable member says no, nobody came forward to ask them that. We talk about the challenges with respect to impaired driving, and now the guy, as you're aware, Madam Speaker, the government's priority this year has been to legalize marijuana. Well, you know, Madam Speaker, and everyone in this chamber knows, this is going to make it more complicated with respect to impaired driving and the challenges associated with this. But yet, at the very same time, the government has legislation that says that if you are impaired driving and you cause bodily harm, you now have the possibility of having a summary conviction offense, something even as low as a fine. I would say, Madam Speaker, that nobody wants something like that. Even the section of trafficking in persons, the Justice Committee is doing a study right now on human trafficking. And we heard from Canadians across this country, different groups, individuals say what a terrible problem this is, that it has to be addressed. But at the same time, the government is reducing the penalties. They're making the possibility. Now, one of the things that I heard from the government over a year ago when they introduced this is that, well, this is going to speed up the criminal justice system. I'll say, sure, yeah, if you're a terrorist and somebody says, hey, there's a possibility you'll get a fine of $1,000. They're going to say, where can I sign up for that one? That's great. That's great news. Let's not hold up the justice system. So, Madam Speaker, my point on these things is these are very serious crimes. They were treated as such when we were in government, and as my colleagues have said, we always stood up for victims of crime to better protect victims and to increase people's confidence in the criminal justice system. When you let somebody off who has committed a horrific crime and you get them the most minimum possible sentence, this does not increase people's confidence in the criminal justice system. It has the exact opposite effect. So, Madam Speaker, we had a very good run at this. We stood up for law-abiding Canadians. We stood up for victims. We wanted the system to work. I'm very proud of all that we have done. And my advice to the government is when the Conservatives have good ideas that you can run by your own constituents and they agree with us, you should adapt those. You shouldn't have to wait to change your mind on those. Thank you very much.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
So one brief comment and one question, Mr. Speaker, and I appreciate the comments from the member opposite and his experience in this matter, but I would put it to him that to question our commitment to fighting religious discrimination I find puzzling in the wake of the strong position we've taken against anti-Muslim hatred, Islamophobia, and anti-Semitism based on yesterday's apology in this House, and the monies that we've dedicated thereto. He did state that he agrees with our position on intimate partner violence and the victims who suffer intimate partner violence, and I thank him for that. I think that's an important area of common ground. What I would say to him is that there are areas there are other victims that are also addressed in this bill, and I'd solicit his views on this area, and that is the area of the disconnect that existed indeed when his party was in power, where you could have a consensual sexual relationship between people between the age of 16 and 18 who were heterosexuals. That was perfectly valid under the Criminal Code of Canada. But until this legislation, the same situation of minors in a sexual consenting to sexual activity who were 16 to 18 years old, who were part of the LGBT community, would be criminalized. This bill will change that. Is that a step in the right direction for the member opposite? And perhaps he could elaborate as to why his government didn't make that change when they were in power.
Well, member for Niagara Falls.
Mr. Speaker, he says he's confused as what we're talking about protection of religious freedom. I was completely confused when I saw this bill repealing a section of the criminal code. I checked out the section of the criminal code. They are repealing the section that specifically protect the members of the clergy and protected people against having the disruption of their religious service. I asked the question, and I was told by one of the members, say, oh, well, it'd still be mischief, if you cause a disruption at a religious service here. And if you threaten a member of the clergy here, it could still be assault. I said, no, it's not the same thing as causing a ruckus at a hockey game or disruption somewhere or getting into a fist fight in a bar. No, it's not the same. That even people who do not attend religious services agreed with me that it is more grievous. It's more serious if you disrupt people's rights to practice their religion. And so I say to the members of the government, yes, they want to better protect religious institutions. Well, make sure the laws don't weaken those protections. Don't make it a hybrid offense or something if you want to go after a member of the clergy. That's a mistake. It sends out the wrong message, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary, the Honourable Member for Nanaimo, Ladysmith, actually.
Thank you, Mr. Speaker. We had really hoped from the NDP side that this legislation would repair the Conservatives' mandatory minimum policy change that they brought in during the previous time. We've heard testimony at Status of Women Committee that when judges no longer have judicial discretion to impose, say, sentencing, serve your time on weekends, you can get your family to look after the kids on the weekend, you can still keep your regular job during the week, families can stay together. Often in the case where women, particularly Indigenous women, may well be accessory to a crime, may well have pled guilty just to get the charge kind of over and underway. They don't have access to good representation. A lot of evidence that mandatory minimums have been harder on Indigenous women than anybody else, and that they have broken up families. And in fact, court challenges have 68% of court challenges are related to mandatory minimums. So have the Conservatives had any second thoughts, or do they regret the decision that they made in the previous Parliament, and do they wish that the government had kept its promise and followed its mandate letter and included a repeal of mandatory minimums in this legislation?
Member for Niagara Falls.
Mr. Speaker, that is the role of Parliament, to set guidelines for the courts. I remember back in the early 90s, I was part of the government, and the government introduced a bill on stalking, okay, to put that into the criminal code, to make that a specific crime. And I remember, I believe the maximum sentence for that was 5 years. I had one of my own colleagues and saying, you know, Rob, just a second, maybe a judge wants to give more than 5 years or something. Why are you limiting it to 5 years? I said, well, that's our job. We set guidelines for the courts. And whether it's the maximum or minimum sentences, that's what we do as a parliament. Now, the honourable member will say, you know, how could you do this for somebody who commits first-degree murder? You know what I mean? Why would you limit it to, you know, why would you insist that it be 25 years? Well, again, these things reflect the seriousness of these crimes, Mr. Speaker. And here's the other thing, too. When a court gives a very light sentence to somebody who's committed a serious crime, it hurts people's confidence in the criminal justice system. They have a problem with that. And that is one of the things that we always wanted to have as a government. We wanted people to have confidence that the criminal justice system does what it is supposed to do, hold people accountable for what they have done, protect the public, and stand up for victims. And that's exactly what we did in our 10 years, and I'm very proud of our record.
Resuming debate, the honourable member for Guelph.
Thank you, Mr. Speaker. It's my pleasure to speak today on Bill C-75. Like other members in this House, I'm very appreciative of the study undertaken by the Standing Committee on Justice and Human Rights and the many witnesses that appeared to give helpful testimony on various aspects of this bill. I'd like to use my time today to discuss the jury amendments proposed in C-75. As you know, jury reform is an area of shared jurisdiction. While Parliament is responsible for the criminal law and the rules in the criminal code, setting out the legal framework for injury selection, the provinces and territories are responsible for determining, for example, who is eligible for jury duty and the process by which the jury roll is compiled. Bill C-75 proposes several reforms with respect to the in-court jury selection process. One of the significant changes, which I'd like to start with, is the proposal to abolish peremptory challenges. The committee heard from several witnesses who testified on jury reforms, all of whom shared an understanding of the importance of preemptive juries. Views differed on whether or not peremptory challenges contribute to or undermine that objective. However, several legal experts and advocates, and most notably Professor Kent Roach, expressed a very strong support for their elimination, which would finally put an end to the exclusion of jurors on a discriminatory basis. Any tool that can be used to effectively undermine the participation on juries of persons of a particular race or ethnicity contributes to a perception of mistrust and lack of confidence in the justice system. Jonathan Rudin, who's Program Director from Aboriginal Legal Services, also gave compelling testimony before the committee that the use of peremptory challenges have had a corrosive impact on efforts to encourage Indigenous people to act as jurors. Discrimination in the selection of juries has been documented for decades. Concerns about the discriminatory use of peremptory challenges and its impact on Indigenous people being underrepresented on juries were raised back in 1991 by Senator Murray Sinclair, then a judge in the Manitoba Aboriginal Justice Inquiry report. More recently, we heard from retired Supreme Court Justice Frank Iacobucci, who studied these issues in his 2013 report on First Nations representation on Ontario juries. I agree with Professor Kent Roach, who in his written brief to the committee characterized jury reforms in Bill C-75 as being long overdue. Having read these reports and hearing from many experts on the topic, I'm confident that Bill C-75 proposes the right approach in abolishing peremptory challenges. It's a simple and effective way to prevent deliberate discrimination and the arbitrary exclusion of qualified jury members. Furthermore, to bring greater efficiencies to the jury selection process and to make it more impartial, the bill proposes to empower the judge to decide whether to exclude jurors challenged for cause, such as because they're biased on one side, by either the defense or the prosecution. Currently, such challenges are decided by two laypersons called triers who are not trained in the law. This process has been problematic, causing delays in jury trials even before they begin, and appeals resulting in orders for a new trial. The proposal would shift the responsibility over such challenges to judges who are trained adjudicators and therefore better placed to screen out impartial jurors. The proposed change reflects the recommendation made in 2009 by the Steering Committee on Justice, Efficiencies and Access to the Justice System, a group established by the federal, provincial, territorial ministers of justice and comprised of judges, deputy ministers of justice from across Canada, defense lawyers, representatives of Bar Association, and the police. It's also consistent with what has been done in other common law countries, such as England, Australia, or New Zealand. I'm confident that this change in procedure will make improvements to the overall efficiency of our jury trials. There are also several proposed changes to modernize and update the challenge for cause grounds. Notably, the proposed change to reduce the number of jurors with criminal records for minor offenses from being challenged and excluded for jury duty will help address concerns that excluding individuals with minor criminal records disproportionately impacts certain segments of society, including Indigenous persons, as noted by Justice Iacobucci. It will also assist with improving broader participation on juries and thus jury representativeness. While a few witnesses before the committee would like to see this ground removed so that anyone with a criminal record could not be challenged for cause, I'm mindful of the fact that permitting a juror with serious criminal background to serve on a jury and make a decision as to the guilt or innocence of the accused could greatly undermine the public confidence in the administration of justice. I'd also like to note that provincial and territorial jury selection or legislation also specifies who is eligible for jury duty and is in many respects reflected by what is already in the Criminal Code. Bill C-75 will also allow a judge to continue a trial without a jury when the number of juries fall below 10 and where the Crown and the accused agree. This change will promote efficiencies because it will avoid mistrials where the jury is reduced to below 10 jurors due to illness or some other reason. Another key change proposed in Bill C-75 is with respect to allowing judges to stand aside a potential juror while other jurors are selected in order to maintain public confidence in the administration of justice, for example, to support the establishment of an impartial, representative jury. The change recognizes the important role that judges can play in improving jury selection at the outset. I believe that the use of this power, where deemed appropriate, will help improve the diversity of jurors during the in-court selection process, particularly in cases where public confidence in the administration of justice would be undermined if the jury were not more diverse. With respect to representatives of juries, there's certainly work that still remains to be done, especially given the important role played by both the federal government and the provinces and territories in the jury selection process. I'm greatly encouraged by the fact that jurisdictions are collaborating to examine a wide range of jury-related issues and undertaking important work to find further ways to improve our jury selection system in Canada, including to enhance the representation on juries. In closing, I'd like to emphasize that the jury reforms in Bill C-75 mark critical process in the area of promoting fairness, diversity, and participation in the jury selection process. These improvements will also enhance efficiencies as well as public confidence in the criminal justice system. Mr. Speaker, I call on all members of this House to support this transformative bill, and again, thank you to the work of the Justice Committee and the witnesses that they heard from in bringing forward this important legislation, including the amendments that they proposed. Thank you, Mr. Speaker.
Questions and comments. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the member for Guelph for his speech. He spent much of his time addressing the issue of peremptory challenges, and I have to say that it was a proposal that I considered very seriously, but there was a lot of evidence before the Justice Committee that peremptory challenges, in fact, are a vital tool, including for defense counsel to use. In fact, defense counsel that appeared and representatives of the defense bar that appeared were unanimous in calling on the committee not to move forward with eliminating peremptory challenges. In addition to that, their evidence was that it actually can increase the representativeness of juries, and consistent with that, the Supreme Court of Canada in the Sherritt decision stated that, in fact, peremptory challenges can increase rather than diminish the representativeness of juries. I was wondering if the member could comment.
The honourable member for Guelph.
Thank you, Mr. Speaker, and thanks to the member from St. Albert, Edmonton, and for his work on this committee. And as he has pointed out, there was conflicting evidence at the committee. But I think where we've landed, Mr. Speaker, is in giving the stand-aside provisions for the justice to be able to put aside people in order to increase diversity is really the way to go. And that by having removed the challenges, we're able to make sure that people aren't excluded because of their race or their background, and that they still are eligible and under the guidance of the judge in terms of final selection of the jury, I think is really a tool that we're giving the judges in order to make sure that we do have diversity and representation on our juries. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Nanaimo, Ladysmith.
Thank you, Mr. Speaker. The Status of Women Committee heard testimony from Jonathan Rudden from Aboriginal Legal Services, who I note my colleague quoted as a defender of the legislation. This is what he said, this is almost a year ago, on the record, having described the impact of mandatory minimum sentencing as being particularly hard on Indigenous women, on having removed judicial discretion. The pattern was observed that women were more and more Indigenous women in prison, and families taken away from them. Even when the children are returned, they are damaged, incredibly damaging, maybe even creating, intergenerational impacts. So he said, quote, "The first thing we urge the committee to recommend and try to do, at least to do, is to have the current government bring in the legislation they have promised to bring in to restore to judges their discretion to sentence people without the burden of mandatory minimum sentences and the restrictions on conditional sentences." End quote. So does my colleague agree with Jonathan Rudden's advice in this case? Can he explain why, although the government campaigned to make this change 3 years ago, they've done nothing and they have not fulfilled their commitment to the Truth and Reconciliation Commission calls to action to repeal the Conservatives' mandatory minimum legislation? They had an opportunity in this bill and they failed to meet it.
The honourable member for Guelph.
Thank you, Mr. Speaker, and thanks to the honourable member from Nanaimo, Ladysmith, and for her advocacy on behalf of women in this legislation. Mr. Speaker, what we are looking at is the principle of restraint that is being legislated here, that we are looking at not imposing unnecessary conditions, but we're giving the freedom to the judge to be able to determine whether mandatory minimum sentences are the way to go. Really, the job of the judge and the judicial process is to apply the proper tools. Our job is to give them the tools for which they can choose to use in the cases, depending on the individual cases and on their expertise in this matter. Thank you, Mr. Speaker.
Resuming debate. Reprise de débat. L'honorable député de Beauport.
The honourable member for Beauport. Thank you, Mr. Speaker. As you know, I'm always happy to speak to a bill that is very important to me. Today, second reading of C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. As I read this omnibus bill of 300 pages long, I think colleagues will agree that this bill is complex and tries to push under the radar certain of the elements in it. The evening of Friday 5th, there were 3 new bills that were already on the order paper: C-28, C-38, consecutive sentences, and C-39, repeal of unconstitutional provisions.
Now, this bill includes a number of changes to the criminal code, and in light of that, I'll be devoting most of my time to changes that victims and others feel run counter to what the Liberals say when they claim that victims of crime are being considered and that their rights are being respected. That is far from being the case, Mr. Speaker. Now, when it comes to placing greater importance on criminals, the Liberals are quick to take action, but there are a number of examples. Just look at the case when it comes to Terry Lynn McClintock, who savagely assassinated young Tory Stafford, who was only 8, who was then transferred to a healing lodge without the family being informed of that ahead of time, and only after a mere 9 years behind bars, when she wasn't eligible for parole until 2031. It took scores of interventions in this House by members of the opposition, a letter to the Prime Minister from little Tory's father, demonstrations on the Hill, and pressure being brought to bear by all Canadians who felt that the transfer was inconceivable, disrespectful, and finally, the Minister of Public Safety took action. Just yesterday, after too many weeks of waiting by the family, Tory's family, the Minister of Public Safety finally asked the Correctional Service of Canada to tighten up transfer policies as a result of all of the pressure brought to bear. But we still don't know if this serious mistake was corrected, because we don't know if Mrs. McClintock is behind bars where she should be. So There's no consolation for the family nor for Canadians. Correctional services must also tighten up transfer to medium security facilities. We need to encourage or hold guilty parties accountable, and Canadians must be aware of that. Mr. Speaker, Canadians were outraged by the transfer of Ms. McClintock, but above all, they were extremely disappointed to note
Honourable Secretary of Parliament.
the Honourable Parliamentary Secretary to the Minister of Justice on a point of order.
About the last 3 minutes discussing matters that relate to the incarceration of individuals and the Correctional Act, which is the purview of the Minister of Public Safety and Public Security. We are dealing here at hand with C-75, a matter that pertains to the Minister of Justice and the Attorney General. If I could perhaps ask her through you to direct her comments to this bill that is before the House.
I thank the Honourable Parliamentary Secretary. Members will know, of course, that members are asked to make sure that their comments are relevant to the matter at hand. Members also know that members are given a fairly large degree of liberty in terms of how they coach those arguments. I recognize the Honourable Member, the Honourable Député de Beauport.
The Honourable Member for Beauport, Côte de Beaupré, Île d'Orléans, Charlevoix, has taken 3 out of her 10 minutes to this point. And I hope that in the remaining 7 minutes, the Honourable Member will address the subject matter before the House. The Honourable Member. Well, thank you, Mr. Speaker. And although my colleague opposite wants me to be silent, I will continue my speech. I'm going to be using my words. I'm not here to be told to not speak. I'm here to speak on behalf of Canadians. The Liberals didn't take action and defended the indefensible by saying they couldn't take action when in fact they didn't want to. Additional damage inflicted upon the family could have been avoided or prevented if the government had had the willingness to take action, but we know the sad outcome. Mr. Speaker, the Conservatives defend victims and families, and never will we give up in cases like this. We are satisfied that this deplorable situation has progressed, but we're concerned by the fact that it has taken so long. Then there's the case of Chris Garnier, who killed a young police officer who was on duty. He is serving a sentence and receiving veterans benefits when he didn't serve a single day of his life in the Canadian Armed Forces. This is Veterans Week, and it would also be appropriate and finally right for the government to apologize and remedy that situation immediately. To go back to Bill C-75, some clauses are approvable for victims of crime. They include the elimination of provisions from the Criminal Code which are deemed unconstitutional. This will be beneficial for victims of crime, and it also makes it possible to fine-tune the code. Other provisions would deal with repeat violent offenses against intimate partners, because this treatment is an aggravating circumstance when it comes to sentencing. On this point, it's absolutely essential to include requirements that are stricter for conditional release when it comes to offenses relating to violence against an intimate partner. I'm particularly concerned with this requirement because domestic violence is on the rise in Quebec. We have to understand that domestic homicide is often the culmination of an escalation of violence over time. In over 78% of cases of homicide between 2021 and 2011. Domestic violence. The cases of domestic violence were known to the police. What's even more troublesome is that when there is an arrest and a conditional release, in cases where one partner has assassinated the other, this shows the need for strengthening provisions surrounding release. Otherwise, if this is not done, more and more innocent victims will lose their lives. Mr. Speaker, another point in C-75 that I disagree with are the changes to the victim surcharge. Victims deserve better than that. C-75 goes back to C-28. It was tabled 2 years ago, and it enabled the courts to reduce this amount, the victim surcharge, if the offender convinces the court that such an amount would be detrimental and unjustified. On behalf of victims of crime, I must vote against C-75, Mr. Speaker. Even though, in fact, there are some steps in the right direction, in my view, there are many measures that do not go far enough, and victims do not have enough of a voice in this bill.
L'Honorable Secretary Parlementaire.
The Honourable Parliamentary Secretary to the Minister of Justice. Well, thank you, Mr. Speaker, and I appreciate the comments made by the member opposite. But I would like to underscore, or ask her, in fact, if she's not of the opinion that we have improved the situation for victims.
The issue of domestic violence, conjugal violence, intimate partner violence, which is a problem throughout Canada, but also in Quebec, as she mentioned in her comments. We've made significant improvements with respect to intimate partner violence, expanding the definition, looking at dating partners, providing for harsher sentences in that context. We're also taking steps to address something that was raised at the Justice Committee, which is that victims of sexual assault are doubly traumatized if they have to appear before both a preliminary inquiry and then a subsequent trial. By limiting the preliminary inquiry process for such sexual assault crimes, are we not addressing the very victims' needs that the member opposite has just underscored in her comments?
The Honourable Member. I'd like to thank my colleague opposite. There have been some steps in the right direction when it comes to domestic violence, but victims, there are still too many victims. And what I deplore, in fact, Mr. Speaker, is the lack of guidance for these spouses, men or women, because there can be women who are aggressive. There isn't enough guidance, and many times a person is released after 2/3 of a sentence, and upon release they seek out their ex-spouse, and unfortunately it often results in murder or even more serious violence. So there is some progress, but in the 300 pages I've read through, there are still a number of gray areas. And, in fact, there are choices. There are other places where victims could be assisted, and today I'm speaking on behalf of victims because that's what we're talking about today. And unfortunately, again, under your government, in this case, the government has omitted to talk about them enough.
Secretary to the Minister of Finance.
Well, thank you very much, Mr. Speaker, and I'd like to thank the member opposite for her speech. She mentioned some of the advances made in this bill. She said she's going to be voting against it, but I'd like her to be more specific as she can, what the problem with the Bill C-75 is, in her view. The Honourable Member. Mr. Speaker, I'd like to thank my colleague from the Quebec City region. I come from a background where my father and my mother were both prison guards. My cousins are police officers. My grandfather was too. So I come from a family where we know about the prison system, where it's always been something we're familiar with. And in this bill, what we're seeing is that today, it's 2018, it's almost 2019, everything is being done to protect criminals, but nothing is being done, or very little is being done, to protect victims of crime. And it's high time that that changed.
One more short question and response. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker. And the member talked about crimes against predominantly females in domestic violence context. One of the issues that we have real concerns with is the watering down of sentences, including for the offense of administering date rape drugs, whereby the sentence could be watered down from as much as 10 years to 2 years less a day. I was wondering if the member could speak to that provision of Bill C-75 and the impact of that change, namely that an offender who was prosecuted by way of summary conviction for administering a date rape drug could not have a DNA order so that they would be in the DNA national database.
The honourable member. I thank my colleague for the question, and clearly he is right. Bill C-75 doesn't go far enough. There has been some progress, but it can be measured in very small steps. It's time for the government to put itself in the shoes of victims of crime. People who day in and day out are confronted by, well, how can I put it? They're aggressors and have no way to protect themselves. My colleague mentioned DNA. Our government put in place the Bill of Victims' Rights. And in that Bill of Victims' Rights, it specifically states that when someone is released from prison, the parents of the victim must be made aware of that. And in many cases today, that is not done. And to my mind, that is a lack of judgment. It's something that should have been included in Bill C-75.
Honourable member for Whitby.
Thank you, Mr. Speaker, and it gives me great pleasure to rise to speak to Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts. Mr. Speaker, before I begin, I would like to thank the Minister of Justice, the Standing Committee on Justice and Human Rights, for their work on this particular piece of legislation that is now at report stage, because it really does address some of the issues of delay within our court system, but also reinforces and strengthens our criminal justice system to ensure that victims are honored, that victims are looked after in a way that protects them, that protects our communities, that protects our society, but at the same time looks at ways in which there are inequities within the system. And Mr. Speaker, before I go any further, I just want to start by quoting Brian Stevenson. Brian Stevenson is a lawyer in the United States, Mr. Speaker, but I have read his book, Just Mercy. And in the book, and I'll quote from it, it says that each of us is more than the worst thing we've ever done. And Mr. Speaker, I start with that quote because I want to lay context here. I've listened to the honorable opposition members speak to this bill, and I want to re-emphasize that our objective here is not to re-victimize innocent victims, to ensure that they are adequately protected, and we look to ensuring that they are protected. But, Mr. Speaker, we know that there are inequities in the system, and this particular bill looks to increase the efficiency of a system and to also increase the equity within a system. Mr. Speaker, there has been many reports, and it's not just me saying this, about the over-incarceration of our Indigenous population or our Black population within federal system institutions across the country. So irrespective of where you are, you'll see that happening. And so, Mr. Speaker, it gives me great pleasure to stand up and speak to this bill, because I want people in Whitby to know I'm not a lawyer. This is not my background. But in looking at this piece of legislation, I want people in Whitby to know and understand what this legislation does to strengthen our criminal system, our criminal code, and to increase efficiencies. And I think by doing both, it does increase that efficiency. So Bill C-75 proposes to do a few things: modernize and streamline our Braille system, including by legislating a principle of restraint intended to reduce the imposition of unnecessary conditions and with the intended effect on reducing the overrepresentation of Indigenous and marginalized Canadians in our criminal justice system. Essentially, Mr. Speaker, this proposal is looking at, when we are imposing bail conditions, to look at the situation of the individual that is in front of the judge, to look at that situation and to come up with reasonable conditions that will prevent them from re-entering the criminal justice system. I think by doing that, we ensure that people do not, it's not a revolving door in and out of prison. We want people to be rehabilitated and otherwise, and to stay out of the system, but there has to be a thoughtful process throughout the whole judicial system to ensure that that doesn't happen. A second proposal, Mr. Speaker, is to change the way our system deals with administration of justice offenses, including by creating new judicial referral hearings as an alternative to a new criminal charge, with the goal of reducing the burden of administrative justice charges and increasing court efficiency. Again, when we look at breaches of bail conditions, for example, you have the judge has an alcoholic in front of them, and one of the conditions is that they don't drink. Mr. Speaker, it is a little unreasonable. Why not put a condition in front that they seek treatment, which is a better alternative than saying, don't drink. Let them seek treatment for that and make that be as part of the condition. So it helps that individual so they don't come back before the courts, and prevent, again, that revolving door and increases that efficiency. Another proposal to strengthen the way our criminal justice systems responds to intimate partner violence, including enhancing the reverse onus at bail for repeat offenders. Mr. Speaker, if charged with an offense, it is not up to the prosecution. It is up to the defendant to present the evidence of why they should be released. This makes it harder for them to reoffend, and it protects the victims. It should be up to them to tell the courts why they will not offend again. It shouldn't be up to the prosecution to do that, so that helps with that. It broadens the definition of intimate partner violence to include dating partners and former partners, and increases the maximum sentence involved in intimate partner violence. Mr. Speaker, another reform is a reform to jury selection processes. Mr. Speaker, this legislation proposes including reforms by including the abolitioning of preemptory challenges, reinforcing the power of judges to stand aside certain jurors in order to increase the diversity of the jury selection. That doesn't mean that that person will not have the opportunity to be a juror. It just means that while they are looking to increase the diversity of the jurors who are selected, a jury of our peers, they should reflect those who are living in the communities. So that particular component allows for judges to have that authority to do that. Jurors cannot be removed without reason. You can't just indiscriminately remove them. There has to be a reason for that. So I think that this also helps to allow our system to increase the equity within our system. Mr. Speaker, this piece of legislation also restricts the availability for preliminary inquiries to only those offenses carrying maximum penalty of life imprisonment, with the intended effect of reducing the time it takes for each case to go to trial. Mr. Speaker, we know that this particular introduction of this proposal will allow for us to understand what victims go through. We are not re-victimizing the witness by them having to testify at the preemptive and also at the trial. It increases efficiency, but it also, as I mentioned earlier, looks at ensuring that that victim does not get further victimized within the system. Mr. Speaker, I want to talk about the hybridized offenses, and I think that there are a few people that may want to understand what this is. There are 3 ways in which you can convict. There are summary convictions, indictable offenses, and hybrids. The fact that we're increasing the number of hybrid cases doesn't mean that the Crown does not have the ability, Mr. Speaker, to decide the appropriate sentence or to look at the seriousness of the offense. And I know that my honorable colleague from St. Albert, Edmonton, has brought this up a number of times. He's a civil litigator, Mr. Speaker, and during his speech, he said that, we can't just leave this up to the Crown, some Crown and somewhere in some building to have the ability to indiscriminately sentence. I'm sure he has faith in his ability of his colleagues. He was a civil litigator, and he would know that, I would hope that he would know that these lawyers take their job very seriously. And so giving them the ability, or not taking away the ability for them to decide the seriousness of a crime, not taking away the seriousness of an offense, they could still go in either direction, whether they're given a fine or 2 years or 2 years to life. That possibility is still available to our attorneys, Mr. Speaker. This is certainly not what it's doing. It's not being soft on crime. And I think that the combination of these proposals, plus the fact that our Minister of Justice has made significant numbers of appointments. Last year, over 100 appointments to the bench. We are currently at 235. We're on track this year to keep that number going. We have the most diversity in our bench. We have judges looking like Canadians. That combination of appointments plus the proposals in here increases the equity in our system and increases the efficiency in our system. Thank you very much, Mr. Speaker.
Questions and comments? The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the member for Whitby for her speech. I want to ask her a question about hybridization, and in that regard, how that is going to make the justice system more efficient, which is the basis upon which the government claims that it is reclassifying or hybridizing offenses. The effect of hybridization is that more cases will be prosecuted by summary conviction. That means that they go down and are prosecuted at the provincial court level rather than the superior court level. We know that 99.6% of cases are already prosecuted at provincial courts, and in addition to that, from the standpoint of the Jordan decision, which imposed timelines upon which delay is deemed presumptively unreasonable, at which point the burden rests on the Crown to justify the case continuing, it's 30 months in Superior Court and only 18 months in provincial court. So not only is the government downloading cases, but they're reducing the timeline to prosecute by about half.
The honourable member for Whitby.
Mr. Speaker, I'd like to thank my honourable colleague for his question. To reiterate, the summary cases have less procedural aspects. They move much more quickly through the system. They do not need as many procedures, and they do increase the efficiency within our justice system. But I would like to talk specifically about the hybridization and to look at, for example, the honourable colleague has brought up before in this House, the instance of kidnapping, for example, and making that a hybrid offence. When we look at kidnapping, you could either have someone, and I have 3 kids, Mr. Speaker, you could either have someone who stands outside a school with a van, luring kids into their van and saying, I am going to take you away and kidnap you in that sense. Or you could have a case in which, a custody case in which a child says, I don't want to live with mom anymore. I'm going to run away and go stay with the dad. Mom calls the police. That is also the same kind of classification as a kidnap. Those 2 things are not the same. And so again, the Crown still has the ability within that context to look at those 2 cases of kidnapping and classify which is the more serious offense, which requires a lifetime imprisonment or which requires 2 years or less.
Questions and comments? The honourable member for Kootenay, Columbia.
Thank you, Mr. Speaker, and I'd like to thank the honourable member from Whitby for her speech. I'd like to address just briefly preliminary inquiries. Preliminary inquiries are, in essence, dress rehearsals for subsequent trials, and they're only used in 3% of cases, so eliminating these isn't really going to save a lot of time. And also, sometimes during these preliminary inquiries, the Crown's case can collapse entirely, and you don't end up having to hold a much longer trial. And critics also claim that their elimination can limit the rights of the accused to fully comprehend the case against them and may increase wrongful convictions. In fact, the Canadian Bar Association, and I'll quote, said Bill C-75 would restrict preliminary inquiries to offences with a maximum sentence of life imprisonment, as the member said. They go on to say this would not reduce court delays and would negatively impact the criminal justice system as a whole. As lawyers who practice in Canada's criminal courts every day, we know the practical value of preliminary inquiries to the criminal justice system. So I'm interested through you, Mr. Speaker, what the member would have to say to the Canadian Bar Association on preliminary inquiries.
Honourable member for Whitby.
Well, Mr. Speaker, I would start off by saying that I don't purport to be a lawyer or to speak to the Canadian Bar Association in a way that they could speak among themselves about this particular reform. But the proposals in C-76 propose to restrict the availability of preliminary inquiries to only those offenses carrying maximum penalty of life in prison, with the intended effect of reducing the time it takes to reach trial. Mr. Speaker, I think one of the things that this does is look at, again, the witnesses and the re-victimization of individuals who have to, at the inquiry and again at trial, go through their testimony, go through some of the very difficult circumstances that took place within the act that happened to them, and that can be a very painful and excruciating process, Mr. Speaker. When we look at limiting those to only offenses that carry a maximum penalty of life in prison, we are ensuring that some of the issues that my colleague is talking about, having the witnesses there, being able to testify for those very serious offenses, are taken into consideration.
Resuming debate, the honourable member for Edmonton, Strathcona.
Thank you, Mr. Speaker.
Mr. Speaker, it's my honor to rise to speak to this bill. We've waited long and hard for these omnibus changes to the criminal code, and a number of the changes have been welcomed by our party. Regrettably, a number of the changes that could have been made and actually promised by the Liberals have not been made, and that is deeply disappointing, not just to us, but to Canadians and to the lawyers who represent them when they end up before the courts.
many of the reforms and the calls for reform have come from the decision of the Supreme Court of Canada in the case of Jordan, where they put in place, as many have spoken to here, a new framework and timeline on the necessity of processing cases, trials through the courts, and the intention being to try to resolve the backlog of cases. In many cases, very serious offenses and charges are simply being dropped because the cases have not proceeded according to the Charter of Rights in an appropriate time, in accordance with the new timelines imposed by the Supreme Court of Canada. As former Chief Justice Beverly McLaughlin 2 years back admonished this government, saying that, in quotes, a perpetual crisis of judicial vacancies in Canada is an avoidable problem that needs to be tackled and solved, end of quotes. So that has been the focus of a lot of the debate that has gone on in this place in the 9 years that I've been elected, and repeated calls by the opposition to the then Conservative government, and now continuing calls by the opposition to the Liberal government to fill those vacancies. But there are other measures which can be taken, some of which have been taken by this government, to try to address the backlog in the courts and to ensure justice is done. But there are a number of significant measures that apparently the Justice Minister was mandated to do and chose not to, at least not at this time, maybe after the next election, which is usually the reason given. Judicial appointments are seen as one solution to the backlog. Other possible solutions have been requested and, as mentioned, not adopted in Bill C-75, despite calls by my colleague, the New Democrat Justice Critic, the MP for Victoria. And his calls have been drawn from the testimony by experts in the field, including the Criminal Trial Lawyers Association. I'm a member from Alberta, and I've noted in the 9 years that I've been here the calls by the Attorney General of my province for the filling of judicial vacancies, which is the prerogative of the federal government, and the hundreds of cases thrown out because of the failure to fill across the country. And there is appreciation that some of those vacancies have been filled, particularly since this past April. But of note, those calls were made by the opposition to the then Conservative government and not filled, and now the calls continue from the opposition to the Liberal government. My province of Alberta has been calling for federal action to fill these judicial vacancies, and are pleased that some action is being taken, but I do want to credit my own provincial government that they are taking action. The Canadian Bar Association has criticized this government for the chronic failure to appoint, in some cases, over a year delay. As I mentioned, I commend the Alberta government for their action in filling vacancies and, in fact, creating new positions in the provincial courts, in quotes, to ensure Albertans have more timely and representative access to justice, end of quotes. And they have also appointed additional clerks and prosecutors to ensure that the cases proceed more expeditiously. I particularly wish to point out some of the recent appointments made by the Government of Alberta. In April of this year, Judge Karen Crochew, first Indigenous woman called to the Alberta Bar Association, and the first female First Nation provincial court judge. This week alone, the Alberta court appointed Judge Cheryl Arcand Kootenay. She is the third First Nation woman appointed to the provincial court. Secondly, Judge Melanie Hayes Richards has been appointed to the Edmonton Criminal Court. And third, Judge Michelle Christopher. She is the first woman appointed to the Judicial District of Medicine Hat in the history of our province. So kudos to the Government of Alberta. Mr. Speaker, there's a number of solutions that could have been taken in Bill C-75 that were not taken. My colleagues have consistently called for this government to cease charging Canadians for the simple possession of small amounts of cannabis. All of those charges, the tens of thousands of Canadians charged for simple possession, have clogged our courts. And we could have simply resolved that even in the past year, where the government has made it clear it was going to legalize cannabis by stopping the charges, those criminal charges. But they chose not to, and so the courts remain clogged. In addition, there have been a lot of calls, including by mothers, a group, moms, to address opioid addiction. and they have been calling for the decriminalization of small amounts of opioids for personal use and to address it as a mental health challenge. Again, those charges could reduce time in our courts. Preliminary inquiries. A number of colleagues in this place have talked to concerns about the government making the decision in C-75 to remove the opportunity of preliminary inquiries. The government has professed that this removal will make judicial process more efficient, but it has been mentioned it's very, very small percentage, 2 to 3%, even of cases that ever go through preliminary inquiry. So obviously will not have substantial effect on reducing the clogging of the courts. There has been concern by the Canadian Council of Criminal Defence Lawyers that this may pose a serious risk of more wrongful convictions. And we have to remember why we have preliminary inquiries, and it has been mentioned previously that in some cases, as a result of a preliminary inquiry, the charges are dropped. It's a good opportunity for the defense to review the evidence by the Crown, and it is concerning. While this government continually likes to use the word balance, this bill is not adequately balancing greater efficiency in the courts and the protection of the rights of the accused. I would also like to speak to the issue of minimum maximum sentences, and that has been discussed a lot in this place. My colleagues are expressing great disappointment, based on also what a lot of the expert witnesses testified to at committee, that the removal of minimum mandatory sentences was not addressed in this 300-page omnibus criminal justice bill, and that dealing with this issue specifically prescribed in the mandate letter to the Justice Minister seemed logical that it would be included in this omnibus bill. Many remain puzzled. Why the delay? And again, as I mentioned, is this going to be yet another Liberal promise that's delayed until the next election? This is a solution that could genuinely address the clogging of the courts, and we would encourage the government to be moving forward more expeditiously and tabling a measure on that before the recess for the next election. Many expert witnesses to the committee, including the Criminal Trial Lawyers Association, recommended taking action on these measures introduced by the Harper government as a significant factor in clogging the courts. And if I can quote the Criminal Trial Lawyers Association, mandatory minimum sentences frustrate the process of resolving cases by limiting the Crown's discretion to offer a penalty that will limit the Crown's ability to take a position that will foster resolution before trial. The effect has been, we're told, to increase the choice to go to trial rather than pleading to a lower charge, and that is because of the necessity by that law that there will be a minimum penalty imposed. And so many who are charged then say, well, I'm going to go to court, I'm going to try to beat this rap because otherwise I may receive a great sentence. And that has really clogged the courts. I have the signal I should close soon, and so I will say, I would quote again Jonathan Rudin with the Aboriginal Legal Services. He has emphasized the need to restore judicial discretion, particularly for Indigenous women, as the Liberals promised. And he has said, we have to look at the fact that there are still mandatory minimum sentences that take away from judges the ability to sentence Indigenous women the way judges would like them to be sentenced. There are still provisions that restrict judges from using conditional sentences, which can keep women out of prison. And I look forward to questions, and I can elaborate further. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker, and I thank the member opposite for her contributions to this House and to her community. I'll confess to find some of the statements made by the member opposite a little bit surprising in respect of her concerns about appointments. Mr. Speaker, clearly when you have to overhaul an entire appointments process, it takes some time to get it right. But what we've done in overhauling that process is shifted from a situation where 30% of the appointees under the previous government were women to a situation where now 57% of all of our appointments have been women, 12% have been racialized, 6% are LGBTQ, and 3% are Indigenous. 230 people have been appointed across the country, including 34 in the province that the member represents. So I would ask her simply, does she share our view that you actually strengthen the administration of justice when that justice is delivered by a bench that actually reflects the community it appears before?
Member for Edmonton Strathcona.
Mr. Speaker, of course I agree with that suggestion. But what I find stunning is when I visit the law school in my constituency, the University of Alberta, a large majority of the students are women. I know that when I graduated, a huge number were women. It's not that we don't have qualified women. It's not that we don't have qualified Indigenous lawyers. It's not that we don't have people from all kinds of different racial backgrounds. It is a poor excuse for the delay in the appointment of judges.
Questions and comments. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I want to thank the member for Edmonton Strathcona for her speech, and I do want to touch upon judicial appointments. Under this minister's watch, we have seen a record number of judicial vacancies. As the member pointed out, months went by where the minister failed to appoint a single judge. The situation became so acute that former Chief Justice Neil Whitman spoke out in the spring of 2016. She's quite right that the provincial government did respond by way of order in council by establishing 10 new judicial posts in October of 2016. The government says it's a priority to fill judicial vacancies. They didn't get around to filling one of them until a year later when my former colleague Grant Dunlop was appointed to the Court of Queen's Bench. It seems, Mr. Speaker, with that kind of a record, that their record doesn't match their rhetoric in terms of taking the situation of judicial vacancies seriously.
Honourable member for Edmonton Strathcona.
Mr. Speaker, as I've mentioned previously during questions to other colleagues who have been speaking, the Conservative Party, where they are in power, were also chastised by provincial attorneys general for the delay in appointments. And so I think both bear the responsibility, and I see no reason whatsoever for not proceeding. We have many qualified lawyers in this country, and it's not the only solution. The appointment to the courts is important. We need more prosecutors, but we can also reduce the number of cases going forward if we take some of the measures that we have recommended. For example, simply referring a lot of people who are addicted to opioids to mental health and other supports instead of charging. There are many solutions. A lot of people are in court not being represented because they can't afford it. This government should step up to the plate and provide more money for legal aid.
Questions and comments. The honourable member for Charleswood, St. James, Assiniboia, Headingley.
Thank you, Mr. Speaker. I'd like to thank the honourable member for her comments, and I agree completely with the comments on more treatment and less criminalization for those who are addicted to opioids. My question is regarding the delay in, or rather, criticism for our continued prosecution of people with simple possession of cannabis before we had legalized it. As you know, Mr. Speaker, our plan was to legalize and strictly regulate cannabis. To stop charging would basically lead to a de facto legalization without any of the regulations in place. Does the honourable member state that we should have had a de facto legalization before we had the regulatory regime in place?
Honourable member for Edmonton Strathcona.
Mr. Speaker, we're talking here about changes to the criminal code. Our party was very clear. We long called for the decriminalization of the simple possession, and that could have been done in the first year that this government was in office, and we could have avoided tens of thousands of charges against Canadians who now probably can't cross the border.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. What a pleasure it is once again to be able to rise and share some thoughts and opinions on what is a very important issue. You know, we take a look at legislation, and this isn't the first piece, but it is a very comprehensive piece of legislation that we have before us. It will, in fact, modernize in a very comprehensive way our criminal justice system. A lot of positive changes that are here. I must say I'm a little bit surprised that my friends across the way, the Conservatives, continue to find ways in which to be critical of good, progressive legislation such as we have here today, and I hope to be able to maybe highlight what I think where it is somewhat misplaced from the Conservative Party. You see, Mr. Speaker, we talked a lot in the last federal election about the importance of keeping our communities safe, protecting victims, and ultimately holding violators or offenders accountable for their actions. And what we have today before us is legislation that will do all three of those points, Mr. Speaker. And that is why, with enthusiasm, I stand today to highly recommend to members to maybe look again, in particular the opposition members, to look again and take a look at what it is that this government is doing in regarding to making our communities safer, protecting our victims, and, in fact, holding those offenders more accountable. Those are three aspects of this legislation that I believe need to be taken into consideration when people choose to stand up and vote in favor or against this legislation. I compliment the minister and the fine work she has done in terms of working with the different stakeholders. Mr. Speaker, we understand that when you think of our justice system and our court process to law enforcement, it's not just one level of government that is ultimately responsible for all of it. We are dependent on ensuring that there's a high sense of cooperation and discussion and dialogue, in particular with our provincial and territorial entities, Indigenous people, Mr. Speaker. There's many other stakeholders beyond what I just finished referring to that need to be taken into consideration and listened to. And I believe that the legislation that we have before us today is very reflective in terms of what Canadians want to see. The discussions that came out of the numerous consultations through the department, Mr. Speaker. And I'm happy to say that when the minister brought in the legislation, made it somewhat clear in some of the discussions and debates that we had that we were open to amendments. And we did receive amendments at the committee stage. The committee did some outstanding work, I must say, Mr. Speaker, and you will find that through that process that the government even accepted amendments that were not even government amendments. Contrary to the days of Stephen Harper, when opposition members were never respected in terms of their amendments, we recognized that there were some positive amendments coming from the opposition, and we got behind and supported that, Mr. Speaker. So it seems to me that the system worked quite well. And I started off by talking about the election and the discussions that members of the South, no doubt from both sides, but I can tell you, at least from the Liberal members of Parliament, when we met with the electorate, we were very keen on the issue of crime and safety and what it is that Canadians had and expected of this government. And that is why we have this progressive piece of legislation that we have today before us. And there was commitments that were made. We commented that we would bring in comprehensive criminal justice reform. We talked about the importance of intimate partner of violence and what it is that we might be able to do with respect to that, Mr. Speaker. So this legislation, in good part, is yet another example of one of many pieces of legislation that this Prime Minister and this government has brought to the floor of the House that fulfills yet again another commitment to Canadians in the last federal election. Once again, I believe that Canadians would be happy with the fact that we are addressing those type of commitments that we know were important to them. So let's talk about some of those changes. You know, my friends in the Conservative Party seem to have a real difficult time with the whole issue of the hybridization. And I might be mispronouncing the word somewhat, but I think I caught the essence of it, Mr. Speaker. And we take a look at it. We have summary convictions, and we have indictable convictions. And then there's a list, Mr. Speaker, that allow for the process to be able to say, well, that could be considered as indictable or summary. And my colleague made reference to kidnapping, and I think that's kidnapping is an excellent example, so that people that are following the debate, that are interested in the debate on this legislation, can kind of get a sense of what it is specifically that the Conservatives are actually opposing. And I'll use the example of kidnapping. There are many lawyers in every region of the country, unfortunately, that will be able to tell you about the negative consequences of a family breakdown, where there's a divorce that takes place, where there's a custody situation. I would ask members to put themselves in the position of a 12-year-old child that has a mom and dad living apart. Maybe it's the mom that has the custody of the child. And that child's having a real rough day or possibly even a pretty bad week, and decides to give the other parent a call and say, look, I don't want to be here. Come and pick me up. I'm really upset. I'm going to run away, or whatever that child might actually say, that 10-year-old child. The other parent maybe meets the child somewhere and or somehow accommodates that child being in his or her home, or maybe drops them off at grandparents' place. Well, technically, Mr. Speaker, that is kidnapping. And kidnapping is a very serious charge. Surely to goodness people that might be following the debate would recognize that that is quite different than someone that preys on a child that's walking out of a schoolyard and throws that child into a van and then maybe does something horrific or decides to try to hold that child for a ransom, or put that child in a dangerous situation such as prostitution. That's a fairly significant. What we're saying is you have the two extremes, and there's a lot of things in between. You know, allow for, under the hybridization, the opportunity to see the discretion. What I like about this legislation, Mr. Speaker, is that's only one aspect. That there's many other things that I could be talking about. You know, I made reference, Mr. Speaker, to the intimate partner violence. We need to realize that it's not just common law relationships or marital relationships where there's an actual certificate, Mr. Speaker. It could be dating relationships where there's that sense of intimacy and the violence, where the victim it really needs to be taken into consideration and given that extra consideration. And that has taken place here, Mr. Speaker. I like the idea that we are providing the opportunity to get rid of preliminary trials. That is a positive thing, Mr. Speaker. It's a very positive thing. We're limiting it. And let me give you a specific example of that. Imagine someone that is a victim of an assault, a sexual assault. Well, as opposed to having to go through a preliminary and relive that nightmare, Mr. Speaker, that preliminary trial could be gotten rid of, where you just have the trial. I see that as a good thing. You know, my Democratic friends just previously said, well, it's such a small percentage of the overall court cases. No, not true. You're talking about, well, it's true, it might be a smaller percentage, but we're talking about thousands of cases. Imagine the impact that has on court times. This legislation, Mr. Speaker, does so much more to reform our system. It's good news for Canadians, and that's why I would recommend all members of this House to rethink their position, get on side with the Prime Minister and this Cabinet and the government, and support it. Thank you.
Questions and comments. The Honourable Member for Kitchener-Conestoga.
Thank you very much, Mr. Speaker. I want to thank my colleague for his comments. A couple of the phrases he used during his speech was progressive legislation, keeping our communities safer, protecting victims, reflective of what Canadians want to see, Mr. Speaker. He said that. This bill is reflective of what Canadians want to see. Well, we know, Mr. Speaker, that this bill purports to reduce the sentences for at least 25 offenses, some of them very serious. I'm not going to read all of them. I'd like to ask my colleague, of these 5 or 6 that I read, which ones did he hear from his constituents that they want sentences reduced for? Would it be for obstructing violence or to arrest an officiating clergyman? Would it be for impaired driving causing bodily harm or death? Would it be for extortion by libel, or arson by negligence, or participation in activities of a criminal organization? Which one of these offenses that are going to have sentences reduced, which one of them has he heard from his constituents that they really want these sentences reduced? Thank you, Mr. Speaker.
Parliamentary Secretary to the Government House Leader.
Mr. Speaker, let me go back to something in which I know my constituents like about this legislation, and it was the specific example that I had given. Imagine that victim, that physically or sexually assaulted victim, where that victim is now not necessarily having to go through a preliminary trial. That means they do not have to relive that nightmare of an event that had taken place. I can tell the member 99% plus would support that sort of an initiative that's within this legislation. The legislation in which the Conservative Party has chosen to oppose, Mr. Speaker, and then on the other hand, try to say that they stand up for the victims. They should give their collective heads a shake, Mr. Speaker, get behind this legislation because it is in the victim's best interest too.
Questions and comments. L'honorable député de Beloy-Chambly.
The honourable member for Beloy-Chambly. Thank you, Mr. Speaker. And I'd like to correct something because my colleague was characterizing our position on criminal investigations. I didn't think it would I didn't say it would solve the problem of delays because there aren't sufficient investigations that they would delay things. Our major concern is what defense lawyers presented in committee. They said it is the preliminary hearings or inquiries where they can see that the person shouldn't be charged. Now, we will have people who aren't guilty who will find themselves in a situation where there's a big trial, and we'll see the conviction of people who aren't guilty increase. And there are already an overrepresentation of vulnerable people. So how can we avoid mistaken convictions?
Thank you, Mr. Speaker. One of the advantages of being around listening to a lot of the debates, I can assure the member, if he was to review some of his colleagues' comments, that what you'll find is that some of his colleagues have tried to give an impression that, well, the preliminary hearings and trying to limit the use of preliminary hearings will not really reduce, the amount of court time. And I would suggest that, from a percentage perspective, yes, preliminary hearings are in a relatively small percentage of the overall cases that go before the courts, but we're talking about thousands and thousands of hours, Mr. Speaker. And when you take a look at the legislation as a whole, there are many efficiencies in it that will ensure that we have a more efficient system. But a big part of it's not just having an efficient system, it's to try to assist in making, as I say at the very beginning, Mr. Speaker, our communities safer. It's about ensuring that there's accountability for those offenders, and that's really what's important for us to recognize. This legislation improves all aspects, and the bottom line is we'll have safer communities as a direct result.
We have time for just a very short question and response. The honourable member for Whitby.
Thank you, Mr. Speaker. And I just want to allow my colleague to go back to the comments from the member from Kitchener-Conestoga, where he said, and I don't think he was trying to mislead the House, but he said that this piece of legislation would be reducing the sentencing for a number of different offenses, which, Mr. Speaker, again, we are not taking away the ability for the Crown, the prosecution, to classify whether an offense goes to summary or to an indictment. We are not taking that away. The Crown still has the opportunity to look at a case and see whether that offense is serious enough to have life or it's not serious enough to have a couple of years. So, Mr. Speaker, I'd love to give my honourable colleague the opportunity to correct the possible mistake that my honourable colleague made.
Honourable Parliamentary Secretary, a short response, please.
Yes, thank you, Mr. Speaker. I appreciate my colleague raising that particular issue, but I'm not going to be as harsh on the member. And the reason why, Mr. Speaker, because he's talking about the Conservative spin. You see, Mr. Speaker, that's all a part of the Conservative spin on this legislation. It doesn't have to be true. They just use it because those are the type of hit points or the media lines that they are trying to circulate to Canadians. It doesn't have to be true, but they still feel obligated to say it.
The honourable member for Kitchener-Conestoga on a point of order.
I draw attention to the unparliamentary language. He's basically accusing me of lying. He's saying that it doesn't have to be true. Well, if it isn't true, it's lying, Mr. Speaker. I take objection to that, and I would ask you to correct us.
I thank the honourable member for his point of order. The use of the word true or not being true, these are words that are expressed from time to time. We generally, depending on the context, how they're used, unless it's quite evident that the member is suggesting that a person was deliberate in expressing an untruth, particularly towards another member, that's when it would cross the line into unparliamentary language. I don't think that was the case in this particular occasion. So we'll go to resuming debate, and the honourable member for Medicine Hat, Cardston Warner.
Thank you, Mr. Speaker, and I rise today to speak on the Liberal government's Justice Reform Bill, Bill C-75. Now, if the Parliamentary Secretary was worked up during his presentation, I can't wait until he hears what I have to say, Mr. Speaker. Hear, hear. Sadly, I can't find a lot of good things to the report on this bill. I can't report it to my riding constituents or to my Canadians at large. Like a number of the Liberal government's legislative measures, the purpose of the bill does not always match up to what the bill will actually do. For example, recently in Bill C-71, the Minister of Public Safety used tragic shootings and gun and gang summit to suggest he was putting forward legislation that would tackle illegal guns, gangs, and violent criminals. The sad reality was the legislation he proposed never once mentioned gangs or organized crime and does nothing to deal with illegal weapons and crimes caused by them. Prior to that, Mr. Speaker, the Minister of Public Safety also introduced Bill C-59, a bill he claimed would strengthen our national security and protect Canadians. Again, the reality was very different, as the bill moves nearly $100 million from active security and intelligence work that actually does protect Canadians to administrative and oversight mechanisms and functions. And worst of all, the Minister of Public Safety made bold claims about moving C-51 to committee before second reading to, and I quote, "I would inform the House that in the interest of transparency, we'll be referring this bill to committee before second reading, which will allow for a broader scope of discussion and consideration and possible amendment of the bill in the committee when that deliberation begins," end of quote. But when it came time to actually consider reasonable, bold, or even small amendments, the Liberals on that committee fought against everything to ensure that the bill didn't change at all in scope or scale. The results will place the security of Canadians at greater risk, and for those who actually work in national security, more people looking over your shoulders, tougher rules, more paperwork, and few, if any, benefits, as frontline efforts to protect Canadians only become more difficult. Now, under Bill C-75, we see the same old story. The Justice Minister has made bold claims that she would be helping address the backlog of cases created when the Supreme Court imposed the maximum time frame for them. Some of her claims include that this legislation would improve the efficiency of the criminal justice system and reduce court delays. She said that it would strengthen response to domestic violence. It would streamline the bail hearings. It would provide more tools for judges. It would improve jury selection. It would free up court resources by reclassifying serious offenses. Wow, that sounds like fantastic. What a great bill. Streamlining the courts, strengthening the justice system, domestic violence, improving tools for judges, improving jury selection. Incredible. But sadly, Mr. Speaker, the Liberals are not achieving any of these objectives, according to the legal community or any of the knowledgeable leaders in this House. Does it shorten trials and ensure that we deal with them, to deal with the backlog? Well, The minister appears to make the claim with the elimination of most preliminary hearings. Now, preliminary hearings are, according to the legal community, account for just 3% of all court time in this country. So with an overloaded court system, eliminating a huge number of these hearings will only have a minimal impact at best. Preliminary hearings often weed out the weakest cases, which mean more cases will go to trial, thus increasing the court backlogs under this current legislation. What can also happen with preliminary hearings is that they create opportunity for the defense to recognize the need to seek early resolution without a trial. Moreover, preliminary hearings can deal with issues up front and make trials more focused. Instead, this new legislation in many cases will be longer, and with added procedural and legal arguments. One member of the legal community called this bill a solution to a problem that didn't exist. High praise for this legislation indeed, Mr. Speaker. But it is the changes to serious criminal offences that have many Canadians, not just the legal community, concerned. I think all members of the House could agree, or at least accept, that not all criminal code issues need to be treated in the same manner, and that serious offences like a homicide and minor offences like vandalism or property damage do not meet the same threshold for a punishment, and we can all agree to that. But, Mr. Speaker, Canadians expect that Ottawa, that government, will make sure we create safe communities and that the law benefits all people, not just slanted in favor of those criminals. Under Bill C-75, the Liberals have provided the option to proceed with a large number of violent offences by way of summary conviction rather than an indictable offence. This means that violent criminals may receive no more than the proposed 12 months in jail or a fine for their crimes. A slap on the wrist for things like impaired driving causing bodily harm, obstructing justice, assault with a weapon, forced marriages, abduction, participation in a criminal organization, human trafficking, and those are there's many more, Mr. Speaker, but it bears time to look at these in particular. These are serious offences. Allowing these criminals back on the street with little to no deterrence makes even less sense. These serious criminal issues should have the full force and effect of the law. None of these scenarios, victims or society, is better served when those responsible for these offences serve only a minimal jail sentence or receive a fine. The principle, Mr. Speaker, is that Canadians expect that our government and our courts will be there to ensure that criminals receive the due punishment for their crime, and that law-abiding Canadians and those who have been victimized by these criminals are treated fairly and with respect. In short, Mr. Speaker, this bill undermines the confidence of Canadians in our criminal justice system and makes it more difficult for law enforcement to ensure safe communities. And, as my colleagues have clearly pointed out already, there are other solutions, better solutions, in fact, Mr. Speaker. The minister could address the backlog with more judicial appointments, as an example. As the former Minister of Justice has said, there was never a shortage of qualified candidates in his 6 years as the Minister of Justice. So it is not a failure of the judiciary. It's not that there are too many preliminary hearings. It's not that there are way more criminals, because crime rates overall have been declining. The problem resides almost entirely with the minister getting more people on the bench in the prosecution services. As I've said in the House before, public safety and national security should be the top priority of this House. It should be above politics, so that the safety and security of Canadians are put ahead of political fortunes. While the Liberals have said that public safety is a priority, they have said that everything is their top priority. And to have 300 top priorities, Mr. Speaker, means they have no priorities at all. Canadians expect that the government will make them their priority. Sadly, this bill fails the test to keep Canadians safe and deliver effective government. The legal community has said this bill is deeply flawed and will hurt the legal system rather than help it. Police will likely see themselves arresting the same people over and over again, even more so than they do today, Mr. Speaker, as criminals get lighter sentences or fines. So the backlog will move from the courts to the policing community, back to the courts, back to the policing community. And how does that help the average Canadian? Canada has been weakened by this Liberal government, Mr. Speaker. Their wedge politics on the values test, pandering to terrorists, ignoring threats from China, targeting law-abiding gun owners, their lack of leadership on the illegal border crossers, and waffling on resource development continue to put Canadians at a disadvantage, weaken our public safety and national security, and place undue strain on families and communities. Mr. Speaker, Canadians deserve better. And in 2019, I suspect, Mr. Speaker, we will get a better justice minister, we will get a better justice bill, and we will get a better government. Thank you very much.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
Mr. Speaker, I thank the member opposite for his comments, and I'm going to put to him something similar to what I addressed to the NDP member from Alberta, which is that when you inherit a flawed process, it takes time to perfect it. And that flawed process of judicial appointments, highlighted by the member opposite, produced a situation where 30% of this country's judicial appointments were women. The process which we've put in place, which is merit-based, inclusive, and venerates personal lived experience, has produced a process which has resulted in 57% of our appointments being women, 12% being members of racialized communities, 6% being people from the LGBTQ community, and 3% being Indigenous individuals. And the question I would ask the member opposite is that, does he believe and does he agree, when we've appointed 230 appointments thus far, 34 in his own province, that the administration of justice and the confidence in the administration of justice is enhanced, not diminished, when you have a bench meting out justice that reflects the communities that are coming before that bench? Thank you.
Member for Medicine Hat, Cardston Warner.
Well, thank you, Mr. Speaker, and thank you for my friend for the question. I guess one has to debate whether or not the system of appointing judges was flawed in the first place. That's number one issue. Number two, it took this government a full year to stand up their Judicial Advisory Committee. A full year.
Shocking.
And so we wonder why we have a backlog in our system. They dragged their feet. The government did nothing. They didn't think they needed to. Well, and now we're paying the consequences for that, Mr. Speaker. So I guess that evidence rests on its own merits.
Questions and comments. The Honourable Member for Whitby.
Thank you, Mr. Speaker. And during my colleague's speech, she talked about knowledgeable leaders in this House, and the person sitting right in front of him, the member from St. Albert, Edmonton, is a lawyer, and I would think that he would have confidence in lawyers and their ability to handle justice across Canada. Mr. Speaker, he also said that Canadians expect that people receive due punishment for their crimes, Mr. Speaker. So, to be clear, we are not removing the ability for prosecution lawyers, such like the member sitting in front of my honourable colleague, we are not removing the ability for them to look at an offence and decide the seriousness of that offence, and to then decide whether it should be a summary conviction or it should be indictable. We are not taking that away. We are not removing their ability to do that. So we are not reducing sentencing for serious crimes. We are giving the prosecution, much like many of my honourable colleagues, friends and colleagues, the ability to do, which we know that they'll do in a just way and an effective way, in order to look at who's before them and give them the right punishment.
Just a reminder before we go to the honourable member, to remind honourable members that we try to stay away from making reference to the presence or absence of members in the House. The honourable member for Medicine Hat, Cardston Warner.
Mr. Speaker, thank you, and I'd like to thank my friend across the way for her question. And I think one of the things that I've heard from the legal community about this bill is that it does water down sentences, even though the rhetoric on the other side doesn't, they don't admit that. But it also takes away the ability for judges to have, the discretion that they need to manage their cases in the manner in which they need to. And, it puts that onus kind of on the prosecutors without a lot of transparency. And it's unfortunate that it does that. And I think over time, if this bill should pass in its current form, the justice system and those in the legal community who have warned us about this, we will see this begin to happen, and it will have detrimental effects.
Questions and comments. Have time just for one more short question. The honourable member for St. Albert, Edmonton.
Here.
Thank you, Mr. Speaker, and I want to thank my colleague, the member for Medicine Hat, Cardston Warner, for his very thoughtful speech. He touched upon hybridization, and one of the things that the minister, I would almost suggest laughably, states is that the hybridization has nothing to do with sentencing. It has nothing to do with sentencing at all, even though you're going in some cases from a 10-year maximum down to a maximum of 2 years less a day. I was wondering if the honourable member would agree with the Justice Minister that hybridization has nothing to do with sentencing, and if that is so, then why would the government rightly have removed from the bill the reclassification of terrorist and genocide-related offences? Unfortunately, they didn't do so in the case of other very serious offences.
Member for Medicine Hat, Cardston Warner.
Thank you, Mr. Speaker, and thank you to my colleague for the question. I know we're pressed for time, and I will simply say it is all about sentencing and the reduction of sentences. That's the only impact this will have. And so there's nothing more to be. This will shorten sentences clear across the board for those offenses identified. Thank you.
Resuming debate, the honourable member for South Surrey White Rock.
Well, thank you. Thank you very much, kind speaker. It is my pleasure to get up and speak to Bill C-75, an act to amend the Criminal Code and the Youth Criminal Justice Act and other acts that are consequential amendments to other acts. And my particular interest is the Youth Criminal Justice Act, having spent 25 years working with the Criminal Justice Act in British Columbia, starting out as a youth probation officer, working on the streets of Surrey, riding with RCMP officers and responding to calls, particularly with youth violence and domestic violence, and being able to be engaged in that, being a foster parent for a number of youths who had been in conflict with the law, and most importantly, being the warden of our largest youth jail in British Columbia for some 10 years, and working with youth who were on overnight arrest, remand, and longer-term sentence, including a number of very serious offenders. While having that experience, I also went back to university to get a PhD and was appointed an adjunct professor in criminology at Simon Fraser University, a position that I hold today. And it's allowed me to look at this from a conceptual framework as well as from a practical experiential model of looking at the concerns and issues facing us. The Youth Criminal Justice Act, we have been very good in Canada in being able to reduce the number of youth coming into custody. Our numbers 25 years ago were substantially higher on a per capita basis, but the development of a number of alternative measures have made our system much more responsive to the nuances and needs of young children and young youth in particular. A number of good research has been in place over the past 15 to 20 years, particularly the Krakow study, which is originally funded by NATO, which has been standardized in Germany as well as in British Columbia. And it's a longitudinal study looking at the issues that become prevalent when youths come into conflict with the law and the challenges we're responding to those. And there are, as a result of this study, this longitudinal study that's been tracking youths for up to 15 years now, we are much better informed in terms of the actions we should be taking for dealing with them. There are 5 profiles or pathways that have become evident in this research that inform the way we should be responding to the needs and nuances of them. In some instances, we're able to look at and make some relatively accurate predictions with respect to the propensity of a youth to become in conflict with the law, even preconception. There are environmental influences, the presence of physical abuse, of emotional abuse, sexual abuse is overwhelming in terms of the number of youth who come in conflict with the law. There are a number of neurological and developmental disorders which are precursors, ADHD, ADD, fetal alcohol syndrome. In certain communities, these items are epidemic, and they've been particularly evident within a number of our Indigenous communities, and certainly domestic violence has a strong link as well. Alcohol and drug addiction, and there are a number of samples in the jail that I was responsible for. Up to 90% of the youths coming into custody had been using hard drugs. personality disorders, aggressive disorders, dependency disorders, antisocial personalities, psychopathy. Those types of disorders are also very prevalent. In fact, we were finding when we used to believe that youth come in conflict with the law in their early teens, it's become younger and younger, and we're finding now that some parents are taking their 2-year-old children to Children's Hospital saying they can't control them anymore. And when that happens, because of the medical model, we tend to mask it with the utilization of drugs and managing it in that fashion, which later on in life manifests itself as they come away from the drugs in all kinds of deleterious and negative behaviors. Many youth come from high needs, from single parent, high economic need, domestic violence, family and child abuse, and 60 to 70% of them come from out of foster care. So the legislation that we're talking about before us in terms of addressing the needs through the Youth Criminal Justice Act looks at how we can provide more community-based responses. We can look at alternative measures so that there's some more choices provided to the courts and to the Crown Council when youth come before the courts. And certainly every bit of the modern research that's being done tells us that we can have a far more profound impact by ensuring that we create alternatives which are responsive to the diagnoses and the needs. And we haven't got that to the level that we need to ensure that we respond to that. I think that probably 100 years from now, we'll look back and say that everything was a health issue, not a criminal justice issue. We're going to look back and say, and people are going to look at us the way we now look at the fact that we used to burn people at the stake and stone them to death and thought that was a good response to things. I think that as we become more responsive with changing our legislation so that we can have more creative responses instead of just saying that we're going to lock people up, put them in solitary confinement, and those type of initiatives, which obviously are not working terribly well. So I'm delighted that we're providing more options within that framework, that we're giving the courts other options, that we're giving communities a chance to respond to the nuances and needs of youth as they come before the court system. So obviously, we have to maintain safety and ensure that our communities are safe, and there are some of those youths who are identified who are psychopathic and have behavioral issues to which we cannot manage adequately without having some type of confinement. And that is an important element of the approach that we take. We want to reduce incarceration for those people who are not representing risk to the well-being of our citizens. And that's an important part of the way that this modifications to the Youth Criminal Justice Act is leading us. It's leading us in a very progressive way, and in many ways, Canada has been a leader in looking at different models. There was a suggestion and a movement in the 1980s where moving towards total de-incarceration, moving to total community-based responses. Massachusetts led that. There were a number of deinstitutionalized models that happened in different pockets of Canada, and they were not successful. And they were not successful because they were not recognizing and identifying those youths who did constitute a risk to the community at large. And fortunately, this act allows us to hold on to that while developing the other parts of our system which have been shown to be so positive and which research is now supporting in a positive and meaningful way. Excuse me. Having the public more actively engaged in alternative measures has been an important part of that type of resolution. And so we have seen the development of a myriad of community-based models for responding to the types of needs that these youth present. And certainly this act provides, again, the opportunity for both Crown Council, for the police, and to be able to screen out at different points those who are at lower risk and don't constitute a need to be put into state-covered or state custody to be able to do that. So by modernizing and streamlining our system, we are responding more adequately and appropriately to the nuances and needs of our communities at large, and importantly to the nuances and needs of those youth who are in conflict with the law. And we're finding ways that respond to the research that allow us to provide the services that they need to become actively, positively engaged in our system and in our society. We have seen many successes of youths who were dramatically at risk, committing horrendous offenses, who are now very positive role models, who've changed dramatically. And you talk to them about their experiences, what they've been through, and their experiences are very revealing in terms of supporting what's happened in terms of the research we're seeing. Their experiences are saying when they made those connections with people who were meaningful, that had that relationship with them, that structured it for them and held them in a place of support, that they then started to see and become connected with people in a meaningful way. This legislation allows us great capacity to do that. It allows us the opportunity to ensure that we provide that support, but while maintaining the security and safety that we need for our communities, and at the same time being an empathetic, caring community and society that does respond to those needs. So I'm delighted to support Bill C-75 and the actions that it takes to ensure that we do have a safe, more compassionate, caring society, which I think is something that we all espouse. Thank you, Mr. Speaker.
Questions and comments. The honourable member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I thank the member for South Surrey White Rock. I want to ask him a question respecting hybridization and how that is going to make the court system, the justice system, more efficient. The effect of hybridization is that more offenses will be prosecuted by way of summary conviction. As a result, those cases are going to be downloaded onto provincial courts that deal with summary offense matters. 99.6% of cases are already before provincial courts. In addition to that, from the standpoint of Jordan, there's a 30-month timeline in Superior Court versus an 18-month timeline in provincial court before a delay is deemed presumptively unreasonable, upon which the case is at risk of being thrown out. So in addition to downloading cases onto provincial courts that are already overstretched and overburdened, I would submit that in fact it's going to increase the risk of more cases being thrown out.
Member for South Surrey White Rock.
Well, I'm sorry I missed the beginning of what you said because I didn't have but I think I caught the end of it in terms of your concern with respect to the downloading onto provincial courts and the potential for their meeting the timelines and then being thrown out of court. Certainly, this legislation, I don't think, contributes to that in any meaningful way. There are some responsibilities that the provincial courts have in terms of appointing enough judges to be able to respond to these needs. We have a number of alternative measures which would, as we develop the alternative measures which are evident within and supported within this act, we will be able to ensure that we also take a number of out of the streams that go into the court system and ensuring that those who are at greatest risk to our society are ones which are held within the court system. And we clearly have to have enough judges in place to respond to those. And I think we will reduce the impact on them by ensuring that alternative measures are developed in an active and positive way and community-based fashion.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member from South Surrey White Rock for his important contributions to today's debate. I want to highlight his work with youth and ask him to address, one, the Indigenous youth in British Columbia, and two, the racialized youth, particularly in the Surrey area, many of whom are of South Asian descent. What we are doing with this bill in terms of creating a model for a judicial referral hearing is taking administration of justice offences out of the criminal justice system. So if somebody breaches a curfew, breaches a bail condition, and forcing the court system and the courts to look comprehensively at the circumstances of the accused, including Indigenous youth and racialized youth. If I could ask the member opposite, the member from South Surrey White Rock, for his comments on how that will improve the circumstances of the very youth he has been working so hard for the last 25 years to defend and represent.
Honourable Member for South Surrey White Rock.
Well, thank you very much for that question and that observation. And clearly, our Indigenous youth have been overrepresented within our system, both in our youth justice system as well as in our child welfare system. Over 50% have been Indigenous youth, and certainly what we're seeing with youth gangs in the Surrey area and the challenges there, about 40% of them are represented from South Asian families. And we've been actively working with them in terms of being able to respond to them. So certainly the issue of administrative responses to that are crucial in terms of being able to ensure that we're intervening at the right level. We shouldn't be intervening with radical, dramatic action when we're starting out with people who are first starting to evidence some of the precursors to negative behaviors and negative activity. And so having administrative responses to that ensures that we be able to move those out of the system and respond to them adequately and appropriately. So I think that's one way that we will ensure that we will see some reduction in terms of what's happening within the impact of the court system. The other fashion is ensuring that we do respond to this in an appropriately sensitive manner.
We got time. Sorry to interrupt the honourable member. We have time just for one more short question and response, questions and comments. The honourable member for Whitby.
Thank you, Mr. Speaker. I'd like to thank my honourable colleague for his speech. We've heard throughout this debate that this particular legislation looks to increase the efficiencies of our Canadian, the criminal code, and to ensure that there is equity in the system. I'm wondering if the honourable colleague could expand on that and tell me what his constituents will think about him voting in favour of this particular bill.
The honourable member for South Surrey White Rock.
Thank you, and thank you for that question. I have had active dialogues with a number of communities, certainly with the First Nations and with the South Asian community. I've met with the leaders of 5 Gurdwaras in Surrey who are very concerned about the activity of South Asian youth and how they are overrepresented in some of the youth gang activities. They will be delighted with our ability, my ability to support this legislation because it gives an appropriate intervention point for both the Indigenous and the South Asians, which are overrepresented. It gives us a point where we can administratively respond to them in a positive, active fashion, where we've got a good opportunity to ensure that their lifestyle becomes much more positive and they can fit more actively into the lifestyle which their communities want and are so active to support. And we are giving them that option.
Before we go to resuming debate and the honourable member for Renfrew, Nipissing, Pembroke, I'll let her know that there are only about 5 minutes remaining in the time before we get to statements by members. Of course, she'll have her remaining time when we get next back to debate on the question that's before the House. Resuming debate, the honourable member for Renfrew, Nipissing, Pembroke.
Hear, hear.
Mr. Speaker, as the member of Parliament for Renfrew, Nipissing, Pembroke, in the heart of the beautiful Upper Ottawa Valley, I appreciate this limited opportunity to contribute to this truncated debate on a piece of legislation that's important to my constituents. I begin my comments by sharing some thoughts with a group called Because We'll Know, and why they say because. The rural community of Wilno is located in my riding of Renfrew, Nipissing, Pembroke, because on September 22nd, 2015, Carol Culleton, Anastasia Kuzik, and Natalie Warmerdam were killed in their homes near Wilno, Ontario. Because they were killed by a man they knew who had a history of domestic violence known to police for over 3 decades. Because even after violence is reported, people slip through the cracks in the system. Because advocates have been calling for these cracks to be addressed for decades. Because dealing with violence is particularly challenging in our rural communities. Because coercion and control of women is a spectrum that can begin with words and escalate towards lethal violence, including multiple killings. Because the culture of society, policing, and courts needs to be better. Because women continue to be killed in Canada at a rate of 1 every 6 days. Because we just couldn't sit around and do nothing. Because we think you can help. Thank you to Holly Campbell, who organized the group Because We'll Know. Violence against women is not new, and while I'd like to believe that in a predominantly rural riding like mine in Eastern Ontario, violence against women is a city problem, we know that it is not the case. Violence against women continues to be a fact of life in Canada and in a predominantly rural riding like Renfrew County. Carol Culleton, Natalie Warmerdam, and Anastasia Kuzik were killed on September 22, 2015. Their killer was known to all of the women and to police for a long history of violence that spanned over 3 decades. While he had been ordered by the court to attend counseling for abusers, he never went. He had been released from prison just shortly before the murders. The system failed these women. On average, in Canada, 1 woman is killed by her partner every 6 days. The man arrested and accused of their murders had a long criminal history, including charges involving 2 of the 3 women. Holly Campbell, who organized the group Because We'll Know, issued this statement to legislators like ourselves, quote, "For too long, Canadians have looked away from violence in our homes that predominantly harms women and children in every neighborhood, every district, municipal ward, and constituency in this country. End of quote. Like Holly, I'm not prepared to let Carol, Natalie, and Anastasia and all the other women who've been victims of violence die in vain. The memory of their senseless deaths is too fresh not to be moved to action. I support the proposal in C-75 that will increase the maximum term for imprisonment for repeat offenses involving intimate partner violence and provide that abuse of an intimate partner is an aggravating factor on sentencing, and for providing more onerous interim release requirements for offenses involving violence against an intimate partner. The Conservative Party believes, as I do, that the safety of Canadians should be the #1 priority of any government. We will always work to strengthen the Canadian justice criminal system rather than weaken it. Conservatives understand that a strong criminal justice system must always put the rights of victims and communities before the special treatment for perpetrators of violent crime. My question to the government is, does C-75 meet the expectations of Canadians in the other 300 pages of this omnibus bill? The fact that this government has decided to move forward with precisely the legislative format it condemned so vociferously in opposition suggests to my constituents and all Canadians that the contents of C-75 are being rushed forward in an omnibus bill precisely because it's out of touch with the concern of average Canadians.
The honourable member for Renfrew, Nipissing, Pembroke will have 5.5 minutes remaining in her time for her remarks and another 5 minutes for questions and comments, of course, when the House next resumes debate on the question. We'll now go to statements by members. Déclaration de député, the honourable member for Kelowna, Lake Country.
Mr. Speaker, I rise to acknowledge the passing of Joe Yafrancesco from Kelowna, British Columbia. A steadfast volunteer, Joe was well known for his dedicated service to our community. Joe gave back through many of the clubs he belonged to and was actively involved over the years in Rotary, Knights of Columbus, Lions, and was president of the Kelowna Italian Club. Joe also served as a member of Crime Stoppers, the Chamber of Commerce, the Downtown Kelowna Business Association, and the Uptown Rutland Business Association. To the end, Joe always put community before himself, and even in the final weeks, Joe and his wife Bianca made significant financial donations to both Joanna's House and the Cancer Care Fund at the Kelowna General Hospital. Mr. Speaker, Big Joe added big value to our community, and my thoughts and prayers go out to his family and friends. He will be missed. Hear, hear.
L'honorable député de Montmagny-Lillette, camarade.
The honourable member for Montmagny-Lillette. Mr. Speaker, today I'm going to be wearing a bow tie instead of a mustache. In my riding, they have offered me the chairmanship of Covember instead of Movember, and I have accepted. They've organized festive activities to talk about how to prevent health problems among men. Ticovember will be November 17th from noon to midnight. I thank the dance school in the region for having lent us its space. The money raised will be shared among various charities in Kamouraska and elsewhere. I hope that you are a good dancer, Mr. Speaker, because I would invite you and all parliamentarians to come and attend our dance marathon for charity.
The honourable member for Steveston, Richmond East.
Mr. Speaker, je prends la parole aujourd'hui afin d'affirmer.
Mr. Speaker, I rise today to assert my solidarity with the Jewish community in Richmond. I feel privileged to represent one of the most diverse ridings in Canada, and the Jewish community is an integral part of it.
Allowed me to share at a Shabbat dinner at Beth Tikva. I enjoyed having lunch with Rabbi Beidelman at the Chabad Seniors Luncheon, and I've had many great conversations with Mike Sachs and Rabbi Levi Vernai at the Bayat. I also want to thank Toby Rubin and everyone at the Kahila Society of Richmond for all the great work they do. And Mr. Speaker, I look forward to attending their upcoming Hanukkah lunch.
The honourable member for Dartmouth Cole Harbour.
Mr. Speaker, this Remembrance Day will mark 100 years since a brave young soldier, in the final moments before the armistice, lost his life, etching the name George Lawrence Price in the history books as the last Canadian and Commonwealth soldier to die in World War I. Price was a Nova Scotian boy, a farm labourer, and after moving to Saskatchewan, he was conscripted in 1917. About a year later, on the 10th of November, Price's battalion took part in an attack on the Belgian city of Mons, tasked with taking the canal. But on the morning of November 11th, only moments before the ceasefire, Price was shot in the chest by a German sniper, dying at 10:58. On this Remembrance Day, we remember the valor, the courage, and the sacrifice of soldiers like Price, who fought and gave their lives for our freedom. Mr. Speaker, please join me in honouring and remembering Nova Scotia's Private George Lawrence Price. Today and every day, we will remember them.
The Honourable Member for Abitibi, James Bay, Nunavik, EU.
We will be honouring all veterans on Remembrance Day. I want to salute them. I also want to pay tribute to those we sometimes forget, the Inuit, the Métis, and First Nations veterans. It is estimated, Mr. Speaker, that between 7,000 and 12,000 Indigenous people participated in 2 world wars, as well as the Korean War. For their sacrifice, they returned home only to continue to endure exclusion and injustice, serving in different battalions, regiments, sometimes as snipers or code talkers. Although there's much work to do, I want to honor them on this 25th Indigenous Veterans Day and extend our sincere miigwech for their invaluable contributions to this country. Mr. Speaker, lest we forget.
The Honourable Member for Bourassa. Mr. Speaker, Saturday, November 10th, 2018 is the 30th anniversary of the radio broadcast Samedi Midi on CKUT. For 30 years, without interruption, this show has presented a look at current events in Haiti and in Canada and has become a real presence in the media. Raymond Laurent, founder and host, with his imposing voice, has interviewed politicians from different levels of government. And on this occasion, I'd like to congratulate Raymond Laurent and his co-workers for their meaningful contribution to advocating for and integrating Haitian Canadians. Congratulations and happy 30th anniversary.
For Lanark, Frontenac, Kingston.
Mr. Speaker, 100 years ago, Canada's wartime aviators were household names. Billy Bishop, the highest scoring ace in the Royal Flying Corps, was Canadian. Raymond Collishaw, the highest scoring ace in the Royal Naval Air Service, was Canadian. So was Andrew McKeever, the highest scoring two-seater ace. So was Roy Brown, who shot down the Red Baron. So too was Alan McLeod, the pilot who became the youngest man ever to win the Victoria Cross. Canada contributed more to the war in the air than did any other allied country. 22,000 Canadians served in the air war. Our country produced 171 officially recognized flying aces, and of the top scoring aces of all countries on both sides, fully 1/4 were Canadian. Thousands more flew perilous artillery spotting missions, and the majority of these did not live to see the end of the war. Ours is a glorious and tragic history, and we owe it to these heroes never to let their memory lapse.
The Honourable Member for Louis-Hébert. Mr. Speaker, I'm proud to rise today to talk about and highlight the work of the Ambulance Cooperative in Quebec, which will celebrate its 30th anniversary. This co-op is the co-op that covers the greatest territory in Quebec. There are 400 members who work day after day to ensure paramedical services of high quality. They are recognized for their leadership and their standards which are above the norm. I'd like to thank them for their professionalism, their devotion, their integrity, and say on behalf of everyone in Louis Hébert, I hope that they go forward in the same way. I wish them many years of success, and I thank them for their work.
On that January night in 1958, as Willie O'Ree skated into history as the NHL's first black player, his family, friends, and fans back in Fredericton were cheering him on. On Monday, when he's finally inducted into the Hockey Hall of Fame, you can bet they will all be cheering again. Neither physical limitations nor racial taunts held Willie back in pursuing his goal. His journey is a story that continues to inspire us all. It is to our community's credit that color was not an issue when Willie was growing up as a kid playing on the neighborhood rinks by Charlotte Street. The fact that I was black never came up when we played as kids, said Willie. You could have been purple with a green stripe down the middle of your forehead, and it wouldn't have mattered a bit. It was only later that I learned what color barrier meant. Willie O'Ree knew that people would be staring at him that night at the old Montreal Forum. Nervous though he was, he chose to keep on skating, and Willie, we thank you for that. And as you like to say, if you think you can, you can. If you think you can't, you're right.
Here.
The Honourable Member for Beauport-Limoilou. Mr. Speaker, on November 11th, Canadians will gather to remember collectively the many ultimate sacrifices made by our ancestors and our contemporaries. They have died during the Great Wars, but also working for the UN as peacekeepers and in Afghanistan. Let us remember the hundreds of soldiers who died in Afghanistan. One of my constituents died in Afghanistan in 2009, and every year his brave parents lay a wreath on behalf of their son. So let us support them. Let us never forget the sacrifice that Jean-François Drouin made to defend our great confederation. Let us never forget him. The Honourable Member for Ville-Marie, le Sud-Ouest, Île-des-Sœurs.
Esatego ni wanizera gehado, negantangoa, aguego anska anti te wahuenuni non quanigunra, dano te yeti numerado, nedo non quehomwe, nene wahuntongaриage, ahatiatratne, neganaragoa, soltart goratne, yeti anontunyo, dano ci yeti yarak nene wahunterio, tanu wahuniheye, ci waterios goa. Te yeti numerado, tanu yeti sanakarata, nene wa onki heyase, negatiskana, I don't want to yunseke. Etoni otunhak, nun quanigunra, chile wehiarak.
The Honourable Member for Vimy. Mr. Speaker, on November 4th, I had the honour to join many Laval residents for the annual Armistice Parade organized by Branch 251 Chomedy of the Royal Canadian Legion in my riding. Every year, this is an opportunity for Canadians to honour the soldiers who yesterday and today served Canada and sacrificed everything for the defence of our country. We remember their bravery, we recognize their courage, and we pay tribute to the invaluable work they do for peace and security. This year also marks the 100th anniversary of the end of the First World War. I would like to thank from the bottom of my heart the soldiers who took part in it. Thanks to them, we now know peace. To our veterans, to our soldiers, and to all those brave Canadians, thank you. Lest we forget. Thank you, Mr. Speaker.
The Honourable Member for Yorkton Melville.
Speaker, this Remembrance Day, Canadians will honour the service and sacrifice of our veterans in the 100th year anniversary of the end of the Great War. Canada joined the war as a British colony and ended it as a united country. I had the honour to be in France this August to celebrate Canada's 100 days that led to the armistice. The Canadian Expeditionary Force did what no other nation could do, defeating 47 German divisions, representing a quarter of the German forces over those 100 days. I was proud to witness how our Canadian Armed Forces are respected worldwide for their dedication to freedom and peace. We live in the greatest country in the world by any measure. We have these blessings because, as it's been said in song, all gave some and some gave all. When our brave men and women return from their missions, we have a duty to care for the injured. Never are they asking for more than we can give.
Hear, hear. Hear, hear. The honourable member for Sydney Victoria.
Thank you, Mr. Speaker. This Remembrance Day will mark the 100 years since the end of World War I. I rise today to celebrate a town in my riding that has a unique place in the history of the end of the First World War. North Sydney became the first community in North America to celebrate the end of the war. On November 10, 1918, the Western Union Cable Office in North Sydney received a message that the war would end the following day. The message notified that peace was to be observed on the 11th hour of the 11th day of the 11th month of that year. A parade was formed, a concert was held, bonfires were lit, and celebrations continued far into the night. The town celebrated a day before the rest of North America even knew that there was a truce. In all this, North Sydney has been carved as a distinct position in the first community to celebrate the end of the World War. On this November 10th, the 100th anniversary of the date of the message that arrived in North Sydney, I look forward to joining Kate Brenners at the North Sydney Historical Society celebrating this one-of-a-kind piece of history.
Oh, well done.
The honourable member for Port Moody Coquitlam.
Each Remembrance Day, Canadians pause in a collective moment of silence to remember those who paid the ultimate sacrifice in service to our country. In that moment, we remember not only their sacrifice, but their commitment. We recognize our freedom, which they fought so hard to preserve, and we pay homage to their courage. As we mark the 100th anniversary of the end of the First World War and the end of the 65th anniversary of the Korean War, we pay tribute to each and every one of those who made the ultimate sacrifice, and we salute those who returned forever changed by their experience. We will always remember their selfless courage, lest we forget.
The honourable member for Barrie Innisfil.
When Canadians learned that 8-year-old Tory Stafford's killer was transferred to a healing lodge just 8 years into a 25-year sentence, they were rightly outraged. We heard that outrage from across the country on talk radio and newspaper columns. Anyone who heard this knew it was wrong for Tory's killer to be transferred. Instead of doing the right thing from the start, the Prime Minister and his ministers became indignant in their defense of the indefensible, putting the rights of criminals over those of their victims. They accused Canadians of politicizing the issue. They accused Canadians of being fearmongers. They hid behind privacy concerns and bureaucrats instead of having the fortitude to act and make the right decision. Tory's family spoke out. They held a protest right here on Parliament Hill. Canadians called on the government to intervene, and at the end of it, Canadians were right. The Liberals were wrong. We've learned today that instead of being surrounded by trees and children, Terry Lynn McClintock is back behind bars and razor wire where she belongs. Thank God Canadians spoke out. Mr. Speaker, Conservatives will always stand up for the rights of victims.
The honourable member for Halifax.
Mr. Speaker, Angus Gus Cameron is a veteran and a devoted veterans advocate in Halifax. Last year, Mr. Cameron came to me because he and fellow veterans were rightly disappointed that the then Conservative government had cancelled the Veterans Identification Card. To veterans across the country, that card was a symbol of a nation's gratitude, one that they could carry with them wherever they went, giving them access to the benefits that they had earned through their courageous service to Canada. It was an honour to partner with Gus and his fellow veterans to sponsor a petition to this House calling on our government to reinstate the Veterans ID Card. I'm proud to say that our government answered that call and reintroduced the Veterans Identification Card. I want to thank the Minister of Veterans Affairs and the Minister of National Defence for listening, acting quickly, and delivering for Gus and all of our veterans. In this Remembrance Day, let us never forget the tremendous debt of gratitude we owe our veterans. Thank you.
Questions orales, oral questions. L'honorable député de...
The Honourable Member for Louis Saint Laurent. Mr. Speaker, this morning 3,000 Canadians woke up with bad news. 3,000 workers at Bombardier, including 2,500 in Quebec, will be losing their jobs. Our thoughts are first and foremost with them. 2 years ago, you'll recall, Mr. Speaker, the Liberal government decided to loan Bombardier $375 million. Bombardier has 30 years to reimburse the loan, but there was no obligation to preserve jobs. So today, 3,000 people are losing their jobs. Can the Prime Minister tell us why he used taxpayers' money to give Bombardier a loan with no job conditions? Mr. Speaker, our thoughts are with the people affected by this morning's announcement. When we hear about job losses, it is of concern to us. Our government is committed to ensuring the long-term success of the aerospace sector, and we are working with the aerospace industry to improve access to the world market, the supply chain, for one of the most innovative industries in the country. The Honourable Member. Mr. Speaker, he should have thought of that 2 years ago when he lent to Bombardier $375 million in taxpayers' money. But at the same time now, the saga surrounding the member for Saint-Léonard is patently ridiculous. We've finally learned that he's going to step down when? January 22nd. Exactly 9 months minus a day prior to the next election. So there won't be a by-election, and as a result, the people for Saint-Léonard won't have a representative in the House until the next general election. Why is the Prime Minister playing with democracy? The Right Honourable Prime Minister. Mr. Speaker, the member in question has published a statement and has identified the files he is working on and on which he will continue to work to serve his community until January. The Honourable Member. Mr. Speaker, the Prime Minister is flouting democracy. 300,000 Canadians don't have an MP because he's refusing to hold by-elections, and now he's got it all staged so that the member for Saint-Léonard isn't stepping down. What the member said is that he had a special exemption from the Prime Minister. Can the Prime Minister inform Canadians why, in fact, he has a special mission that prevents him from coming to the House? The Honourable Prime Minister. The member in question has stated that he will be leaving his position in January. He has also shared the files he will be working on between now and then to serve his community. We expect that all members of the House work in the best interest of their constituents.
Is finally back behind bars where she belongs. Canadians were outraged that a child killer more than a decade away from parole eligibility was moved to a fenceless healing lodge. Each and every one of these Liberals voted against our motion that would have forced Tori's killer back behind bars, saying they didn't have the power to do the right thing. Will the Prime Minister apologize to Tori Stafford's family for forcing them to fight against him and his government to put Tori's killer back behind bars?
The Right Honourable Prime Minister. Mr. Speaker, our hearts go out to the family of Tori Stafford for the loss they endured. The Minister of Public Safety asked the Commissioner of the Correctional Service to review the transfer decision in question and their policies on offender transfers. Following that review, he has provided direction to improve transfer policies on medium security women offenders to facilities without a directly controlled perimeter. These changes will help ensure guilty parties are held accountable while fostering rehabilitation so we can have fewer repeat offenders, fewer victims, and ultimately safer communities.
For Chilliwack Hope. Well, Mr. Speaker, the Prime Minister has just admitted he had the power from day one to do the right thing and put Tori Stafford's killer behind bars. Instead, he hid behind bureaucrats. He hid behind the Minister of Public Safety when all along he had the power. He forced Tori Stafford Stafford's family to fight against the government to get justice for their murdered daughter. Will he apologize to them for making them come to Ottawa to fight against this government to do the right thing?
Right Honourable Prime Minister.
Mr. Speaker, I cannot even say how much our hearts go out to Tory Stafford's family. We understand, we hear their anguish. That is why the Minister of Public Corrections asked Public Safety asked Corrections Canada to review their policies and to ensure that they are changed going forward. That is exactly what happened, Mr. Speaker.
Honorable député de Rimouski.
The Honourable Member for Rimouski-Nejet-Témiscouata-les-Basques. Mr. Speaker, this morning Bombardier announced it would be laying off 2,500 employees in Quebec, and the leaders are coming out with the same old song, it's to save money. However, in 2017, the 6 executives gave themselves a 50% raise, bringing the amount up to $42 million, receiving hundreds of millions of dollars in public funding, lining the pockets. This is unacceptable, Mr. Speaker. How long will the government continue to pad the wallets of these business leaders instead of standing up for workers? The Right Honourable Prime Minister. Mr. Speaker, our thoughts go out to the families and the communities affected by this morning's announcement. We are always very concerned when we hear about potential job losses. Our government is committed to ensuring the viability and success for the long term of the Canadian aerospace industry. We will work with the aerospace industry to improve access to global markets for one of the most innovative industries in the country. The Honourable Member. Mr. Speaker, the Prime Minister should have ensured that this money wasn't going into the pockets of the leaders.
That it will cut 5,000 jobs. The company said these measures will result in savings of $250 million per year. But let me remind you of something. In February 2017, Ottawa loaned $372 million to Bombardier. And guess what? In March of that year, salaries of the top 6 leaders of the company increased by 50% to reach $42 million. Liberals could have made that loan conditional to no bonuses and job protection. Why didn't they?
Right Honourable Prime Minister.
Mr. Speaker, our hearts go out to the workers, their families, and the communities impacted by this morning's announcement. We're always concerned to learn about any possible job losses. Our government is committed to the long-term viability and success of the Canadian aerospace sector. We will work with the aerospace industry across Canada to improve access to global markets and supply chains for one of the most innovative and export-driven industries in the country.
Honourable Member for Essex.
Yesterday, the Prime Minister decided he will not take part in the signing of the USMCA alongside Donald Trump if tariffs are still in place. How exactly is this defending Canadian jobs? Is the Prime Minister so vain that he thinks depriving the U.S. of his presence from a photo op is the best trade strategy to get rid of the tariffs? But make no mistake, we're still signing it. He just doesn't want his picture doing it. And who can blame him? I wouldn't want my picture taken signing it either. These tariffs are killing jobs. Will this Prime Minister finally do the right thing and not sign the agreement until the tariffs are removed?
Right Honourable Prime Minister.
Mr. Speaker, I suggest the member from Essex pay attention to the region of Windsor, which is overwhelmingly happy that we have secured access to the United States for the coming years. But as I told the steel and aluminum workers on the floor of their plants, this government has their back. Canadian countermeasures will remain in place until the unfair tariffs on steel and aluminum are removed.
I want to remind the Honourable Member for Barrie Innisfil and others that the time to speak is when they have the floor. Whether that comes today or some other time, they have to wait for that. And keep in mind the standing order against interrupting. The Right Honourable Prime Minister.
Thank you, Mr. Speaker. During negotiations, our purpose has always remained to create the conditions to grow a stronger middle class and improve opportunities for Canadians. We will not stop working until these unfair tariffs are gone. It's what Canadian workers and their families expect, and it is what we will do.
The Honourable Member for Rosemont-la-Petite-Patrie. Mr. Speaker, thousands of jobs are at risk in steel and aluminum because of Mr. Donald Trump's tariffs. But no panic, the Prime Minister has a strategy. He's going to go and sulk in a corner. He's going to refuse to offer up his August presents to Cameras to sign the free trade agreement with, if you're not nice with me, no pictures, Mr. Trump. We can just see the guy shaking. Seriously. Does he think that we are going to be able to save jobs for aluminum workers who are here today by refusing to have his picture taken with them? Is that his strategy? The Right Honourable Prime Minister. Mr. Speaker, for 13 months we've been negotiating with Americans. We secured trade with the United States in an agreement, and I could point out the words, in fact, of the member for Rosemont La Petite Patrie, who said to the negotiators of the agreement, I just want to congratulate everyone in this room for the fantastic work that you have accomplished. He also added that the USMCA is the best agreement and it protects workers across the country. We will continue to defend workers in steel and aluminum and all workers across the country.
Honourable member for Thornhill. Order.
Mr. Speaker, we learned today that the Liberals not only misled this House, but misled the Privacy Commissioner to believe that the deepest personal financial information of only 500,000 Canadians would be seized without consent by Statistics Canada. We know now that it's 500,000 households, that almost 1.5 million Canadians' data will be captured. Mr. Speaker, did the Liberals try to hide the true scope of this project because they knew Canadians would be quite rightly appalled?
Honourable Minister of Innovation.
Mr. Speaker, the Chief Statistician has been absolutely transparent and clear with Canadians. When this question was posed, the Chief Statistician made it very clear that this information was part of a pilot project, and he was very forthcoming with his answers. Again, I want to highlight, no personal information will be disclosed. All that will be removed, Mr. Speaker. Again, the members opposite have a fundamental problem with Statistics Canada, and the Chief Statistician is disappointed to see that they haven't learned the lessons from 2015.
Honourable member for Thornhill. Order.
Mr. Speaker, Anne Cavoukian, the former Ontario Privacy Commissioner, says it's time Statistics Canada realized it's no longer the same world as when the Statistics Act was first enacted. Dr. Cavoukian says when our sensitive financial data is disclosed by our banks to the government without our consent and then housed at Shared Services Canada, you can bet we have something to worry about. Mr. Speaker, why won't the Liberals listen when a privacy expert like Anne Cavoukian says, stop this totally unacceptable practice?
Honourable Minister of Innovation.
Mr. Speaker, we have clear laws under place when it comes to protecting the privacy and data of Canadians. Section 17(1) of the Statistics Act is very clear. No policing service, RCMP, CRA, government agencies, the courts, even the Prime Minister can compel Statistics Canada for any personal information. There are provisions in place to protect privacy and data, Mr. Speaker. The members opposite should read the laws.
Honorable député de Montmagny.
The Honourable Member for Montmagny-Lille, Kamouraska, Rivière-du-Loup. Mr. Speaker, the Liberals have boasted loudly and clearly about invading the privacy of a million Canadians by capturing their personal financial data without their consent, to such an extent that the Commissioner of Privacy had launched an investigation. Mr. Speaker, it's like me coming to your house, breaking down the door, and once I'm inside the living room, asking for permission to come in. That's exactly what they're doing. With 20,000 signatures on a petition in just a week, Canadians have shown they're clearly opposed to this intrusion into their private lives. What's the government waiting for to put an end to this practice, Mr. Speaker? The Honourable Minister. Mr. Speaker, I don't agree with my colleague because our government takes the privacy of Canadians very seriously. Let's be clear. This is a pilot project. No data has been collected to date. No data has been collected, Mr. Speaker. The Chief Statistician has stated that the project would go ahead only once the concerns of Canadians have been dealt with. Thank you, Mr. Speaker. The Honourable Member for Beauport, de Beaupré, Île d'Orléans, Charlevoix. Mr. Speaker, in light of what the Minister just said, it might be a good idea to pull the plug on the project because Canadians are very concerned. They're so concerned about the government digging into their personal financial data without their consent. That's intrusion, an intrusion into Canadians' privacy. When will this government do what's best for Canadians, who they claim to listen to, and stop this project. The Honourable Minister. Mr. Speaker, let's talk about the facts. Personal information will be removed. Canadians can rest assured that their banking information will remain protected and private. Statistics Canada can absolutely not share that information. No. People, government, nor the Prime Minister will have access. The privacy of Canadians will be protected.
Mr. Speaker, the government's plan to collect personal, private financial information from Canadians gets more disturbing every day. Yesterday, we learned that despite previous statements, the number of affected Canadians every year won't be 500,000, but will easily be 1 million or more. They just won't say, Mr. Speaker. At this rate, it won't be long before every single Canadian is tracked. Now that we know that the true scope of this project is much larger, will the Liberals finally end this surveillance scheme, Mr. Speaker?
The Honourable Minister of Innovation.
Again, Mr. Speaker, this over-the-top rhetoric, surveillance scheme, is completely inappropriate and unacceptable. Let me be very clear. When it comes to Statistics Canada, the Chief Statistician has been very clear. He will only proceed if he gets assurances and the support from the Privacy Commissioner, which he proactively engaged to deal with the issues around privacy and data protection. Mr. Speaker, the members opposite have been fear-mongering, over-the-top rhetoric to mislead Canadians. Enough is enough. Let's support Statistics Canada, and let's support good quality, reliable data.
The Honourable Member for Central Okanagan, Similkameen Nicholas.
Speaker, the Privacy Commissioner said today at the Senate committee that he was awestruck by the revelation of the amount of Canadians that will be under surveillance. That is ridiculous to say you're working with them. We also learned yesterday that despite promises to anonymize the data, Liberals will actually keep all the private information and have the ability to access it at any time. The government will be able to check every transaction and tie it to every individual. So now the scope is increased and their plans to anonymize the data are gone. Will the government finally put Canadians first and stop tracking their finances without their knowledge or consent?
Honourable Minister of Innovation.
Mr. Speaker, let's stick to the facts, because one falsehood after another falsehood after another falsehood is what is misleading Canadians, what the member opposite is doing. No personal data will be disclosed. All of that will be removed. All personal information that the members are talking about by the banks will be disclosed to its clients. No breaches with Statistics Canada server has occurred. And proactively, the Statistics Canada's agency has proactively engaged with the Privacy Commissioner. And as I've mentioned, under Section 17.1, no government, either Conservative, Liberal, I didn't mention the other party, nor Liberal or Conservative government can compel Statistics Canada, Mr. Speaker.
The Honourable Member for Jonquière. Mr. Speaker, the Liberals refuse to amend the Bankruptcy Act, and workers always end up with crumbs. Workers at Sears Canada spent their lives working and contributing to their pensions. Shareholders at Sears received $509 million. And what did the company give workers? Nothing. The most vulnerable are the ones paying the price once again. What is the government waiting for to change the Act and put an end to this kind of pension theft? The Honourable Minister of Innovation.
Difficult this is for the workers at Sears and the pensioners. Our government has been very clear about supporting pensioners. We brought in the Wage Earner Protection Program. We've also strengthened the Canadian Pension Plan as well, Mr. Speaker. In the last budget, we've indicated a desire to work through a whole-of-government approach to make sure we provide additional security measures for pensioners. With respect to this particular issue that the member opposite has raised, the CCAA process has made it very clear that there are some issues, and the fact that they are addressing these issues the monitor has put forward indicates that the process is working.
Honourable Member for Hamilton Mountain.
So we're talking about pension theft, not about CPP. Mr. Speaker, today we learned that the owners of Sears Canada are being sued in the hopes of recovering millions of dollars paid to investors while the company was in financial ruins. This is the same kind of corporate theft I was asking the Seniors Minister about last week when she accused me of providing misinformation. The Minister said consultations have and will continue to take place, yet we have not heard anything about these promised consultations. Who is misleading who? Will the Seniors Minister release a list today of all the people she has consulted and a schedule for the formal consultations promised in the budget?
Honourable Minister of Seniors.
Mr. Speaker, let me make it very clear that consultations have been taking place. That is a commitment we made in our 2018 budget, and it has been reaffirmed by the Prime Minister in his mandate letter to me. The consultations are taking place because this is a very difficult issue, and we want an evidence-based solution, which is why these consultations are necessary. We have the interests of pensioners at heart, and we are going to work hard to find the solution that's right for pensioners that doesn't have unintended consequences for them. We're going to work hard to get the right solution, Mr. Speaker.
Honourable member for Carleton.
Well, yesterday the Prime Minister refused to tell us whether the GST and HST would apply on the carbon tax. So I dug up the documents directly from the Canada Revenue Agency, which indicate that consideration payable for the supply of the gasoline upon which the supplier will calculate HST does include the carbon tax. So now we know there will be a tax on a tax. Based on these calculations of 13% in the province of Ontario, how much will Ontario taxpayers spend in a tax on the tax?
The Honourable Parliamentary Secretary to the Minister of Environment.
Speaker, let me begin by expressing my condolences to the honourable member from being left off the cover of Maclean's magazine alongside his colleagues from yesterday. What the honourable member is trying to do with this question is trying to trick Canadians into believing that life will be made more expensive under our plan. That is simply not true, Mr. Speaker. We're moving forward with putting a price on pollution that's actually going to make life more affordable for Canadians. Mr. Speaker, that collection of miscellaneous Conservative politicians labeled themselves the resistance on the cover of that magazine yesterday. From where I sit, all they seem to be resisting is progress on social and environmental issues.
Order. The Honourable Member for Carleton.
Mr. Speaker, through you directly to President Donald Trump. This government may have backed down to you on Buy America, on softwood lumber, and on so much more. But I will have you know that if you do not back down on your steel tariffs, this Prime Minister will deny you a photo op. Okay? My question for the government, will he go further and say he will not appear on the cover of a U.S. magazine until these tariffs are gone?
Order. I think I'll just speak to colleagues here when I can get their attention. Order. It is good to see the House in a good mood, of course. Order. Now, of course, the purpose for the rule that says you can't say you in here unless you're speaking to the Speaker is, of course, about not talking to someone on the other side and saying you, right? And therefore, I guess that's a bit different. It's unorthodox, but I'm going to allow that in this. Okay. The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. I'm not sure how I can top that, but why don't we actually listen to a Conservative who knows what he's talking about when it comes to trade. Let me quote former Prime Minister Brian Mulroney, who said, "This agreement is a highly significant achievement for Canada. Canada appears to have achieved most, if not all, of its important objectives in this lengthy and challenging set of negotiations." Thank you, Mr. Speaker.
Honourable Member for Carleton.
Mr. Speaker, I report as well that the President has tweeted out a point of order, and you'll have to rule on it after a question period. But back to the issue of the HST, Mr. Speaker. The government will collect $720 million of HST on the carbon tax, according to a basic calculation of that tax to the planned price on carbon use by Canadians. So the question is very simple. Were those numbers included in the calculation of the cost to the average family of this tax?
Honourable Parliamentary Secretary to the Minister of Environment.
Again, Mr. Speaker, the Conservative Party's strategy seems to be to mislead Canadians on the cost to families. What we actually do know, Mr. Speaker, is that when we move forward to protect the environment by putting a price on pollution, we're actually going to leave middle-class families better off at the end of the year. Mr. Speaker, I look forward with great anticipation to the next campaign when the Conservatives campaign on a commitment to take money from their constituents so they can make pollution free again.
The honourable member for Carleton.
But that is exactly his policy. The government is proposing to take money away from all of our constituents when they commit the crime of filling up their gas tank to drive to work or heating their home in minus 40-degree weather, while they make pollution absolutely free to large industrial corporations that emit more than 50,000 tons of greenhouse gases. And then at the same time, they claim that they can take $10 in taxes for every $9 in rebates, and somehow taxpayers will be better off. Well, they drop the phony math and tell us how much the average family will spend paying the tax on the tax.
The Honourable Parliamentary Secretary.
Mr. Speaker, over the last number of weeks, I've watched the honourable member spin tales. He's suggested that large polluters are exempt. He suggested small businesses will be stuck with the bill. He suggested that families will be worse off. These are all falsehoods, Mr. Speaker. We are moving forward with a plan that's going to make big polluters pay. We're going to give small businesses the tools they need to succeed, and we're going to make life more affordable with Canadians. Mr. Speaker, if the honourable member has the courage to ask one more question based on facts instead of falsehoods, I'd be pleased to give him an honest answer. If he comes again with these falsehoods and underlying assumptions that can't be proven, I'd be pleased to dress him down one more time.
Order. The Honourable Member for Hochelaga. Mr. Speaker, the opioid crisis is so serious that life expectancy in Canada could actually go down. It would be the first time that that's happened in decades. Even President Trump has called it a national crisis in the U.S. The longer the Liberals wait to act, the worse the situation gets here at home. When will the Prime Minister implement a national strategy to fight the opioid crisis?
Ministre de la Santé.
The Honourable Minister of Health. Thank you, Mr. Speaker. We are facing a tragic crisis. We've lost thousands of Canadians in the last few years, and it's simply tragic. Our government continues to work with provinces and territories, and in Budget 2018, we invested $230 million. First, to ensure that there will be more services on the ground, and also to ensure that we will have a public awareness campaign about stigmatization, because often Canadians don't get the services they need because of stigmatization. Thank you.
Honourable Member for Vancouver East.
For the first time in decades, life expectancy in Canada could decrease because of the ongoing opioid crisis. Canada is the second largest user of opioids behind the U.S. Purdue Pharma was guilty of misleading the public and downplaying the risk of addiction and was forced to pay $830 million. It's time for the Prime Minister to stand up to Big Pharma and seek justice for families. Will he launch a criminal investigation into opioid manufacturers and seek compensation for costs of addressing the opioid crisis?
Honourable Minister of Health.
Mr. Speaker, we are in a national public health crisis when it comes to the opioid situation, and we are deeply troubled with the numbers of Canadians, the numbers of loss of life that we've seen. In Budget 2018, I'm pleased to say that we invested over $230 million. $150 million of that is to provide emergency treatment for people on the ground. And finally, investments are made to put in place an anti-stigma campaign, as we recognize that many individuals do not receive the treatment they need because of the stigma that exists. Thank you, Mr. Speaker.
The Honourable Member for Ottawa-Vanier. Mr. Speaker, Canadians know that diversity is a strength, and linguistic duality in Canada is at the heart of who we are. Francophone and Acadian communities are facing demographic challenges, and we know that immigration plays an essential role in developing the vitality of these languages, including right here in Ottawa-Vanier. We have set up ambitious Francophone immigration targets outside of Quebec between now and 2023, and we're working hard to meet those targets. Can the Minister update this House on the progress that's been made? The Honourable Minister of Immigration. I thank the member for her question. Our government is taking historic measures to attract new Francophone immigrants. Yesterday, I had the pleasure of announcing $11 million that will go to help Francophone immigrants prepare for their new life in Canada. There will be new services to help them as well. And we are making French language testing more accessible and affordable. We need to understand the importance of Francophone immigration.
Honourable member for Battle River Crowfoot.
Mr. Speaker, those who served our country deserve our utmost respect, gratitude, and support. However, complaint after complaint rolls in about this Liberal government's neglect of veterans and their needs. My constituent writes, I am a military veteran. In mid-April, Veteran Affairs Canada received all my documents for reassessment of my disability, and yet almost 6 months later, I still await a decision. And I have no way of knowing whether a decision is 2 months away or a year away. Wow. Mr. Speaker, why the wait? Why does this government continue to fail our veterans?
The Honourable Parliamentary Secretary to the Minister of Veterans Affairs. Thank you, Mr. Speaker. We know that we can and should improve service deadlines. We've hired more than 460 new frontline officers. We've also reopened 11 centres that the Conservatives closed. We've also set up centres for mental health and worked with 4,000 professionals. There's a lot of work to be done, but we will do it, Mr. Speaker.
Member for Renfrew, Nipissing, Pembroke.
Mr. Speaker, this government gave $10 million to a convicted terrorist who built bombs in Afghanistan, but the veterans who were blown up in bomb attacks are denied the critical injury benefit. This government promised that they'd stop taking veterans to court, but they're still doing it. They promised to bring back the pension for life, and they broke that promise too. The consequences of these failures? A 3-tiered care system for veterans. Why is the government treating our veterans this way?
Here, here. Honourable Parliamentary Secretary to the Minister of Veterans Affairs.
Thank you, Mr. Speaker. The well-being and financial security of our veterans is our top priority. We have invested $10 billion of new money in veterans. We are not cutting corners, Mr. Speaker. We estimate that more veterans will choose monthly tax-free lifetime payments rather than the lump sum payment. So this way, the budget is spread out over a longer period. The Honourable Member for Beauport-Limoilou. Mr. Speaker, it's not just a question of investments. Beyond the broken promises that the government made to veterans, there's a problem of red tape and a lack of respect in the department for our brave men and women in uniform. Now, there are people who have to prove every single year over and over that they were injured in Afghanistan. Is that normal? Having our veterans have to continue to fight here? Will the Prime Minister commit today to reducing red tape and all of the rules within the department? The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. Indeed, it's by investing money that we can solve some of these problems, including the lifetime disability benefit. We have delivered with the new lifetime benefit, and veterans ask themselves for monthly payments rather than a lump sum payment. This plan will provide compensation for pain and suffering, as well as an income replacement. We've made significant changes, Mr. Speaker. We know we have a lot of work to do, but we will deliver the goods.
Member for Yorkton Melville.
Speaker, this Prime Minister claims to be a feminist. Yet female veterans will receive less each month in pain and suffering payments than males because sex is a factor of life expectancy. Veterans Affairs' mandate is to compensate all members of our Canadian forces equally. The Minister is discriminating against women who have served this country. Hear, hear. Did the Prime Minister instruct the Minister to complete a gender-based analysis on the new pension scheme?
The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. We're committed to protecting the well-being of all veterans with no exceptions. Both female and male veterans will receive more under our new plan. Veterans who present a new request as of April 1st, whether they're men or women, will receive exactly the same pain and suffering benefit, and we will always be there to support women veterans. The Honourable Member for Salaberry-sur-Roi. Mr. Speaker, Canada Post's bargaining tactics with its unions are shameful. They're attacking the most vulnerable. They're cutting short-term disability benefits, long-term benefits, and maternity benefits. And despite these aggressions, the Liberals are continuing to trust Canada Post. The Prime Minister said that if this isn't solved soon, all options are on the table. What does that mean? Back-to-work legislation? What will the Liberals say to justify the fact that they are abandoning workers? The Honourable Minister of Labour.
And small businesses rely on Canada Post, especially at this time of year. We've been working with the parties. We respect and have faith in the bargaining process, and we urge parties to work together to get a good deal. If the parties are unable to achieve a negotiated deal together, very soon we will use all options to find a solution to reduce the impacts to Canadians, businesses, Canada Post, and their workers. Thank you, Mr. Speaker.
Member for Elmwood-Transcona.
Mr. Speaker, if they believe in the bargaining process, they should not be threatening back-to-work legislation. They shouldn't be targeting sick and vulnerable workers. We know that the minister has the ability to call up Canada Post and tell them to stop. We're about to go home to our constituencies for a week, and when we come back, it'll have been a month that these workers have gone without pay. So will the minister pick up the phone today and do something about it, or resign and make way for somebody who has the compassion and the backbone to do it?
The Honourable Parliamentary Secretary to the Minister of Public Service.
Happily, Mr. Speaker, the NDP have never been afforded the opportunity to manage vast sectors of our economy, but we understand that work disruption is having on our employees and their families, and that is why our government has been encouraging both parties to reach a fair agreement as soon as possible. Unfortunately, when a strike occurs, the expiry of collective agreements affects some of the supplemental benefits available to employees through Canada Post. But rest assured, Mr. Speaker, employees maintain full access to employment insurance, other important benefits, including maternity and parental benefits. Canada Post management is accepting requests.
Honourable Member for Oshawa. Order.
Mr. Speaker, this week the Prime Minister stood his ground and told Donald Trump that he won't be attending the signing ceremony of the new NAFTA because steel and aluminum tariffs are still in place. Mr. Speaker, we know how difficult it can be for this Prime Minister to miss a photo op. Acting like a tough guy now is too little too late for the steel and aluminum workers who can't make ends meet on this Prime Minister's empty gestures. Why didn't the Prime Minister show some backbone when it actually mattered?
Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Mr. Speaker, I'd like to point out to the honourable member that we've added 700,000 jobs to the economy since 2015. Vis-a-vis the steel and aluminum, we are taking action, and we have taken action to prevent the diversion and dumping of unfairly priced foreign steel. We've added $2 billion to help the workers in those factories affected. We've consulted widely on possible trade remedies and measures. We've heard from the interested stakeholders and shareholders, and we're considering options as we move ahead. Mr. Speaker, USMCA is a good deal for Canada, and we're proud that we achieved it. Thank you.
Honorable.
The Honourable Member for Mégantic-L'Érable. Well, they must be proud of the deal, Mr. Speaker. But the Prime Minister will not be attending the signature. There won't be a photo op with Mr. Trump. That's the reality. That's the Liberals' secret weapon, Mr. Speaker, to ensure that they're going to protect Canadian steel and aluminum workers. The Prime Minister will not be there for the photo op. Mr. Speaker, why is the Prime Minister so afraid of a photo with Donald Trump, and why doesn't he stand up to Donald Trump to defend steel and aluminum workers? The Honourable Parliamentary Secretary. Mr. Speaker, to start, I want to make sure that everyone is clear that we added more than 700,000 good jobs since 2015. We are working very hard and very successfully to protect the steel and aluminum industries here in Canada.
For Battle River Crowfoot seems to forget that the time to speak is when he has the floor. He seems to think he doesn't need to have the floor in order to speak. And, of course, the danger of that is that he might not have it for quite a while. All right? The Honourable Parliamentary Secretary has the floor.
Monsieur le Président, si vous voulez.
Mr. Speaker, if you want to continue with my colleague across the way, I'd be fine with that. No? Oh, thank you. Well, Mr. Speaker, we have made $2 billion available to defend and protect the interests of these industries in Canada. We also have targeted compensation for manufacturers who are facing exceptional circumstances. Thank you. The Honourable Member for Pellon-Jacques-Cartier. Thank you, Mr. Speaker. Everyone knows that there is a labour shortage and that we need to take action quickly. I've had a number of meetings to move forward on a file with a group of entrepreneurs who are ready to act and invest to resolve this labour shortage. But the file has been blocked at the Labour Department. We need to support our regions and businesses so that they can remain competitive. I encourage the Prime Minister to give some instruction to the Minister of Labour to authorize the pilot project. When will the Liberals act, Mr. Speaker?
Minister of Employment.
Mr. Speaker, the member opposite's right. We have one of the fastest growing economies in the G7, the lowest rate of unemployment since the 70s, and this brings new challenges. And I know that certain regions across the country are struggling with finding good, talented people. So as I've said before, we are working extremely hard to make sure that every Canadian has the skills they need to take advantage of these job opportunities. I continue to hear from employers across the country, however, including Quebec, that a robust immigration system is key to solving some of these problems. So, Mr. Speaker, we're going to continue to invest in skills and training programs and ensure that every Canadian...
The Honourable Member for Mississauga-Streetsville.
Mr. Speaker, constituents in my riding have identified gun and gang violence as a significant public safety issue, which must be urgently addressed. Last November, the Minister of Public Safety and Emergency Preparedness announced funding that would help support a variety of initiatives to reduce gun crime and criminal gang activities. Can the Parliamentary Secretary to the Minister of Border Security and Organized Crime Reduction kindly update this House on our government's efforts to reduce gun and organized crime across the country?
Honourable Parliamentary Secretary.
Mr. Speaker, I'd like to thank my colleague from Mississauga-Streetsville for his question and his tireless advocacy on this issue. The safety and security of Canadians are top priorities for our government, and today we announced an investment of $86 million to help stem the flow of illegal firearms into Canada and providing necessary equipment and technology to both the CBSA and the RCMP. We're listening to the concerns of Canadians while the Conservatives want to weaken firearms laws without consultation. Canadians can continue to have tremendous confidence in the work carried out by these agencies, and we will continue to work with them to bolster prevention and enforcement programming. Thank you, Mr. Speaker.
The Honourable Member for Chicoutimi-Le-Fjord. Mr. Speaker, the Privy Council has revealed that 73 people were aware of the Liberal Cabinet's secrets around the decision to delay the execution of the shipbuilding contract given to the Davie Shipyard. We know that many ministers have either a real or perceived conflict of interest in this file. Once again, the Prime Minister has chosen not to provide the information. Who are the 73 people who are aware of this? Or at the very least, what are the names of the Liberal members involved?
Mr. Speaker, the Department of Public Prosecutions is in charge of the prosecution in this case. The defense has obviously very eminent defense counsel. I haven't seen any indication anywhere where the honourable gentleman opposite has been engaged to represent the parties in a legal dispute before the courts. The courts are seized of this matter. The representations will be made in courts. An independent judge will make the decision.
The Honourable Member for Saint-Hyacinthe-Bagotte. Mr. Speaker, the employment insurance system has many shortcomings, including the black hole or spring gap, and a mere 15 weeks for sickness benefits, and the selection criteria for EI are sexist. Many women do precarious work, making them ineligible for EI benefits. Only 1/3 of unemployed women are eligible, compared to half of unemployed men. Is that normal? When will this so-called feminist government finally open its eyes and reform this outdated, discriminatory, and sexist employment insurance system?
The Honourable Parliamentary Secretary.
I'd like to assure the members that EI reform is an ongoing process with this government. We have made EI more accessible, working well on benefit more easy. We've also speeded up the way in which claims are processed, and therefore the dollars are arriving in families' homes much quicker. EI reform is fundamental to making sure that workers get the support they need as they transition in a very volatile economy. But the best news is the 700,000 jobs we've created, which makes EI less and less important. On the issue that she raised, that is an important issue, and we are seized of it, and we're reporting back to the House with developments as soon as we can.
Honourable member for Perth Wellington.
Mr. Speaker, farmers across southern Ontario are facing high levels of vomitoxin in this year's corn crop, making it unusable as livestock feed or for ethanol. This means contracts risk being unfilled, increased costs and delays for testing, and significant cost flow issues caused by lack of storage for crops and lack of alternative markets for this corn. Why has the Minister of Agriculture failed to address the concerns of Canadian farmers?
The Honourable Parliamentary Secretary for Agriculture. Mr. Speaker, we have programs that are intended to meet the needs of Western farmers and farmers all across Canada. We'll be working with our provincial counterparts to solve the problem. Thank you. The Honourable Member for Montcalm. Mr. Speaker, last night this House voted against the principle of letting Quebec choose its own approach for integrating immigrants. There are three non-negotiable principles on which the Quebec nation is founded: gender equality, separation of church and state, and the French language. All three of these are missing from the policy on multiculturalism. Why is the government refusing to let Quebec set its own rules about how its citizens should live together? The Honourable Minister of Immigration. Immigrants play an important role in the economy and in the country.
System is key to attracting the best and the brightest talent from around the world, which is followed by investment. We will not opine, of course, on specific proposals in the context of an election, but at the same time, we'll continue to work with the province of Quebec to build on the great record of collaboration that we've had with the government of Quebec. In fact, I met just this week with my new counterpart from Quebec, and we had a great meeting, and we committed to continue to work.
The Honourable Member for Montcalm. Mr. Speaker, the House of Commons claims to recognize Quebec as a nation, but when that actually means taking action, Ottawa refuses to do so. They say no to promoting the French language, no to our environmental sovereignty, no to letting us decide how we should live together. Will the Prime Minister admit that his recognition of Quebec as a nation means nothing at all? It's just a smokescreen. The Honourable Minister of Heritage. Mr. Speaker, here, the Bloc Québécois is trying to divide us once again and to bring us back into these old disputes. I find that surprising because I thought they had understood the importance of unity because they reunited. Now, Canadians share common values all across the country, and we don't have any lessons to take from the Bloc Québécois. We will be working for all Quebecers and Canadians. The Honourable Member for Joliette. Yes, Mr. Speaker, Irving seems to have a bad case of jealousy. As soon as Ottawa turns its head to look at another shipyard, Irving throws a jealous fit, and the government has to offer them gifts to be forgiven. So the government's given Irving a new $800 million contract for a useless mud breaker so that Irving's work list will stay full. Meanwhile, there are only 60 employees left at the Davie Shipyard, and the federal government has given them nothing but peanuts and will do so until 2021. When will the Davie get the Obelix contract? The Honourable Parliamentary Secretary. Mr. Speaker, the Government of Canada has always tried to find opportunities for the Davie Shipyard within its shipbuilding strategy. We care about the Davie Shipyard workers' expertise. And in fact, I myself went there to announce a $610 million contract for the purchase of 3 icebreakers. And on November 1st of this year, Mr. Speaker, we announced our intention to have a maintenance contract worth $7 million to 3 shipyards, including the Davie Shipyard. The Honourable Member for Joliette. That's still just 2% of the total contracts, which is peanuts. Now, we know that there's no real difference between the Conservatives and Liberals. They are both the lackeys and errand boys of Irving. Only Irving gets money to protect its forests against the spruce budworm. Irving pushes for the revival of the Energy East pipeline so that it can fill its pockets while polluting the earth. Irving has accumulated so many federal contracts that it's behind schedule. When will the Liberal government stop giving everything to this corporate behemoth and finally give some real contracts to the Davie Shipyard? The Honourable Parliamentary Secretary. Well, here's the best example that the Liberals and Conservatives are not the same. The Conservatives gave no contracts to the Davie Shipyard, and the Liberals have given them big contracts.
Hello.
Order. The Honourable Member for Repentigny is rising on a point of order.
Monsieur le Président, alors comme il y a...
Yes, Mr. Speaker.
Since there has been a significant increase in rail accidents in Canada, I'm sure that I will receive unanimity for the following motion that the National Transportation Safety Board reverse its position and maintain the monitoring of the transport of flammable liquids such as gas and the type of gas which led to the accident at Lac Mégantic as is being asked for by the Quebec Federation of Municipalities. Is there unanimous consent? No, there is no unanimous consent. Thanks. I wonder whether my colleague has anything to say about the major cuts in media newsrooms. That is a question of debate.
The usual Thursday question.
Merci, Monsieur le Président. Monsieur le Président.
Thank you, Mr. Speaker. Mr. Speaker, the government will explain what work is coming up in the House after the break week.
Mr. Speaker, I'm sure colleagues were looking forward to the chance when I could answer the Thursday question again. So good news, Mr. Speaker, you're about to see it.
Mr. Speaker, this afternoon we will continue our debate at report stage of Bill C-75 to modernize our criminal justice system tomorrow, pursuant to the order adopted on September 21st last. The House, as my colleague indicated, will not be sitting, so members may stay in their ridings for Remembrance Day. Next week will be dedicated, again, as my colleague indicated, will be dedicated to helping our constituents. Mr. Speaker.
November 19th, we shall have an allotted day. On Tuesday, we will resume debate at report stage of Bill C-75, the Justice Modernization Bill. And finally, Mr. Speaker, I know all Canadians are looking forward to Wednesday because the Minister of Finance will deliver his fall economic statement. And Mr. Speaker, while I'm on my feet, I think you will find unanimous consent, as there has been obviously discussions amongst the parties. I hope you'll find unanimous consent for the following motion: that notwithstanding any standing order or usual practice of the House, at 4 p.m. on Wednesday, November 21st, 2018, the Speaker shall interrupt the proceedings to revert back to statements by ministers to permit the Minister of Finance to make a statement. After the statement, a member from each recognized opposition party, a member of the Bloc Québécois, and the member for Saanich Gulf Islands may reply. After each member has replied, or when no member rises to speak, whichever comes first, the House shall proceed to the taking of any recorded divisions deferred to the end of government orders or to immediately before the time provided for private members' business, and then proceed to the consideration of private members' business. Mr. Speaker, I think it was quite clear. If you'd like, I could repeat the whole thing again, or would that be...
That's very kind of the Honourable Minister of Intergovernmental Affairs to offer that, but I think probably the members would prefer to pass on that kind offer. Does the Honourable Minister have the unanimous consent of the House to propose the motion? Agreed. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Adopted. Before I rule on a point of order, I wonder if members would permit me to say how nice it is to have teachers here from across the country visiting us this week at the Teachers Institute. One member has just said that if he knew there were teachers here, he would have been a lot more quiet. Well, I should have mentioned it earlier, obviously. I am now prepared to rule on the point of order raised on October 29, 2018 by the Honourable Member for Haldimand-Norfolk concerning the right of all Canadians to petition Parliament. I would like to thank the member for having raised the matter. Lors de son intervention,
During her intervention, the member for Haldimand-Norfolk explained that a paper petition that she received from constituents was not certified, a requirement before presenting it in the House. The objection was that the paper was not the usual size. The current practice is that the petition should be legal or letter size. She noted that the petition was on ledger-sized paper, specifically to accommodate the signatories, each of whom have some degree of visual impairment, and that the petition itself seeks to amend the rule of the House, Standing Order 3611C, dealing with this requirement for paper of usual size. This rule, she finds, denies some fair and reasonable access to the paper petitions process.
she raised this subject a year ago, on October 24, 2017. At the time, I suggested that the Standing Committee on Procedure and House Affairs consider this particular matter. The committee did just that on May 8th of this year, but no recommendation was brought forward to remedy the problem. However, the chair is pleased to note that the committee did see fit to present its 75th report earlier today. In particular, it contains a recommended change to Standing Order 36.1.1c that addresses the issue raised by the member for Haldimand-Norfolk. I thank the honourable member and the committee for their efforts to better ensure the right of all Canadians to participate in the democratic process to the greatest extent possible. Je remercie les honorables députés.
Thank you to honourable members for their attention.
Ordre du jour.
Orders of the day. Government orders. Government bills. Commons.
Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts.
Resuming debate, the honourable member for Renfrew-Nipissing Pembroke has 5.5 minutes remaining in her speech.
Reducing penalties for serious crimes sends the wrong message to victims, law-abiding Canadians, and to criminals. This government is failing to take the criminal justice issues seriously. Sadly, for Canadian women, this Prime Minister has developed a reputation of obfuscation when clarity is required. The Prime Minister sets a bad example. The female reporter who is subjected to an unwanted sexual advance by the Prime Minister in a workplace is still waiting for an admission of responsibility. His hypocrisy in lecturing others while failing to account for his own behaviour sets a bad example at a time when members of his own party are lecturing Canadians that bad behaviour is encouraged by the things politicians say or do not say. This open letter appeared in a Toronto newspaper this week. It is important that the government hear directly from the casualties of its neglect of the rights of victims and their families. Start of quote. When I was 10 years old, one of Canada's most notorious pedophiles, Peter Whitmore, kidnapped, tortured, and raped me in an abandoned house in rural Saskatchewan after repeatedly slipping in and out of the justice system's oversight. And so you might imagine the rush of anger, pain, and sadness I felt reading the recent news that Terry Lynn McClintock, who kidnapped, raped, and killed 8-year-old Tori Stafford in 2009, was moved from a maximum security prison to an Indigenous healing lodge. I feel the pain of the Stafford family. The justice system is once again failing to protect our children. It was the Liberal government that released Peter Whitmore from his 8th time in a federal prison for the abduction and rape of a myriad of children before his sights fell upon me in 2006. When I tell my story publicly, I usually ask the audience, what is the most important thing to us and to the future of our country? The answer is plain and simple: our children. How could someone as callous and destructive as McClintock be moved to a healing lodge? How can people who are supposed to ensure justice is done allow this to happen? This is not the first time the Liberal government or parole boards have failed to keep child abusers locked up. Over the past few months, I've come upon multiple cases of convicted pedophiles and child murderers being released or having their sentences reduced. For example, Ryan Chamberlain, a Saskatchewan hockey coach who admitted to sexually abusing 4 young boys after a prior history of sexually abusing children, was released after serving less than 4 years in prison. His mother told the media, "It's so sickening to even think he's going to be back out, and I can't do anything more about it," adding that men like her son can't change and the federal government must act to keep them behind bars. Kyle Larson, a pedophile who has multiple convictions, has not sought treatment, was released recently after serving 12 months in a Calgary correctional facility. The Edmonton Police Service went so far as to issue a public statement saying they fear Larson, who plans to live in Edmonton, will commit another sexual offense against someone under the age of 16 while in the community. The striking statement, according to the Force, was issued as part of its duty to warn the public about the risk Larson poses. Larson is considered an untreated child sex offender with pedophilic interest towards both male and female children, police said. Larson has a history of opportunistic offending against children known to him. However, he's also to believe to be at risk of offending against victims unknown to him and has shown he will groom and or lure his victims if given the chance. McClintock, a convicted child murderer who is anything but a model prisoner, is being moved to a healing lodge intended to rehabilitate prisoners with light sentences. Translation: her punishment for murdering and assaulting a child will now amount to living with minimal security in a facility that receives child visitors. What kind of a person does not understand that these people do not change? Predators are predators. A 25-year study of sex offenders in Canada found about 3 in 5 offenders reoffended based on sex reoffense charges or convictions or court appearances data. That figure increased to more than 4 in 5 when all offenses and undetected sex crimes were included in the analysis. These loopholes are making our justice system look like a game of catch and release with no more than a slap on the wrist for a consequence. The real punishment is handed off to victims and their families. What makes this such a painful blow for victims and families impacted by these monsters is the failure of the Liberal government to stand up for the rights of victims and survivors. Some people are offended when victims speak out seeking justice. They appear to defend the rights of predators who destroyed lives, predators like mine, who raped and abducted many children in his pedophilic career, were allowed to walk free from a federal prison on his way to the front door of my parents' Saskatchewan farmhouse in 2006. 8 times the system failed to stop this monster from getting back on the streets. 8 times the family was ripped apart, never to be whole again. 8 times he slipped through the cracks, and on the 9th time, he chose the wrong child and the wrong family, a family who's not giving up until justice is truly served. I'm raising my voice for those who cannot not let the Stafford family victims and victims' families know that they're not alone while standing against the failing justice system. I'm standing up for the protection of our children. I'm speaking out for what's right. End of quote. The author of this letter is a farmer and a volunteer firefighter. Bill C-75 needs to be chopped up to allow for careful consideration and proper debate. Anything less is failing Canadians.
Hear, hear. Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member opposite for her contributions to today's debate, and I would ask her if there may be some common ground in respect of the important aspects of domestic violence that she indicated both in the first part and the second part of her speech were a priority for her side of the House. And what I would put to her is that there are important changes with respect to domestic violence in terms of intimate partner violence, expanding the definition so it's not just violence that comes from a spouse, but also from a dating partner or a former spouse, increasing the maximum sentence for those convicted of intimate partner violence, and indeed reversing the onus on bail for those who are repeat offenders. And in fact, the changes we're making to preliminary inquiries would reduce the likelihood, would eliminate the likelihood that a woman who is dealing with a sexual assault trial has to be victimized twice. By removing the preliminary inquiry, we no longer have sexual assault victims having to testify twice in both the prelim and the trial process. Are those the kinds of changes she's encouraged to see in terms of putting the rights of victims of sexual assault and intimate partner violence at the heart of the legislation?
Honourable Member for Renfrew, Nipissing, Pembroke.
I mentioned in the speech, Mr. Speaker, that adding jail time as a consequence and interpreting what previous activities of that nature as assault is one action I support in C-75. But C-75 is an omnibus bill. That's the very type of legislation that government promised during the election they were not going to bring forward. And speaking of dating, what they changed from an indictable offense to a summary offense is the application of noxious substances to other people. What they're saying that putting a date rape drug in a person's drink is really not that serious. And I oppose that.
Questions and comments. The Honourable Member for Mount Royal.
Thank you, Mr. Speaker, and I thank my colleague for her contribution and for standing up for victims, as we all like to do. She mentioned that the issue of applying a noxious substance was changed from an indictable offense to a summary offense. Of course, Mr. Speaker, through you, to my honourable colleague, that is not correct. It was changed to an offense that, based on a prosecutor's discretion, could either be proceeded with indictably or through summary, as were many of the offences in the bill. My question for my honourable colleague, through you, Mr. Speaker, is does my honourable colleague support the changes that the committee made to the bill to remove the body house provisions and vagrancy provisions that have been applied against gay men from the criminal code?
The Honourable Member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. And in my speech, I didn't touch on that, so I'm not sure what happened in committee, but I will talk about a part that I am familiar with, and that is the reduction of the sentences from an indictable offense to a hybrid offense with respect to impaired driving. So in my riding, anyone who's driven through the roads will see large billboard signs of Emily. Emily was a girl, about one of my daughter's ages, actually looks very much like one of them, and she had just backed out of her parents' driveway, and a person drunk out of her mind bashed into her, and the girl's car exploded in fire. We happened to be driving along the main street a couple blocks away from that, and the parents and the neighbors who watched Emily burn alive could hear her screams. Mr. Speaker, making drunk driving less of an offense is a tragedy, and it's certainly an insult to the memory of that very innocent Emily.
Time for a short question. I'll remember the Honourable Parliamentary Secretary of the Government House Leader.
So, thank you. Mr. Speaker, I'm wondering, there's aspects of the legislation that I would think that the member across the way would definitely endorse. Preliminary hearings, for example, will now be used far less. And a good example of that would be an individual victim. If a female was physically assaulted, as opposed to having to relive that nightmare by going to a preliminary hearing, this is an issue that's actually being addressed here. Would the member not agree that this is a positive amendment aspect of the legislation?
For Nipissing, Pembroke.
Mr. Speaker, the point behind this legislation was supposed to be arising out of the Jordan decision, in which justice denied, or justice that takes too long is justice denied. So what they're trying to do is shorten the length of time that a person has to wait before going to trial. So when you eliminate these preliminary hearings, that only amounts to about 3% of the total court time. What they're doing, by and large, in many parts of this bill, is increasing the length of time. And by hybridizing some of the indictable offense, what it means is if they even go to jail at all, they'll be coming back. So, Mr. Speaker, there are many parts that I do not agree with.
Resuming debate, the Honourable Member for West Nova.
Thanks very much, Mr. Speaker. I'm pleased to be on the Standing Committee for Justice and Human Rights, and I know that our committee did good work in reviewing this legislation. I'm pleased to speak today in support of Bill C-75 and would like to spend my time today outlining proposed changes, in particular to the Youth Criminal Justice Act, changes that would focus on how administration of justice offences are dealt with in the youth criminal justice system. As you may know, Mr. Speaker, the YCJA came into force in 2003 and has significantly reduced the overall use of the formal court system and custody for youth. However, despite the overall success of the YCJA in achieving its goals, the treatment of young persons in relation to administration of justice offences has remained an area of concern. While the YCJA clearly encourages alternatives to charging for less serious offences, approximately 85% of youth accused of administration of justice offences are subjected to formal charges, with many of these cases leading to custody. This is despite provisions in the YCJA which require the consideration of all alternatives to custody that are reasonable in the circumstances. Mr. Speaker, these high rates of charging in custody for administration of justice offences contribute to delays in the system and the overrepresentation of vulnerable youth, particularly Indigenous youth, for conduct that would not in and of itself be criminal. The aim of the proposed youth reforms in Bill C-75 is to strengthen aspects of the current youth justice framework so that fewer young persons are prosecuted and incarcerated for administration of justice offences. In this regard, the bill would amend the YCJA to do several things. First, further encourage the use of alternatives to charges such as extrajudicial measures and judicial reviews in response to administration of justice offences. Second, ensure that the conditions imposed on a youth at the bail stage or at sentencing are necessary to address the offending behaviour of the youth and required for criminal justice purposes. And third, further restrict the use of custodial sentences for administration of justice offences. Bill C-75 would provide that extrajudicial, in other words, informal measures, such as police warnings or referrals to community-based programs, which are adequate to hold a young person accountable for breaches of conditions or failures to appear at the bail stage and for breaches of community-based youth offences. An exception to this presumption, however, would arise in circumstances where the young person either has a history of breaches or where the breach caused harm or a risk of harm to the safety of the public. Lorsque les mesures extrajudiciaires ne seraient pas considérées.
When extrajudicial measures are not considered adequate to address a breach of conditions, the bill would establish the circumstances in which an appearance for a breach of conditions under the Criminal Code as proposed in Bill C-75 or the existing mechanism in the form of a community sentence outlined in the bill would be used to respond to such breaches.
Rechange constituera l'approche privilégiée.
These alternative measures would represent the most favored approach, as long as they are adequate, and the use of formal charges in response to offences regarding administration of justice would be discouraged except as a last resort. Madam Speaker, I would now like to move on to the use of conditions in the context of the criminal justice system for adolescents. Many are of the opinion that the heart of the problem when it comes to offenses, administration of justice offenses, have to do with the many conditions imposed on youth. The concern is that in many cases, imposing such conditions only leads the young person to failure, which leads to new charges laid against them and perpetuates their participation in criminal activities.
From Ryerson University, who has focused her research over the past decade on the YCJA and issues surrounding bail and the use of bail release conditions, in her testimony before our committee, stated that there are numerous broad-ranging conditions placed on youth, and many times those conditions appear to be crafted with broad social welfare aims that go far beyond the purpose of release conditions. Dr. Sprott also testified that the use of these broad welfare or treatment-based conditions is problematic for a variety of reasons, and that, quote, however well-intended, they're unlikely to achieve their desired goals and can actually do more harm in a variety of ways, one of which is setting the youth up for failing to comply. The youth justice proposals in Bill C-75 would require greater scrutiny at the front end to ensure that any conditions imposed are reasonable in the circumstances and necessary for a valid criminal law purpose, such as ensuring the young person's attendance in court or protecting the safety of the public. Furthermore, conditions could not be imposed on a young person unless he or she would reasonably be able to comply with those said conditions. Finally, the bill would prohibit the imposition of conditions for the detention of young persons as a substitute for appropriate child protection, mental health, or other social measures. Madam Speaker, as I have mentioned, the use of custody in relation to administration of justice offences committed by young persons remains an area of concern due to the fact that 35% of these cases are resulting in custody. Bill C-75 would modify the criteria for youth custody by providing that custody could not be imposed on the basis of prior failures to comply with non-custodial sentences unless the prior failures resulted in actual findings of guilt. In other words, evidence alone of prior failures would not be sufficient. In addition, the bill would provide that if a youth justice court is imposing a sentence for a breach at the bail stage or for a failure to comply with a community-based sentence, custody could not be imposed unless the young person caused harm or a risk of harm to the safety of the public in committing the offence currently before the court. These changes would make it less likely for administration of justice offences to lead to custody for youth. Madam Speaker, in closing, I can tell you it is a pleasure to be a member of the Standing Committee on Justice and Human Rights, and I can assure my honourable colleagues we did a comprehensive study of C-75. And while I know there were legitimate disagreements between members of the committee, there were also a number of amendments that were made that were unanimously adopted that strengthened the bill. I thank the many witnesses who gave their time and expertise to assist the committee through testimony and through providing written submissions. I am confident that these reforms I have touched on today will contribute to a more efficient youth criminal justice system and to a better justice system overall. They will free up court time so that the more serious criminal matters, both on the youth side and the adult side, can be dealt with in a timely fashion and in line with the parameters set out in the Jordan decision. Madam Speaker, this is why I support passage of this bill and urge all of my honourable colleagues to do so as well. Thank you very much.
Questions and comments? L'honorable député de Hochelaga. Hochelaga?
Oui, merci Madame la Présidente, j'attendais.
Thank you. I was just waiting for the light from my microphone. I would like to ask the member if, to reduce delays in our criminal justice system, why does this bill not seize the opportunity to eliminate the mandatory minimum sentences imposed by the Harper government years ago?
Thank you, Madam Speaker. This is an important question. I appreciate my friend for raising this. Obviously, mandatory minimum penalties are an issue that have to be dealt with, in my view. Some mandatory minimum penalties are appropriate. There are others that the Supreme Court of Canada have ruled that are inappropriate and violate the Charter. It is important that the government take a comprehensive view to ensure we get this right. That review is ongoing right now. We'll make sure we take the time to get it right and to set the criminal justice system up for doing the duty it does every day to mete out justice in the best and appropriate way.
Questions and comments? The honourable member for Edmonton Manning.
Well, thank you, Madam Speaker. The question to I heard the member opposite just respond to a question on some of the weaknesses maybe of this bill, and since he's on that path, I would like to ask him if he can outline some of the areas that can be probably strengthened or be better off with this bill. And if those weaknesses, can he highlight those weaknesses that he wished that would have been in that bill better than the way the bill is written as we see it?
West Nova.
Madam Speaker, I guess, you know, this bill does do a number of things that will address the issue of delays in our courts. Does it fix every problem that our criminal justice system has? No. Is it a positive step in the right direction? It 100% is. I therefore support the bill. When we look at the administration of justice offences and the way that that is going to get rid of the tremendous backlog in our provincial courts, and the custodial sentences that are being applied to our youth, especially Indigenous youth, as I highlighted in my speech. These will really get at the heart of many of the issues that are causing the delay. But, of course, one bill does not fix all problems. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
I want to just compliment the member, first of all, not just on his comments here today, but also on his really tremendous work at the Justice Committee in terms of bringing his expertise to bear in terms of the study that's being undertaken. His speech commented on the importance of looking at reforms, and he highlighted some of the committee testimony, specifically around bail. We know that Indigenous and other marginalized groups are overrepresented in the criminal justice system and that they're disproportionately impacted by the bail process. And we know that if they're disproportionately impacted because they're detained sometimes in custody for reasons that are entirely unrelated to the offence that they are alleged to have committed. For example, they don't have enough money or don't know individuals who are suitable for supervising the accused if they were to be released on bail. We're changing bail through certain key amendments in this legislation to take into account that overrepresentation of Indigenous and other marginalized groups. I was wondering if the member could comment on how those changes will alleviate the plight of those groups in particular.
The member for West Nova.
Well, I thank my friend for the excellent question, and it's obvious through the testimony we heard at committee that the measures in this bill will go a long way to dealing with not only delay in our court system, but unfairness as well. Patent unfairness that we see far too often when marginalized individuals come before the criminal justice system and for one reason or another are given conditions that they cannot reasonably comply with and are therefore breached for not complying with a condition that they really had no opportunity to be able to comply with. So it's important that the judicial referral hearings that are one of the aspects of this bill is put in place to deal with not only the backlog in our court system, but also to allow fairness, to ensure fairness for all individuals who are facing a criminal charge. Thank you.
Reprise de débat. L'honorable député de Lévis-Lotbinière.
The Honourable Member for Lévis-Lotbinière. Thank you, Madam Speaker. It is always a privilege to speak in this House, especially when it is to protect the safety of the people in my riding and Canadians all over the country. Every day since the election in 2006, I've had the privilege of being chosen to represent values that are dear to us in Lévis-Lotbinière. And with my Conservative colleagues, we are committed to being up to the honor with ethics, respect, and integrity. The legislative measures debated and passed in the House generally help Canada to move forward. But since the election of this Liberal majority government, the legislative proposals that are hastily debated and passed in the House are unfortunately causing it to take a step back.
The list is long, but one only has to think about the disastrous effect that marijuana legalization will have on our youth's future. Now, obviously, I'd like to be positive. I'd even like to be optimistic, or even be able to put my head in the sand like several colleagues seem to be able to do, considering that this bill, Bill C-75, is 300 pages long. Once again, Madam Speaker, as official opposition, we have to condemn the lack of judgment and vision of this Liberal government that doesn't seem to be able to understand the consequences and gaps that these changes will bring about for the safety of our children and our country. On what grounds, Mr. Speaker? Well, just to check off their list of promises, even if that means that Canada's prosperity will go backwards. And you'll see time will prove us right. We've had the good fortune to have inherited a political system that is one of the most stable and long-lasting in the world, a model in peace, order, and good government. But obviously, this is all being overshadowed by a Liberal government that wants to make free what we deemed needed to be controlled. Bringing about major changes to the justice system in Canada is a serious exercise, one that can't just be taken lightly, like, once again, this Liberal government is doing. Believe it or not, Madam Speaker, instead of acting to combat terrorism, Liberals would like to reduce the sentences of those who have gone abroad to join a terrorist group like the Islamic State. How can a Prime Minister believe that reintegration and not prosecution is the best way to deal with these Islamist State fighters? True to his liberal opportunism, it is clear that this government does not believe in the rights of victims and the safety of Canadians in the same way that we do. The Prime Minister wants to reduce sentences for the most serious crimes. And whether it be through listening to witnesses in committee, doing studies, following just good common sense, adopting this bill will mean, contrary to what we heard, that criminals will only have to pay a fine to go to prison, rather than going to prison for serious crimes like joining a terrorist group. Human trafficking, leaving Canada to join a terrorist group, impaired driving causing bodily harm. This makes no sense, Madam Speaker. All these offenses are criminal offenses, indictable offenses, and should have a mandatory sentence. The Justice Committee listened to victims of crime who are angry that the Liberals once again are betraying them by refusing to see justice done. The Prime Minister recently refused to put a killer back behind bars. It's outrageous, Madam Speaker. The Conservatives of Canada have always stood up for victims of crime, and we will continue to do this. And that's why we proposed more than 100 amendments in order to make sure that Canadians and our country are safe. We wanted serious offences to remain indictable offences, and we have demanded that the Liberals back down on eliminating preliminary hearings and peremptory challenges. We've also demanded that the cross-examination of police officers for certain offences also be cancelled, and that minimum sentences be increased for sexual violence. Now, obviously, there are some amendments that brought about that are positive. The Conservatives will be able to support some of the following proposals. We agree that we should repeal any provisions in the criminal code that are unconstitutional. The Conservatives will support that step because it helps victims of crime and it allows us to streamline the code. We also support increasing the maximum sentence for repeat intimate partner violence. We feel that the mistreatment of an intimate partner is an aggravating circumstance in determining the sentence. Madam Speaker, it goes without saying that we also agree to reduce delays in our legal system, especially those that deal with preliminary inquiries, that allow increased use of technology in order to allow for remote appearances during procedures, that also modernizes and clarifies interim release provisions. We also support hearings for not appearing at an administration of justice offense, for example, or a breach of parole. We think that modernizing the language in the criminal code is also a good change. Madam Speaker, the Prime Minister, after traveling like a grasshopper all over the world, this Prime Minister who wants to use omnibus bills, this Prime Minister wants to now finally fulfill some of his promises a few months away from the election. This is so unfortunate, Madam Speaker. An omnibus bill is being pushed through without time for an in-depth examination. During the session, there were bills like Bill C-45, legalizing marijuana, C-46, drug-impaired driving. These are two important bills that follow up on the immoral promise of the Liberals to legalize marijuana, a promise that was made during the election campaign of 2015. Because of these delays and bad legislative management, the government's finally running out of time to fulfill its mandate. It's going to have a hard time to meet its deadlines with Bill C-75. This has been going on for months. The government did nothing up until now to reduce delays within the legal system. And we have raised this several times, including the PM's lack of judicial appointments. Mr. Speaker, on the 1st of April 2018, 3 years after his election as Prime Minister, there were 59 vacant positions, judicial positions within the federal government. In conclusion, Madam Speaker, just checking things off their list of election promises must not jeopardize the safety of honest Canadians, must not jeopardize the safety of our borders, and must not further weaken the justice system in Canada. It's not just this Prime Minister who will be a failure, but a whole generation will suffer for what we have fought for so long. Questions and comments?
To the government, to the Minister of Justice and Attorney General.
Thank you, Madam Speaker, and I appreciate the comments from. J'apprécie beaucoup les commentaires.
I appreciate the comments and remarks, my colleague on the other side. But I want to raise an issue that wasn't raised by him nor by his Conservative colleagues, but that has been raised several times within the committee, and that is the rights of LGBTQ2 communities.
Solicit the member's comments on. This bill puts into compliance with the Constitution aspects that relate to the LGBTQ2 community. It removes vagrancy, it removes the body house provisions, which allows the expungement of records that historically discriminated against the LGBTQ2 community. And secondly, we've removed in this bill Section 159 of the Criminal Code, which makes it an offence for consenting minors between the ages of 16 and 18 who are engaged in LGBTQ2 sexual relations, makes that an offence under the criminal law, whereas the exact same sexual relations by a heterosexual couple would not be criminalised. I want to know if the member opposite appreciates these aspects in terms of this government's support and this Parliament's support for the important issue of the human rights of the LGBTQ2 community. Thank you.
The Honourable Member for Lévis-Lotbinière. Thank you, Madam Speaker. And I'd like to thank my colleague for his question. All Canadians have a right to the same legal system. All Canadians throughout the country. Thank you. Questions and comments. The Honourable Member for Abitibi-Témiscamingue. Thank you, Madam Speaker. There were many amendments that were rejected. I'd like to know which ones my colleague is most disappointed about. The Honourable Member for Lévis-Lotbinière. Thank you very much, and I'd like to thank my colleague for her question. I am disappointed about all the amendments that were rejected, and I'm especially disappointed about Liberals making it easier for criminals to remain free. It's always easy for a Liberal to allow them to be released early without thinking about the consequences. Criminals who leave prison too early can affect Canadian safety. The Honourable Member for Montreal. Thank you very much, Madam Speaker, and I appreciate the comments of my colleague opposite. Madam Speaker, I hope that my colleague appreciates the fact that Bill C-75, which came back to the House, does not change the Terrorism Act. It does speak to terrorism, but the committee made sure that this did not change the Terrorism Act. He said that he's disappointed that the Conservative amendments on hybridization amendments were not accepted. So one of those changes to offences was hybridizing the offence of branding cattle and moving vessels that are on the rocks. I'd like to know what my colleague opposite thinks of that. And I'd like to thank my colleague for his question. It is a victory on the part of the Conservatives to have any amendments on terrorism to be withdrawn in this committee. We feel that the committee made a difference, and especially the Conservatives, on the withdrawal of those amendments. The Honourable Member for Mégantic-L'Érable. Thank you very much, Madam Speaker. You know, it's all very well to change legislation, to improve legislation, to bring forward amendments, but when there are no judges, and when there's a system that doesn't work, then what happens? Well, a citizen in my riding was the victim of an attempt on his life, and I think that we have to deal with the lack of judges in our system. The Honourable Member for Lévis-Lotbinière. My colleague is absolutely right. Where there are 59 vacant positions in the judicial system in Canada. If all judges had been appointed, there wouldn't be so many delays in the system. Thank you. Resuming debate, the Honourable Member for Abitibi-Témiscamingue. Thank you very much, Madam Speaker. We are at report stage of Bill C-75. This is a bill that was brought forward by the Liberals to increase compliance with the Jordan ruling that was brought down in 2016 by the Supreme Court and to help get rid of backlogs in the justice system. Unfortunately, what we've heard over and over again is that Bill C-75 was drafted very quickly, that there are very vague provisions in it, and that unfortunately it will not respond to the main goal, which is to make the legal system more effective, more efficient, and it won't meet the goal of improving it for citizens' benefits. Something that was raised and wasn't resolved was the lack of an overall true deep reform of the criminal justice system, including repealing mandatory minimum sentences. This is a major point. Mandatory minimum sentences are present in most cases. However, for many offenses, there are many circumstances that the judges would have liked to take into account in the sentencing. When you have mandatory sentences, the judge has no choice and cannot take into account any extenuating circumstances that are sometimes very sad ones. I only need to think of unfortunate cases that I have heard of myself. And some people have tried to commit suicide, for example. And oftentimes, these people are suicidal, they become very, very distressed, and they may end up threatening police officers, either with legitimately acquired firearms or other kinds of weapons that may simply look like firearms, because they want to be killed. They do this to police officers so that police officers will train their firearms on them. And that's how some of these people end up committing suicide, through another person. These people are in severe distress. Firearms are subject to mandatory minimum sentences, rather the use of firearms. And over the course of the trial, if the judge realizes that it wasn't a criminality problem, but rather a mental health problem, if the judge realizes that it would be a better idea for this person to be taken care of rather than be considered as a criminal, well, unfortunately, they're often limited because of these mandatory sentences. So I think it's very, very important that flexibility be granted to judges so that they don't necessarily have to impose these mandatory minimum sentences. What's also very important to understand is this. Some people who do commit crimes end up receiving sentences that extend far beyond mandatory minimum sentences. So there's a bit of a perverse effect. The judges, once again, cannot consider extenuating circumstances. They cannot consider the past of the individual, of the accused. It's very hard for judges to take into account their personal situation or any family responsibilities that the accused may have. So it doesn't give the flexibility to the judge to change that sentence. And there are other issues that weren't addressed, but that do have an impact on the legal system. And that is the lack of access to financial resources, whether it be for victims or families of victims, or whether it be for people who have been accused. What's important to understand is that there are many young people who don't have dependents or who don't have families, and the threshold for legal aid is very low. You have to be very, very poor to have access to legal aid. And what this means is that some people simply cannot pay for legal services. They don't have access to legal aid, or their income may be too higher than that threshold. There may be people who are in their 20s who are earning maybe $30,000, $40,000 a year, and therefore they don't have access to legal aid because their income is considered to be too high. It's impossible, though, for these people to afford the $30,000 in legal fees, even if it's legal aid. So in that case, they don't have access to good legal advice, and they're stuck in a system with no access to any resources whatsoever. And now on the other side, there are also the victims. Victims also have to be considered in our legal system. And if they were assisted, then their experience of the system could also be better, but they oftentimes receive no support whatsoever. And oftentimes you hear parents who are there, their children, for example, might have been killed in road accidents or rather killed by drivers of other cars. They find that they have no access to financial resources or human resources when they're attending these trials. So they pay everything out of their pocket. So resources for them is also a major problem, and that's also affecting the efficiency of our legal system, and it is not addressed in Bill C-75.
We have to be more logical, we have to be able to support them, and we have to make sure they understand what is going on. Parents of victims must, for instance, if they are completely lost in how proceedings are unfolding and when they have to pay for their own legal fees, simply to understand the proceedings and to find their way through the legal system, again, I believe that the bill could have done better in that regard, or the issue could have been reviewed in committee, but it wasn't. It was not addressed in committee. Another problem with the bill is that if we truly want to improve our criminal justice system, we must untangle the various acts, criminal acts, which come as a result of social problems. The simple possession of drugs is still a criminal offense, and anyone accused of such gets sucked into the legal system. I think we should take another look as to whether possessing an amount of drugs is not more of a health issue rather than a criminal one. But the way it is treated now in the criminal justice system, we should ask ourselves whether it is the best way to treat these cases, or whether simple drug possession and drug use should not be considered as being a health matter. And that way, the legal system could focus more on more serious criminal acts, and it would free up resources within the legal system. So instead of resources being used for simple possession of drugs or use of drugs, which could be treated elsewhere in detox centers or at the hospital, then these resources could be used, for instance, to look at human trafficking issues, sex crimes, violence against First Nations. These crimes occur frequently, and unfortunately our legal system does not deal with them in an efficient manner. So I believe we should rethink what our priorities are within the criminal justice system. Many offenses are committed, and they come as a result of social problems, which come as a result of extreme poverty. Some people commit criminal acts simply to survive. So criminalizing these people, is that the right solution? Or perhaps it would be better to address the root causes of crime and to understand why some people's behavior, criminal or other, might be examined more closely. I think I've run out of time, and I'll leave it at that for now. Questions and comments? The Honourable Parliamentary Secretary for the Minister of Justice. I appreciated the speech given by the member for Abitibi-Témiscamingue, and she mentioned the case of several groups in Canada and people who are forced to hire lawyers.
That were made at committee that addressed this very important issue. Something that was raised with us was the issue of when you're changing summary conviction offences and moving them to 2 years less a day in terms of the penalty. What does that mean in terms of those people that are either unrepresented or represented by law students, paralegals, or agents? And what we've done at committee is that there's been an important change that has been supported that would allow the provinces and territories, it's a change to 802.1 of the Criminal Code, that allows the provinces and territories to permit agents to appear on summary conviction offences that are punishable by more than 6 months of imprisonment. Is that the kind of change she is encouraged to see, because it addresses the very access to justice issues she raised in her speech?
The member for Abitibi-Témiscamingue. Thank you very much. Well, it's clear that if people can turn to legal students or paralegals to help represent them in court, that might help. But that kind of support cannot apply to all offenses. As a result, if people turn to legal students, or law students rather, they can only do so if there's a law school nearby. In Abitibi-Témiscamingue, there is no law school, so the constituents of my riding would not have reasonable access to law students. So the problem remains. When at the age of 21 you owe $30,000 or $40,000 in legal fees, that means mortgaging the rest of the life of that person, or at least you're mortgaging the next 15 or 20 years of their life, and you are affecting that person's career and other aspects of their life. So if a person does not have or cannot afford to pay for legal fees, many people will simply plead guilty.
St. Albert, Edmonton.
Thank you, Madam Speaker, and I thank the member for Abitibi-Témiscamingue for her speech. I want to address the issue of limiting preliminary inquiries. The government in Bill C-75 will limit preliminary inquiries only when the maximum sentence is life behind bars. anyone charged with an offence with a lesser maximum penalty would not have the benefit of a preliminary inquiry. The government has provided no empirical data to back up its assertion that this is going to reduce the backlog in our courts. We heard a considerable amount of evidence before the Justice Committee that preliminary inquiries help narrow issues. They allow both parties to test their cases. They provide a discovery function. And in terms of data, 86% of cases that have a preliminary inquiry are resolved. I was wondering if the member could comment.
The member for Abitibi-Témiscamingue, you have just over a minute to respond. Yes, indeed, I'm in fact very concerned about the elimination of, or the limitation of preliminary inquiries. It's a bit of a dress rehearsal to a trial, and a preliminary inquiry helps to put evidence, present evidence, and sometimes a preliminary inquiry results in there not being a trial. However, if you limit them and there is not enough evidence or some criteria are not met to lay charges that might help the parties uncover certain issues which would otherwise not be known. So preliminary inquiries do play a role. It also means that there's less time for family law cases, which often require the immediate intervention of judges. Many considerations are at stake, and I believe it was not a good idea.
Thank you, Madam Speaker. Really pleased to be joining the debate. I've been listening for a few hours now. What different members believe are the most important parts of the bill, the biggest defects, the biggest advantages given to it. The member for St. Albert Edmonton, I thought, gave probably one of the best, most succinct rundowns of the bill in terms of its many defects in it. And it's an omnibus justice bill. I happen to sit on the Standing Committee on Finance, so we are well-versed in omnibus legislation there, proposed for 3 years now from this government, a government that during the last election promised not to ram through this House any more omnibus legislation. It was a promise at the time, a promise they have continuously broken since then. They failed to live up to them. This particular piece of legislation, the lens I want to give to it is mostly consideration of some of the hybridized offenses in it. Like I've mentioned to the House before, I am not a member of the legal profession, so my eyes on it are basically the eyes of just any regular member of the public, I would think, and what they would feel are serious offenses versus non-serious offenses. One of the reasons for this piece of legislation that we have been told in this House is that this will drastically reduce the bottleneck at our provincial courts, that the court system will be somehow liberated from having to deal with all of these cases that are just clogging it up and all the court delays. And with the Jordan decision rendered by the Supreme Court of Canada, that bottleneck, those court cases are even more important now because we have individuals being charged with offenses but never seeing an actual court, never actually going through the system to be judged. I would call this piece of legislation, there's a Yiddish proverb, it says the gift is not as precious as first thought because there's so many defects, as the member from St. Albert Edmonton pointed out, will actually create an even greater bottleneck at the provincial courts. Those courts closest to the people are the ones that deal with the vast majority of criminal offenses. They deal with family law, young persons 12 to 17, traffic bylaw violations, regulatory offenses, small claims, preliminary inquiries. These are actually the judges doing most of the work. Every province has it set up just slightly differently in how they proceed with different types of offenses. So many of these won't be directly affected by this, but the ones that deal with the criminal offenses will be, because a great deal of the hybridized ones will be going to those provincial courts. You're not making it simpler, actually. Madam Speaker, they're not doing that. They're actually creating a greater bottleneck. And I thought that it was the House of Commons with the Senate together, Parliament, that decided what was a serious enough offense to warrant 5, 10, 15, 20, 25 years, not prosecutors. Not prosecutors. It is this House that decides on behalf of our constituents what are serious offences and what is deserving of consideration by a judge, whether a judge should consider the maximum offence of life, 25 years to life, whether it should be 15 years or 10 years. It is not up to prosecutors who are not responsible to any constituency. They're not responsible directly to the public. They do not have to go to the public every 4 years and make a pitch for the retention of their job. Neither does a judge, but what we ask judges to do is to consider the particulars in an individual case and determine whether it warrants 10 years, 5 years, something in between, and to make a judicious decision based on the facts of that particular case. We're actually taking away that ability of the justices in particular cases to be able to render a decision. And I'm sure there'll be a member of the Liberal caucus who will stand up and attack some past Conservative government's record, and we could go back and forth to the 19th century if we want to, about what previous government did, another government did. But we're looking at the record of the past 3 years. That's where the focus should be. Right. This piece of legislation comes to us as an omnibus. What it should have come to us as is pieces of legislation, different focus areas that could have been proposed to this House. It is not as if we have a maximum load that we can take on, and afterwards we simply cannot consider any more legislation in this House. The government has shown a great interest in guillotine motions in this House. I think it's over 50 now that they have used, even after saying they would not do so and they would allow a fulsome debate in the House. There is no reason why this particular piece of legislation could not have been broken up into different pieces so that members could consider whether, in fact, criminal acts of sabotage were serious enough to perhaps warrant full consideration by indictable offense, whether that would be the best way to proceed. Forgery or uttering a passport, the selling or purchasing of an office, the bribery of public officials, I think is a serious enough offense. There should be no opportunity for a prosecutor to elect to have it hybridized and go by summary conviction. Prison breach, assisting an escape, infanticide, participation in activities of a criminal organization. Just this morning, as I was touring my constituents through the House of Commons, we had the Minister of Public Safety outside making an announcement that the government's going to be spending $86 million to fight organized crime. Well, at the same time, on the very day, they're proposing to hybridize the participation activities of a criminal organization and rendering the decision over to a prosecutor to decide whether that is a serious enough offense in a particular matter, before the judge even has a chance to listen to the facts of the case and an individual's particular circumstance and their participation. This is why I used, the gift is not as precious as first thought. Yiddish proverb, a very good one. Someday I'll be able to actually say it in Yiddish. But if the gift is that we're going to be reducing the bottleneck in our provincial courts, if we're going to be reducing wait times, appoint more judges so they can hear more cases. Provincial governments should be looking at also more court space. Something, the city of Calgary at one point, a brand new court building was built, expressly because there was a problem of securing court space, so that judges could have the space they need to hear the cases. But if this is their gift, if this is their attempt to resolve the problem, then it's not worth it. I'd say go back to the drawing board. Piece by piece, this legislation can be dealt with, and the parts of which many members on the official opposition side said that we can agree on, individuals can agree on, could be expedited onto the other place. And those parts of which we want to debate, and that's why we have a Justice Committee where, to the government caucus members who are on the committee, to their credit, they agreed that, terrorism and genocide are pretty serious offenses and therefore should not be eligible to be hybridized. But I would think that members with me would agree here that the selling or purchase of an office, and I don't mean in this case a corporate office, vacancy space, is at 30% in Calgary right now, if any member here is interested. We're talking about the purchase of an elected office. I think that is a serious enough offense that it does not deserve to be hybridized in any way. And again, to the matter of I think, process here, an omnibus piece of legislation like this, had it been broken out and had there been an attempt, I think, to reach consensus on certain parts, would have gladly passed those pieces we agree with. And it's happened before in this House. I've seen it happen where both sides, all sides, have agreed that a particular piece of legislation should pass on more quickly than another one. And maybe certain portions of this one would have been able to do so. Instead, we're having more fulsome debate so that individual members on this side, in the New Democratic Caucus, and others are able to explain their concerns that their constituents have expressed to them over the contents of this legislation. Because sabotage is a serious crime. It should not be up to a prosecutor to decide whether it's deserving of a faster process because they're busy. We know that attorney generals in every single province actually give direction to their prosecutors. Thou shalt prioritize certain cases over others. There's only so much time in a prosecutor's day, and I understand they need to prioritize it somehow. And that's led by the Attorney General of the respective province. I think that's a fair process right there. But at the same time, it's this Parliament that is supposed to set what is a serious offense and what is not. And what the government is doing here, and what it looks like to me, a copy and paste, just taking giant sections of the criminal code and dumping it in here, they're basically saying they should all be hybridized in a vain attempt to find some type of time savings for judges. And judges won't even have a chance to listen to the contents of every particular case like we expect them to do. So, Madam Speaker, I won't be able to support this piece of legislation. It's simply defective in its content, it's defective in its process, and perhaps the small amendments that the government caucus members at the Justice Committee accepted is a good step in the right direction. But there should be far more amendments to this piece of legislation before it becomes in any way permissible to pass this House. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
I thank the member from Calgary-Shepherd for his comments and for his contributions in this House. What I would say to him as a brief comment is that with respect to judicial appointments, the Minister of Justice has appointed 235 judges thus far. In each of the past 2 years, that's more judges than have been appointed by any minister of any political stripe in the last 2 decades. That includes 34 in his province alone. But what I put to him is that he questioned the ability to actually speed up the processes about compliance with Jordan and get things moving faster. And I'm going to put to him 3 statistics and ask for his comment. The first statistic is that an administration of justice offence is an offence such as breaching a curfew. Those types of offences have increased in terms of the system since 2004 by 8%. 1 in 10 incidents reported to the police involve an administration offence, and 4 in 10 cases in adult criminal courts include at least one administration of justice offence. Given those statistics, would the member opposite agree with me that when you take those types of administrative charges that are criminalized right now and are clogging up the system and move them to a separate administrative judicial referral hearing, you are addressing the exact backlog that he has identified that is a problem in this country in terms of delivering justice more quickly?
The member for Calgary-Shepherd.
Thank you, Madam Speaker. Thank you, Madam Speaker. The member had a kind of a preface to his commentary with the statistics we provided, one that I can't pass on because it was that justice minister that blew up the entire Judicial Advisory Committee appointment process where they heard advice from those committees on who should be appointed to become judges. They created a system that led to the backlog of appointments. Exactly. So they don't deserve any credit for any appointments they've done since then because they're the ones that caused the situation that they're catching up to fix today.
Questions and comments? Questions et commentaires? The honourable member for West Nova.
Speaker, I appreciate my friend's speech, but there were a number of things that I can't agree with. First of all, he indicated that it shouldn't be up to a prosecutor to determine the seriousness of an offence. I mean, I wonder if my honourable friend understands that 152 criminal code offences currently are hybrid offences, some which can be completed in a range of ways that can be very serious, including sexual assault. We trust our Crown prosecutors to make determinations based on a case-by-case basis every day. Wouldn't he agree with me that the Crowns do an effective job dealing with the cases that are before them based on the circumstances of the offence?
Member for Calgary-Shepherd.
Thank you, Madam Speaker. I'd like to thank the member for the question, and I listened intently to the previous contribution to the debate that that he made, he raises a good point. Yeah, prosecutors right now have a great deal of leeway in how they proceed with their cases. But again, like I mentioned, in cases such as sabotage, prison breach, the participation activities of a criminal organization, I think the judge should be the one to determine on the matters of the case how long the person should spend in jail in the conditions under on those situations where they convict the person of the crime involved. And it's this House that decides what the maximum and the minimum should be in those particular cases. The prosecutor makes the case, the defense defends them. So we do entrust onto them a great deal of leeway. But in cases of sabotage, like I mentioned, selling or purchasing an office, infanticide, no. In those particular cases, it should be up to the judge to hear the complete case.
We have time for a brief question. The honourable for St. Albert Edmonton.
Well, thank you, Madam Speaker. And the member for Calgary Shepherd is absolutely right. What this bill does is it takes discretion out of judges to fashion sentences having regard for the individual circumstances of a case, and it puts it in the hands of prosecutors in a non-transparent and arbitrary way. The member made reference to some of the offences that are hybridized. I would draw his attention to another, including selling young women and men into sexual slavery, as well as administrating date rape drugs. If we're going down this road, where do we draw the line? Maybe murder should be a hybrid offence next.
A brief answer from the member for Calgary Shepherd.
Thank you, Madam Speaker. So the member for St. Albert Edmonton is right. So here lies the problem. There are simply too many offences being hybridized. And it is kind of, if it was a piecemeal approach, section by section, if they had combined them together into bite-sized pieces of legislation with an easier way to explain why we're doing this, we wouldn't be in a situation where just going through the list of the offences they're proposing to hybridize raises red flags all over the place. This is the wrong way to build legislation. Omnibus justice legislation in this House simply does not work. It raises too many questions. Too many members have issues with particular sections that they want to see removed out of it, and it's simply they should go back to the drawing board and start over again.
Hear, hear. Resuming debate, the honourable member Caribou Prince George.
Well, thank you, Madam Speaker. Madam Speaker, today during this debate we've heard words such as hybridization, we've heard the tough on crime, we've heard about speeding up the judicial system. Madam Speaker, I'll remind the House and those that are listening in, Canadians that are tuned into this debate, that it was probably day 10 of the 2015 campaign that the then member of Papineau said a few things. He said that under his government he would let debate reign. He would not resort to such parliamentary tricks as closure and limiting debate. He also said that he would not resort, his government would not resort to legislative tricks to avoid scrutiny, such as what? Omnibus bills, Madam Speaker. And here we have a bill that is well over 350 pages. It actually encompasses 3 bills, Madam Speaker, and we just see another failure by this government well, I think that probably speaks more to their legislative failure than a lot of other things, Madam Speaker, and it begs a question. You know, one of the things they always say is that they are protecting Canadians. Protecting Canadians. Madam Speaker, C-75 does not do that. I don't feel, and I will preface this speech by saying, look, I'm not a lawyer. Don't profess to be one. But we have seen instances over the course of the last 3 years where the Liberals would like to say, the government would like to say, that they're tough on crime, that they're standing up for victims' rights. And what we see just recently, we saw a convicted murderer transferred from prison to a healing lodge. She had a key to her room. She could come and go as she pleased. Now this murderer, she lured an 8-year-old away from her school, and then her and her partner murdered young Tory Stafford. Now, for weeks, the Prime Minister and the Minister of Public Safety and Security said that it was not in their mandate that they could change that it was not in their powers to be able to do it. It was done. It was they probably blamed it on the Conservatives. They blamed it on the opposition for actually politicizing this event. And then what did we see last week. Well, we saw that Tory's father actually and family came to the Hill and actually protested on the steps of Parliament. They begged and they shamed this Prime Minister and Minister to change the rules. And what happened today, Madam Speaker? We saw that through that public shaming, they changed the rules, and that murderer is now behind bars. Why do I bring this up, Madam Speaker? Why do I bring this up? Because we're talking about C-75, hybridization of certain offences that previously were by indictment only. Why were they classified as by indictment? Well, because they're some of the most serious offences, Madam Speaker. And I know our honourable colleague from Calgary Shepherd brought this up, and actually his speech was bang on, Madam Speaker. But let's talk about some of these offences that have now been hybridized. So, punishment for infanticide, concealing the body of a child. How about abduction of a person under 16 or abduction of a person under 14? Administering an obnoxious substance. How about enslaving male or female into prostitution? Now, Madam Speaker, that is those are some of the crimes that are now hybridized. So it takes away the discretion of the judge, as we said earlier on, it takes away the discretion of the judge to be able to levy some of these serious crimes with serious punishment. Madam Speaker, I sat in the testimony, the committee testimony for C-75. I had the opportunity to sit through 2 sessions of this. And we had witnesses that were criminal defense lawyers that offered this, that while there were some good changes to C-75, they felt that one of the main key points that was missing was fill the voids, fill the judicial vacancies. That would help out. And I've heard the arguments from those across the way. They blame it on the government previously. They say they want to put their record up against the Conservative record. And as our honourable colleague from Calgary Shepherd so aptly put it, why are they always doing that? You know, they've been in government now for 3 years, Madam Speaker. 3 years. And yet they always say, well, you should have seen it when the Conservatives had it. Or you should have, could you just imagine if the NDP had it? Yet their failures are their own, Madam Speaker. And I'll offer this. At times, this Minister of Justice has held records for the most judicial vacancies. And I'll offer this to our honourable colleagues across the way who are going to point fingers at us. When did the Jordan decision come about? In July of 2016. So the Jordan decision, you would think, would have spurred that minister on to fill those judicial vacancies. Why is that such a key issue, Madam Speaker? Well, in rural communities such as mine and areas right across Canada, it is tough to get a judge at times. And what happens? Well, those cases get thrown out. Madam Speaker, prolific offenders in some of our communities, they're the ones that are getting out. And 90% of the crime is committed by those prolific offenders. They talk about being tough on crime. Listen, it was this Minister of Public Safety and Security that couldn't even say the word murder. Now it's a bad practice. You know what? The people that are crossing our borders illegally, now they're crossing the border irregularly. And actually, also, that brings me to another comment. In C-75, I can't call my wife a spouse anymore. It's an intimate partner. I've never introduced my wife. Madam Speaker, here's my intimate partner. I think I'd probably get slapped. It goes right along the lines of Service Canada or the Prime Minister's comments about people kind. We can't say mankind anymore. It's people kind. He said he was joking. I doubt it. Service Canada changing the vocabulary for on their forms, either removing father, mother, Mr., Miss, Mrs. I don't know about you, Madam Speaker. Have you ever introduced your partner as an intimate partner, your spouse as an intimate partner? It's ridiculous. far we have fallen that we can't see. Man, oh man, it's crazy. Madam Speaker, they said they were going to, well, do away with omnibus bills, and here we have a 350-page document that doesn't give opposition an opportunity to fully engage, doesn't give the electors that elect the opposition an opportunity to fully have a say. Madam Speaker, this government has shown contempt for this House time and time again by closure, by continuing to table these omnibus bills, Madam Speaker. It's quite shameful. And you know, they like to say that they're consulting with Canadians. And really what we know that is that they'll invite somebody for 7 minutes at committee. That's consultation. You know, Madam Speaker, they like to say they work collaboratively across the floor with opposition, and that all parties are having a say in things. And really what we know, it's their way or the highway. They know best. Madam Speaker, it really is quite shameful. What they actually are doing and saying behind closed doors is completely different than what they want their public image to be. You know, I should probably watch what I'm saying. Maybe the Prime Minister won't agree to take a picture with me now because he won't like what I said. Poor you. Yeah, poor me. You know, Madam Speaker, C-75 is a flawed piece of legislation. It is a rushed piece of legislation, is what we've heard. And we'll go back to some of these hybridized offenses. Polygamy, forced marriage, marriage under the age of 16 years of age. Canadians, if you're listening in, that's right, your government wants to make forced marriage and marriage under the age of 16 now a hybridized offense. And that is shameful. Canadians should be afraid of that and should be alarmed at what is going on by this government. They're not standing up for victims. They're making it harder for police and police agencies to do their job, and this piece of legislation is flawed.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Madam Speaker, I'm actually quite troubled by some of the comments that were just made by the member opposite, and I appreciate that there's an effort to simplify vocabulary and to make things understandable to people in the chamber, people who are watching on television. But the reason why the definition of intimate partner violence is entrenched in law is because domestic violence and violence between sexual partners is a very troubling, problematic matter that all parliamentarians should be concerned about. Even members of his own caucus today in this chamber, in response to questions that I've raised or on their own volition, have agreed that the changes to intimate partner violence form a critical part of this legislation that most members, I think, could agree with. So I would ask the member, I'm just going to give him one more opportunity to not make light of the situation, but does he believe in the fact that when you expand a definition so that things like strangulation, choking, and suffocation are deemed an elevated form of assault, and judges have to take note of that when they're issuing orders. They have to take note of the fact that it's not just your current partner, but it's also your former partner. They have to issue harsher sentences for such violence. That's a step in the right direction.
Honourable Member for Caribou Prince George.
Madam Speaker, to our honourable colleague's comment, I wasn't talking and I wasn't referring to that piece of legislation. I was referring to the fact that we can't talk about our spouse anymore as a spouse. It is now the intimate partner. We have to use that term. Madam Speaker, violence against intimate partners or our spouse or loved ones, it is shameful and it's wrong. Madam Speaker, I stand here unequivocally in support of what our colleague across the way was saying. I question the terminology. I don't question the law behind it. I question the terminology, and I'll let my comments stand with that.
Questions and comments? The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Madam Speaker. It's very interesting hearing Conservatives try to come across as if they're really tough on crime and they stand for the victims. When you really break it down, it doesn't sound, it's just not true. And let me give the example of Tory Stafford.
Tory Stafford, we have time and time, 3 times today at least, where Conservatives have stood in their place trying to give the impression that they're really tough on crime, Madam Speaker. But do you know, when Stephen Harper was the Prime Minister, there were dozens of murderers that were transferred into healing lodges. Sadly, over 12 of them, Madam Speaker. I'm wondering if the member could tell me why it is this so-called tough on Stephen Harper Conservative Party crime file didn't do anything on those files, on those child killers. Why were they allowed to go to medium security prisons when they sat in government?
The honourable member for Caribou Prince George.
Mr. Speaker, I wasn't elected at the time, so I can't comment on that, but I can comment on this Prime Minister and this Minister of Safety and Security's inability to actually get the job done and to act when it mattered most. And instead it took a family, the family of Tory Stafford, to come here to Ottawa to publicly shame and beg the Prime Minister and Minister to act. And that, Madam Speaker, is shameful.
Questions and comments? The honourable member for St. Albert, Edmonton. A brief question, please.
Thank you, Madam Speaker, and the member for Caribou Prince George went through a long list of what are currently serious indictable offences, but this government is watering down by reclassifying them to be hybrid offences. Another offence that he didn't mention, and I'd be interested in his comments on, is impaired driving causing bodily harm. We know that impaired driving is the leading criminal cause of death in Canada, and yet instead of holding those individuals who make the choice to drink and drive and as a result injure another person, this government is going to hybridize that offence. What kind of a message does that send?
The honourable member for Caribou Prince George.
Madam Speaker, I thank our honourable colleague for that question. I wasn't going to touch on that because, as most in this House know, that I lost a brother. My brother Fabian was killed by a drunk driver in March 17th of 1990. Madam Speaker, I think it's shameful that what this government is doing, and to hybridize bodily harm by impairment or impaired driving is shameful. I would just beg the question as to where Mothers Against Drunk Drivers, what their thoughts are on this, because, Madam Speaker, that just re-victimizes us and draws up the old wounds of those that we've lost. Thank you.
Order. Pursuant to the relevant standing order, it is my duty to inform the House of the questions to be raised at adjournment. The honourable member Saint-Hyacinthe-Bagotte. Poverty.
Resuming debate, the reprise de débat, the honourable member for Haldimand, Norfolk.
Well, thank you, Madam Speaker. And Madam Speaker, I rise today to add my insights to this very important discussion surrounding Bill C-75, an act to amend the Criminal Code, the Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts. And I'm speaking on behalf of the constituents in my beautiful riding of Haldimand, Norfolk. Now, as you know, Madam Speaker, one of the core functions of government is to provide a framework and a set of laws to protect those that they govern, whether that be through the creation and maintenance of a strong military to defend us from foreign threats, or, as is more applicable to today's discussion, to protect Canadians from domestic threats and to administer just consequences for those who break the law. Now, this is something that we as Conservatives take very seriously. And before speaking to the shortcomings of this bill, I'd like to first say that I do agree with reforms proposed to deal with repeat offenders of violence against intimate partners, and I see this as a step in the right direction. That said, for the few steps forward that are made in C-75, the Liberals seem to run backward with much of the rest of this bill. Now, the Liberal Party, in particular the Prime Minister, seems to jump to the defense of serious offenders and violent criminals, disregarding the rights of victims. Now, Madam Speaker, the previous Conservative government worked hard on behalf of Canadians and on behalf of victims. We brought forward legislation designed to reduce the re-victimization that occurred because of shortcomings in our justice system. Bills like the Tackling Violent Crime Act come to mind. That one implemented conditions such as a reverse onus on bail, which requires that those accused of serious gun crimes show why they shouldn't be kept in jail while awaiting trial. Our initiatives aimed at ending the revolving door form of justice that was all too common and had put people who had committed serious crimes, particularly serious gun crimes, back out on the street with bail. Now, this law was targeted squarely at organized crime and at tackling gun violence. The Tackling Violent Crimes Act also introduced tougher mandatory jail times for serious gun crimes, which again targeted organized criminals and gangs. Now, the truth is, Madam Speaker, tougher and longer sentences are about deterrence and about protecting society from violent and dangerous offenders. Violent or dangerous behavior can't be changed simply by keeping or prematurely returning an offender to the environment that bred that very behavior in the first place. But, sadly, the Liberal position seems to be quite the opposite. Now, of course, we all recall the recent transfer of Terry McClintock from the Grand Valley Corrections Institution in Kitchener to a healing lodge with no fences around it. Rightly, Canadians were outraged. They were outraged that one of Canada's most notorious criminals, convicted of first-degree murder in the kidnapping, rape, and killing of an 8-year-old, was being moved to such a weakly enforced facility. And what was the Liberal response to Canadians' outrage? Well, it was a vehement defense of that decision. Yes, it's sad, but unfortunately, that's true. And this speaks to the low position that victims have in the eyes of this Liberal government. It speaks to the undeniable Liberal bent toward making life better for even the most offensive and deplorable criminals. And this bill just further displays that view. Now, the number and types of offenses that could result in lighter sentencing as a result of this bill, even going so far as to reducing some of them to just a fine, sends a clear message to victims, and it also sends a clear message to criminals. I think that most of us would agree that Canadians are largely compassionate, they're willing to forgive, and give second chances to people who might have made some bad choices. That said, the types of offences that the Liberals seem to be making light of in Bill C-75 are well beyond what Canadians would consider just bad choices. Offences like participation in the activities of a terrorist group and leaving Canada to participate in terrorist group activities may now see reduced sentences. Madam Speaker, this includes people who have left Canada for the sole purpose of joining and fighting with ISIS. Now, for a Prime Minister who claims to be a progressive and a feminist, it's hard to see how granting a softer consequence to ISIS fighters fits this narrative. Now, this is the group that represents the very antithesis of everything that Canada represents and tries to be. These people burn homosexuals alive and throw them from buildings. They take sex slaves. They commit public mass executions, and they've declared war against our own Western values. But the Prime Minister and the Justice Minister thinks that maybe a softer touch is the best way to deal with ISIS fighters. Now again, Madam Speaker, as concerning as this is, sadly, based on what we've already seen from this government, it's not surprising. The Prime Minister seems to think that government programming to reintegrate returning ISIS members is a suitable option. And we all remember Omar Khadr. Well, Mr. Khadr, who is directly and admittedly responsible for the grenade attack that led to the death of Allied U.S. Special Forces Sergeant Christopher Speer and the injury of retired U.S. Special Forces Sergeant Lane Morris. But is Khadr in jail? Courtesy of the Prime Minister, he's now $10.5 million richer, and that thanks to the Canadian taxpayer. Canadians are appalled, Madam Speaker, and rightly so. This bill also brings in softer sentencing for, among other things, advocating genocide, participating in activities of criminal organizations, arson for fraudulent purposes, human trafficking-related offenses, and material benefit for sexual services. Now, Madam Speaker, listening to this list of some of these offenses on which the Liberals are going soft, one really can't help but wonder if some of the stakeholders who were consulted on this bill were actually organized crime leaders. Municipal corruption, selling or purchasing office, influencing appointments or dealing in offices. Many also receive lighter sentencing. And one can't help but wonder what the Liberals are preparing for with these types of changes. Now, in all seriousness, Madam Speaker, the list goes on and on. Even the abduction of a child, a defenseless child like Tori Stafford, could see lighter sentencing under this Liberal soft on crime bill. And Madam Speaker, back home in Haldimand, Norfolk, people are shocked to hear that these are the views of the modern Liberal Party and our Prime Minister. They're shocked at the disregard for victims of crime that's shown in bills like C-75. And they're baffled by the doublespeak of the Liberals, who claim in one breath to be opposed to gun crime, but then they introduce bills like C-71 that provides no meaningful way of addressing illegal gun crime, but that does not imply that law-abiding hunters, farmers, and sport shooters are part of the problem. And they, like Canadians right across this great country, are genuinely concerned that the soft on crime policies of Liberals are going to put their communities and their families at greater risk. So in closing, I'll again say that, there are some good aspects to this bill, but they're needles in a 300-page haystack of bad policies. Right. Now, I don't recall reading about reduced sentencing for terrorists, child abductors, and organized crime members in the Liberals' election platform. I didn't see it in the Justice Minister's mandate letter, and I'd wager good money that not one Liberal candidate would put that in any of their next campaign literature. Right. I'm confident that this is not the mandate the Canadians gave them, and nor would they give in 2019. I implore the Liberals to take this monster of a bill, split it up into more reasonable-sized bills, and set their partisan self-serving tactics aside so that this House can come together and vote in agreement for the good bits that are in C-75. Then we can have a more thorough debate on the merits of the rest of the policies and a discussion about the lack of mandate from Canadians to legislate the rest of it. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker. So I'll start with a comment and then end with a question. So the comment would be that, for my friend Opson, I thank her for her speech today, is that hybridization occurs regularly throughout the criminal code. It did under the previous government's watch, and it continues to occur today. Over 100 offences are already hybridized. And hybridization is about giving the Crown Attorney a choice about to proceed summarily, to proceed by way of an indictable offence. It doesn't predetermine the sentence. And the choice is critical, as highlighted in the instance of kidnapping, because kidnapping can be extremely heinous in the context of kidnapping someone to then traffic them for prostitution, or in the context, it can be treated in a much more benign manner in the case of a parent who shares custody with an estranged spouse who simply overstays the stay with a grandparent and has the child for an extra day. Those require different responses by a Crown Attorney. But the question that I have is, the member opposite spent a lot of time debating as to whether our government's position on crime is sufficient enough or tough enough from her perspective. And I would put it to her, how does she explain the fact that under our government's watch, all summary conviction offences are moving from 6 months to 2 years less a day in terms of a much more significant penalty for those types of offences?
The honourable member for Haldimand, Norfolk.
Well, Madam Speaker, kidnapping is kidnapping is kidnapping. Grandparents having the child for an extra day, I don't think anybody reasonable on the police force or laying charges would describe that as kidnapping or even be in a position to lay those charges. We're talking about kidnapping where there is the option of giving them a much, much later sentence for a young child. Madam Speaker, I look at it and I say, okay, the Liberals say that they're going to be tough. It's like the other day when we had the apology in the House for that terrible situation on the MS St. Louis. And the Prime Minister said that this kind of intolerance, this kind of bias should never be allowed to happen again. And yet one of this Liberal government's very first actions was to eliminate the Office of Religious Freedoms and to bring in C-51, which tried to take away protection for religious freedoms and for those who practice them. So on the one hand, they talk a good line, but when you watch their actions, it's a whole other thing.
Questions and comments? The Honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Madam Speaker. I disagree with the members across the way's comments regarding kidnapping. You know, there is a significant difference, and to try to marginalize one or play up another one, I think is wrong. Let me give a different example. Within the legislation, there's going to be a reduction of pre-trials. And the one that I would like to highlight, imagine being a sexually assaulted victim, an assaulted woman who, as opposed to having to go through a pre-trial, because of this legislation, in good part, that pre-trial could be avoided. So she doesn't have to relive that horror, that nightmare again, because of not having to go through a pre-trial. Does she not see that as a good thing? She is a victim. Why would you obligate her or want to see her have to go to a pre-trial when it's just not necessary?
The Honourable Member for Haldimand Norfolk.
Well, Madam Speaker, there are a number of ways that those kinds of situations have been dealt with successfully and sensitively in the past. But what this bill does is, by allowing so many of these very serious crimes to be hybridized, is it downloads them to the provinces. In many cases, and the provinces are already overburdened. Their justice systems are loaded. And the minister herself has said, oh, this bill is going to speed up the process at the federal level. Well, of course it will, because they're just shifting the workload off to the provinces, who have neither the time nor the capacity. So that's going to help the federal stats. But it's not going to do anything to fight the gangs. It's not going to do anything about gun crime. It's not going to punish those as more of a deterrent to those who commit the very crimes that the Liberal government says it wants to fight the most. It doesn't do that. In fact, it reduces, in many cases, these very serious crimes to a slap on the wrist to be handled by someone else instead of the federal government taking responsibility for what it should be responsible for.
Resuming debate, reprise de débat, the Honourable Member for Kitchener-Conestoga.
Well, thank you, Madam Speaker. I'm pleased to rise today to speak to Bill C-75. And throughout the day today, we've heard a lot of rhetoric from the other side in terms of what Bill C-75 actually does. We've heard comments like this is progressive legislation, this is to protect victims, it's to strengthen the criminal code, it's reflective of what Canadians want to see, it will create safer communities and protect victims. This bill, Madam Speaker, actually reduces the penalties for many offences, over 25 offences that will be reduced with the introduction of this bill. I'm going to speak a little more to that later, but some of the objectionable parts of what's happening today, Madam Speaker, relate to the process that brought us to where we are today. During the campaign, I remember sitting in many all candidates debates and being told that if the Liberal government was elected, they would not use closure, they would not use time allocation to limit debate on important bills. Here we are today, Madam Speaker, with I don't know how many dozens of times this government has implemented closure. We were also told that omnibus bills were something to be avoided at all costs. And here we have a bill, Madam Speaker, that deals with 3 substantive issues that were actually part of 3 previous bills. Over 300 pages, lumping together all kinds of reforms, some of them which we support, Madam Speaker, but this omnibus bill is impossible to support in its entirety, and I'm going to outline my reasons for that as I proceed. This piece of legislation, as we have seen time and time again by the actions of this Liberal government, actually does very little for victims of crime, and it actually reduces the potential consequences for criminals. It's become a pattern with this government to put the rights of criminals ahead of the rights of victims. Thankfully today, one of the government's failures has had a positive resolution with the reincarceration of Tory Stafford's murderer, Terry Lynn McClintic. Madam Speaker, when when Stafford's father found out that Terry Lynn McClintic was being transferred to a healing lodge, he raised objections, and through a number of contacts to individuals and then organizing protests here on the Hill, which I was able to attend and to hear the concerns of Rodney Stafford and his family, to hear how they have been impacted by the relocation of Terry Lynn McClintock to the Healing Lodge. They were very concerned about that, and many Canadians joined with them, Mr. Speaker. Thank you to see a change in speakers. And they showed their concern by coming to the protest here on Parliament Hill. And also last Saturday, Mr. Speaker, hundreds of people in the Woodstock area joined in front of the Woodstock Courthouse to register their concerns with the fact that Terry Lynn McClintock was being housed in a Healing Lodge way beyond the time when she was due to be released. We agree that we need to have rehabilitation efforts in place, Mr. Speaker. But to have someone put in a Healing Lodge 10 years, more than 10 years before her eventual release is certainly an inappropriate way to be treating our criminals, but especially to have concern for our victims. Mr. Speaker, I'm still disturbed by this government's continuing soft on crime, soft spot for criminals. Currently, Mr. Speaker, I'm dealing with a situation at the Grand Valley Institution for Women in Waterloo Region, the issue of prison needle exchange program. This program, Mr. Speaker, puts needles into the hands of hardened criminals in order to use illicit drugs in their own prison cells. We're not talking about EpiPens or insulin syringes administered by nurses. We're talking about needles being handed to prisoners to administer drugs to themselves in their own cells. Rightly, the Canadian Correctional Workers Unions have come out against this as it puts their members in danger. They were not consulted at all, Mr. Speaker, in the implementation of this pilot project, which is being carried out at the Grand Valley Institution for Women. They've held protests outside the offices of the Health Minister and the Minister for Public Safety. But it seems like this government is just turning a blind eye to this illegal substance problem in our prisons. Not only do I stand with the Correctional Workers Union on this issue, I am also very concerned about my community in Waterloo Region. These prisoners who are using the prison needle exchange program can maintain an addiction throughout their entire sentence. And the fact of their participation in the exchange program won't even be shared with the parole board when their application is being made for parole. So it's quite probable, Mr. Speaker, and quite possible that we'll have cases where criminals are returning to our community and they're still addicted to substances that may have played a role in their behavior that led them to commit their crimes in the first place. I hope that my colleagues in the Liberal Party can realize how we in the Conservative Party have a hard time believing that they are tough on crime when they encourage these types of programs in our prisons. Mr. Speaker, as a Conservative, I believe that the safety of Canadians should be the #1 priority of any government. On this side of the aisle, we will always work to strengthen the Canadian criminal justice system rather than weaken it. We will continue, Mr. Speaker, to stand up for victims. That is why today our leader was in Brampton laying out the Conservative plan that cracks down on guns and gangs. This plan has 5 proposals. First, ending automatic bail for gang members. Right now, even the most notorious gang members are entitled to bail. That means dangerous criminals who are known to police often go right back out on the streets. This is a dangerous risk to our communities and wastes valuable police resources. A Conservative government will change that and make sure that arrested, repeat gang offenders will be held without bail. Secondly, identifying gangs in the criminal code. Every time prosecutors go after gang members, they must first prove to the court that their gangs are criminal organizations. This includes well-known gangs like MS-13 and Hells Angels. This makes no sense as another huge waste of resources. A Conservative government will create and maintain a list of proven criminal organizations which will help law enforcement prosecute gang members more quickly. 3, revoking parole for gang members. Parole is a privilege, not a right. Currently, paroled offenders are required to abstain from drugs and alcohol and promise to keep the peace. A Conservative government will also require those on parole to cut ties with gangs. Statistics show offenders are more likely to reoffend on parole if they're part of a gang. If you're associating with gangs while you're on parole, message is simple. You go back to jail. 4, tougher sentences for ordering gang crime. Right now, Gang leaders who order others to commit crimes can receive very short sentences in prison, often served alongside other gang members. A conservative government would bring in mandatory sentences in federal prisons for directing gang crime, sending a strong message to gang members that they belong behind bars. 5, new sentences for violent gang crime. Gang-related murderers, assaults, robberies, and other violent acts are steadily on the rise and pose the biggest threat to Canadians' safety. A conservative government would create new offences for committing and ordering violent gang crime and attach mandatory sentences in federal prison for each. Conservatives understand that a strong criminal justice system must always put the rights of victims and communities ahead of the special treatment for perpetrators of violent crime. The Prime Minister is failing to take seriously the criminal justice issues. Reducing penalties for serious crimes sends the wrong message to victims, it sends the wrong message to law-abiding Canadians and to criminals. As such, we are concerned with the Liberals' proposal to eliminate consecutive sentences for human trafficking and the elimination of the victim surcharge introduced by our previous Conservative government to help victims of crime. The Liberals are breaking yet another promise. They committed to keep full protection in place for religious officials under Section 176 of the Criminal Code. Assault on officiants during a religious service is a very serious crime and should remain an indictable offence. We have serious concerns with other elements of this bill as well, including the number and type of offences that could result in later sentencing, including fines for what are some very serious crimes. Under the proposed changes, several serious offences could be prosecuted by summary conviction and therefore could result in later sentences. Mr. Speaker, I just want to outline for the benefit of anyone who's watching this today some of the changes in Bill C-75, some of the changes that would result from the passing of this bill. Quite probable that the penalties for these indictable offences, amongst many others, would be reduced. So, first of all, I have on this list prison breach, municipal corruption, influencing municipal officials, obstructing or violence or arrest of an officiating clergyman. I mentioned that earlier in my speech, Mr. Speaker. And certainly at this time, when we have a rise in many of these types of crimes that are happening across, especially North America, this is not the time to be reducing the sentences for these types of crime. There are many others here, Mr. Speaker. Is my time up? All right, I'll try to maybe answer them in that question period. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the member from Kitchener-Conestoga for his contribution to today's debate, and I want to ask him with respect to the constituents that he represents that are members of the LGBTQ2 community. Those constituents are directly affected by this bill in two important regards. We've removed the vagrancy and body house provisions, which brings this bill into conformity with constitutional decisions of the Supreme Court of Canada and allows the expungement of decisions of records that existed for the violation of those criminal code provisions that were inherently discriminatory. And secondly, most importantly, a provision has been changed whereby Section 159 of the criminal code has been removed. The impact of that is to treat exactly the same a consenting sexual relationship between a heterosexual young couple, age 16 and 17, and a LGBT young couple, age 16 or 17. I would wonder if the member from Kitchener-Conestoga would indicate his support for those types of changes because of the important impact they have on the LGBTQ community in his own riding.
The Honourable Member for Kitchener-Conestoga.
Mr. Speaker, I want to thank my colleague for that question, and I will always stand for any protection that is included in the Constitution and the Charter of Rights and Freedoms, absolutely, regardless of sexual orientation. But, Mr. Speaker, it's not good enough to just hide behind that when you look at the long list of other offences here that are very serious offences that my constituents have concerns about, Mr. Speaker. I have been contacted directly by my constituents about some of this. In fact, Mr. Speaker, I just happened to be working today on my responses to a number of letters that I've received, and one of them clearly says we need to be more clear on the consequences for serious crimes that are being committed in our area. And one of them, Mr. Speaker, refers to the use of drugs. And that's a big concern, and I'm very concerned that not only are we lightening these sentences, we're now giving the tacit message to our population that the use of drugs is okay by the legalization of marijuana, Mr. Speaker. It's not appropriate.
Question commentaire. La députée d'Abitibi.
The member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. In the last few months and years, there's been a lot of talk about violent sexual crimes committed against women, and there's also been a lot of talk about the ineffectiveness of the criminal justice system when it comes to dealing with these issues and how to deal with the issue of sexual violence, and how we can not re-victimize victims of sex crimes again in the courts. Does this bill help address that issue, or on the contrary, is there no improvement?
Well, thank you, Mr. Speaker. I want to thank my colleague for her question. I think this gets to the heart of one of the problems with dealing with an omnibus bill that incorporates so many different aspects to these reforms. As I said in the first part of my speech, I support some of the aspects of this bill. In fact, the one that deals with intimate partner violence, absolutely, we want to make sure that the message is given. This is absolutely inappropriate. It must be rooted out. But, Mr. Speaker, when you have this omnibus bill with so many other elements introduced into it, it makes it impossible for us to support that initiative because there are so many other initiatives in it that are totally wrong-headed, Mr. Speaker.
Questions and comments? The Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker. And my friend from Kitchener-Conestoga went through a list of offences that this government is watering down. One that he didn't highlight that I'd be interested in his comments on is a breach of a long-term supervision order. These orders involve the most serious sexual offenders, individuals who are so dangerous that following the conclusion of their sentence, they are subject to an order for up to 10 years administered and overseen by the Parole Board of Canada. When these individuals breach these orders, it is a clear sign that they are returning to their cycle of dangerous criminal behavior. I would submit that this is just another example of why Bill C-75, in terms of reclassification, is so badly thought out and so badly drafted and puts public safety at risk. I was wondering if the member would agree.
The Honourable Member for Kitchener-Conestoga.
Well, Mr. Speaker, I want to thank my colleague for his question, and I certainly don't pretend to have anywhere close to the knowledge that he has of the legal justice system. And I certainly agree that we need to do everything we can to give a strong message that any of these breaches will not be tolerated. And again, I want to come back to my earlier point that there's such a long list of lightening of sentences here that it gives me great concern for my entire community and, in fact, Mr. Speaker, for the whole country. Thank you.
Resuming debate, the Honourable Member for Calgary-Midnapore.
Thank you, Mr. Speaker. I'm very pleased to rise to speak to Bill C-75. I believe that the House now knows that I previously worked as a diplomat for 15 years, and I worked in Argentina. Then I worked in El Salvador, and lastly, I was posted in Dallas, Texas. But I also had the opportunity to work for my colleague, the member for Thornhill, when he was Minister of Foreign Affairs. And it was a very interesting experience for me because we had the America strategy.
Major principles that we followed in everything that we did. And the first was the idea of democracy, and of course, as Shadow Minister for Democratic Institutions, this is something that is very close to my heart. Secondly was that of prosperity, promoting free markets. I remember the Brazilians did not like this. They said, oh, you think everyone should be rich. No, this was not our thinking at all, rather that we chose to promote free markets abroad. But the third, Mr. Speaker, and the one that I believe that this bill flies in the face of, is justice. Because is this really the example that Canada wants to be setting for the world in terms of what is being established within this bill, Mr. Speaker? You know, I remember one time when I was consul for Canada to San Salvador, in El Salvador, there was a very unfortunate incident whereby a Canadian, as is the case abroad from time to time, as my fellow consular corps would have experienced and would have had occur, gets caught with narcotics. And in this situation, the individual was in a taxi cab. They were coming out of the cab, which had been pulled over, and unfortunately, the narcotics fell out of some tissue paper that the individual had. And so, as such, the individual was brought to jail and then put upon trial. And as the consul for Canada in El Salvador at the time, I was asked to attend these proceedings. And you know, Mr. Speaker, this was a very difficult situation for me. I would say amongst the most difficult that I had as a diplomat, because, Mr. Speaker, I in fact did receive a speech from the judge in El Salvador, who indicated that fighting narcotics, in his opinion, at this time, and you know, this was back, I'm going to say, circa 2006, Mr. Speaker, was one of the primary tenets of the Western world. But my point is this, Mr. Speaker, it is not this situation specifically or in particular, but again, it goes back to the point that I'm trying to make in regards to the deficiencies in this bill, which really is this bill not only in the delays which it causes, but in particularly the lighter sentencing. Is this really the example that Canada wants to set for the rest of the world? Exactly. I absolutely think not. And you know, Mr. Speaker, I will go through, of course, some of the lighter sentencing items, which I know my colleagues have gone through, some in quite extent, but I'll remind you as well, reducing penalties for the following crimes, which include, but are not limited to, participation in activity of terrorist groups, leaving Canada to participate in activity of terrorist groups, punishment of rider and concealment of identity, breach of trust by a public officer. And, you know, I should add, Mr. Speaker, as we go back to the items, participation in activity of terrorist groups and leaving Canada participate in activity of terrorist groups, you know, I dare say that it has historically been a major component of not only Canada's foreign affairs agenda, but I would also argue our aid agenda, and I would also argue our defense agenda to be in contrast to these things, in opposition to these things, to fight against these things in the world. And really, is this the example with C-75 that we want to set in the world? So certainly some of those things which I mentioned. You know, another item, Mr. Speaker, that stands out to me, obstructing or violence to or arrest of officiating clergymen. You know, I see here in the House my delightful colleague, the Honourable Member for Calgary-Shepherd, and you know, I worked side by side with him in his roundtable that he had for clergy individuals, you know, God bless him. And I tell you, Mr. Speaker, now, I'm sure they always do, but they did have, I will say, the fear of God in regards to the potential, you know, changing of this legislation. And I dare say that they might have it again today in seeing that these penalties can potentially be reduced. It very well might embolden some. So that, Mr. Speaker, is also very, very concerning. Again, advocating genocide, it's something that we as a nation should be leading in. You know, we are indicating in Bill C-75 that perhaps this is not the priority that we have indicated to the world that we said it was in reducing the sentencing for advocating such a thing. And I think that's a shame. And again, I ask, is this the example that Canada wants to set for the world? These examples as found in C-75. But also, Mr. Speaker, I'm going to go to one of the last items on the list, and that is participation in activities of criminal organization. And this is one that is very dear for me, again, having served in El Salvador, a place which unfortunately has much gang violence with much negative effect on society there. And you know, Mr. Speaker, in addition to being the consul and the chargé d'affaires during my time in El Salvador, I was also very fortunate to sit on the Canada Fund as a member to decide the allocation of these funds for programs. And Mr. Speaker, every single time we put these funds towards activities that would discourage gang violence, primarily towards youth, getting them involved in physical activities, in youth organizations, having other interests that would allow them to believe and see that they are worthwhile and worthy and can contribute to society. And I guess then, Mr. Speaker, this would be a good time for me to indicate that, you know, I'm very proud of our leader today and the legislation that he has brought forward in regards to gangs for a safer Canada. You know, and this includes ending automatic bail for gangsters, identifying gangs in the criminal code, revoking parole for gangsters, tougher sentences for ordering gang crime, and new sentences for violent gang crime, something that I believe, given my experience, given my work in Canada and abroad, is something that is very timely and is very necessary for a safer Canada. Thank you very much. That's right, and I do believe that we should all get behind our leader and his message of a safer Canada in promoting and in supporting this legislation, because, Mr. Speaker, I have seen the end result of where gang violence takes over a society, and it is not a pretty picture, and it affects all areas of our society. And again, I ask in Bill C-76, 75, pardon me, I've worked on 76 for so long under Democratic Institution, 76. Is this the example we want to set for the world as Canada? You know, in conclusion, Mr. Speaker, what I will say is, you know, my counterpart, the Minister of Democratic Institutions,
indicated that the reason he ran for public office and to sit in the House of Commons was to change or rather to help to make it easy for Canadians to vote. And the reason I ran was to defend democracy, and I believed in Stephen Harper and everything he did to help democracy and the prosperity of our country. He also worked to make Canada more fair and to improve our legal system. And for all those reasons, I cannot support Bill C-75. It goes against the interests of Canadians. It goes against where we stand in the eyes of the world. Thank you. Questions and comments. The Honourable Parliamentary Secretary for the Minister of Justice.
Comments from the member opposite, and salute her contributions to Canada in terms of serving in the Foreign Service in the past. While I'm tempted to ask her a question about the disenfranchisement of all of the Canadians abroad under the previous government while she was serving those Canadians abroad in El Salvador, etc., I won't ask her about C-76. She asked repeatedly about whether this is something we should be proud of, whether this is the kind of symbolic representation we want for the world. And I have a comment and a question. We do want to be known as a government that takes discrimination against Indigenous people seriously, and a government that listens to those very same foreign counterparts that she has served in her various roles in the Foreign Service, like England, who eliminated peremptory challenges in 1988, a provision that is basically discriminatory and allows you to secure a homogenous jury when you have something like a white farmer who's accused of killing an Indigenous man in Saskatchewan. So that is something I would put her that we want to be known for around the world. But I'll ask her a question now, and the question is simply this. Would she agree that it's also good to be known around the world for taking a substantive stance against intimate partner violence, something that the member from Caribou Prince George questioned in somewhat mocking manner in this chamber? But what I would put to her is, by expanding the definition, by including dating partners and former spouses, by ensuring that you have tougher penalties on intimate partner violence, is that the exact kind of stand that she would like our government and this Parliament to be taking against violence against women?
Honourable member for Calgary Midnapore.
Well, what I will say, Mr. Speaker, is that, I am very proud, again, as I indicated, of the Harper administration, and along with that, my predecessor, Jason Kenney. I'm very fortunate to know very well the Honourable John Baird, and I believe all of these people worked together to promote, in a principled stance, an absolutely way of principle, democracy, prosperity and justice in the world. I mean, it was this type of leadership that saw us do many great things during that time of administration. So I do not believe that the reduction of sentences for these significant atrocities to humankind do anything to further our place in the world. And I would very much always stand behind and encourage the types of stands that we saw with Minister Kenney and Minister Baird, and certainly Prime Minister Harper. And, I really look forward to returning to those practices again very soon under a Conservative government. Thank you.
Questions and comments? The member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. Even though this bill introduces certain measures to counter domestic violence, there are many victims of violence, of sexual violence, who have said that the current legal system is not equipped to meet the needs related to sexual violence, and that often the system re-victimizes victims. Even though this bill contains some measures to address domestic violence, is this in fact the major overhaul of the legal system we need when it comes to addressing sexual violence? When are we going to get a truly more efficient legal system to deal with sexual violence?
Thank you very much, Mr. Speaker. Frankly, I don't think that C-75 I think that with the work that she did, I can say that ours is the party that supports victims of genocide, and that includes women. Frankly, we are the party that supports the victims of genocide, and with that, women. As I said, I cannot support Bill C-75 because, frankly, to be for C-75 is to be against genocide.
Juste avant la reprise de débat, je dois informer la députée.
I must inform the honourable member for Mégantic-l'Érable that there's approximately 6 minutes remaining for the end of government orders today. However, he may begin, and the remainder of his time will be granted the next time the House resumes debate on this motion. Resuming debate. The honourable member from Mégantic-l'Érable. Thank you very much, Mr. Speaker. It is now my turn to speak to Bill C-75. As many have said, this is a omnibus bill that includes more than 300 pages. This government had promised no omnibus bills. I remember quite clearly that they had promised this, but they didn't keep it. In Bill C-75, this bill has the Liberals' mark all over it, because at second reading, there was a time allocation motion for C-75. And why is that? Because the Liberals, once again, don't want to hear the truth when they present a bill. They don't want to hear what people in the opposition have to say. And I will tell you that we represent all Canadians, and what we have to say deserves to be heard. I know that my time is running out quickly, so I will move right along. There are consequences to government inaction when it comes to justice. I know an individual in my riding who was the victim of the Liberal government's inaction in matters of justice. Mr. Denis Lassalle, he's a citizen in my riding. He was victimized twice. First, he was the victim of a criminal act and an error by the Correctional Service of Canada. He was also a victim of the Jordan decision. His attacker was freed. It's absolutely unbelievable that a government, in spite of this great bill, does nothing to resolve the case of Denis Lassalle, a citizen who did not ask to be victimized several times, not just by a criminal, but by the government. He's also the victim of the government's insistence to refusal to deal with it. Now, he's invested over $80,000 in legal fees simply to uphold his point of view and to make the government hear reason in order to be able to move on. This government has become a specialist in victimizing victims, and it is completely unacceptable. Mr. Speaker, let me remind you of the story. Mr. Lassalle was victimized. He was shot twice. He was shot 9 times. He suffered many physical and mental injuries. It was an incredibly violent act which completely upended his life that he wrote in a letter that was addressed to many individuals. April 21st, 2017, the accusation, or rather the charge for murder in the first degree, as well as the attempted murder, was thrown out due to the Jordan decision. Mr. Speaker, this decision ended any opportunity that Mr. Lassalle's case could be brought to justice. He asked one question at the time, and we still don't have the answer today. Is it reasonable for his attacker to not face justice for a crime as violent and gratuitous? Is it reasonable for him to live the rest of his days with the results of this attack? The consequences of the Jordan decision for him are a loss of trust for victims, for citizens, with regards to the Canadian justice system. And we could present. Unfortunately, interpretation was not working. There was a malfunction with the console. My apologies. The interpretation is now working. Yes. Thank you very much, Mr. Speaker. We will continue. The Honourable Member for Mégantic-L'Érable. Thank you very much, Mr. Speaker. Unfortunately, time is running short. What Mr. Lassalle wants is for the government to recognize the mistakes that were committed in his file. He wants the government to recognize that there were mistakes in the file of his aggressor, who was freed when that individual should not have been freed. An attacker that is freed when he should be in prison, who commits another crime, is now free of any charge. It is scandalous. During this time, this government gave $10 million to Omar Khadr, Mr. Speaker. And we have here a citizen who was just going to work, who was shot, who was victimized, and who now today has to ask for help. He wrote to the Prime Minister, the Minister of Justice, the Minister of Public Safety. The Minister of Public Safety was the only one to answer. In his answer, he said that the file falls under the auspices of the Minister of Justice. And what happens at that time when the ball gets passed back and forth? Well, what happens is the file does not get solved. We must think of these individuals who are the victims of this system that did not work. This government that is failing to appoint judges for all kinds of reasons, Mr. Speaker, and unfortunately, there are citizens who are waiting, who have to spend fortunes, who have to spend their money in order to obtain justice. to get justice for themselves, to try to get justice, while this government refuses to resolve the situation as quickly as possible. As Bill C-75 does not help the case of Mr. Lessard, of course, I will be voting against it. Thank you. The honourable member for Mégantic-L'Érable will have 4 minutes remaining for his speech when this House resumes debate on this motion. As well, there will be a question and comments period of 10 minutes. As it is 5:30, the House will now proceed to private members' business, according to what is indicated on the projected order of business. Private members' bills. Debate at third reading, Bill C-281.
Local Food Day Act in the name of Mr. Stetsky.
Mr. Stetsky, seconded by Ms. Sanssouci, moves that Bill C-281, an act to establish a national local food day, be now read a third time and do pass. Debate. The honourable member for Kootenay, Columbia.
Thank you, Mr. Speaker. It gives me a great deal of pleasure, of course, to rise today for the third reading of my Bill C-281 to create a national local food day the Friday before Thanksgiving every year. For those of you that aren't familiar with private members' bills, for those of you at home and how they work, when you become a member of Parliament, your name goes into a hat. So there were 338 names put into a hat, and they draw those names out, and whichever spot your name comes up in becomes the number of your bill. So I was about number 111 in terms of private member bills. So the first introduction of my bill was on June 1st of 2016, and then it was almost 2 years later, May 30th of 2018, that we held the second reading, and a number of members of Parliament from all parties gave some really inspiring speeches about how important local food was in their ridings, and I very much thank you for that. From there, the bill went to the Standing Committee on Agriculture and Agri-Food, and that was approved unanimously on June 20th. I'd like to thank the member from Cowichan Malahat Langford for his support at the Agriculture Committee. So why is local food important, and why do we have support right across Canada for my bill? Well, I'll start locally. In the summer of 2018, I went on a farmers market tour around my riding. My riding is 64,000 square kilometers. There's a lot of communities to visit. But I attended farmers market with my tent and my table in 11 communities. 10 actually, in the 11th I had the privilege of opening the summer market. So over the course of the summer I was in Fernie, Jaffrey, Cranbrook, Creston, Selmo, Nelson, Revelstoke, Golden, Radium, Invermere, and Kimberley. And everywhere I went, people were excited about local food and about National Local Food Day Bill. And why is that? Well, of course, it's because local food benefits us in so many different ways. First of all, it's healthy. We know where it comes from when it's grown locally. It's important to food security. We don't have to import food that we grow locally. And food security is going to become a growing issue internationally, particularly with climate change. Benefits the local economy. I know our farmers market in Cranbrook very quickly, after about 3 years of being in existence, was generating over $1 million a year in benefit to the economy. And this summer, going around to the various communities and participating in their farmers markets, I met tourists from all over Canada and all over the world that come to farmers markets in local communities. So it also benefits tourism as well as the economy and food security. And one of the fastest growing agriculture products in Canada is organic food, which you can get at farmers markets, of course, as well as many local grocery stores. And according to Canada Organic, organic food, comprised mostly of fresh vegetables and fruit, was valued at $4.4 billion in 2017, with 66% of Canadian shoppers saying they buy organic food, and that is, of course, on the increase. Now, you also find growing food locally is a benefit to the environment. The Intergovernmental Panel on Climate Change, when they released their report on October 10th, said one of the key messages that comes out very strongly from this report is that we are already seeing the consequences of 1 degree Celsius of global warming through more extreme weather, rising sea levels, among other changes. At the current rate of warming, the world is likely to reach 1.5 degrees between 2030 and 2052. Mr. Speaker, locally grown or harvested food has a much smaller carbon dioxide footprint than food imported from around the world and is essential to our food security. Increasingly, locally grown food is one important way to fight climate change. And a few weeks ago during question period, a question was raised around climate change impact of greenhouse marijuana grow operations that use a lot of electricity and a lot of plastics. The best way to counter that from an environmental perspective is for the government to give priority to outdoor marijuana grow operations. And I can assure you my marijuana farmers from the Kootenays are ready to do their part and to help save the planet. So in addition to hearing directly from people, there was a petition that circulated around the riding this summer, which again drew support from across Canada. And that petition talks about the need to strengthen the connection between consumers and producers of Canadian food, support our local farmers, and that a National Local Food Day to celebrate food is one of the most elemental characteristics of all of the cultures that populate this nation, and therefore call upon the Government of Canada to support the NDP's bill and act to establish National Local Food Day and designate the Friday before Thanksgiving every year as National Local Food Day. We also circulated postcards, and one of those postcards invited people to draw and send back to us what they thought represented local food. So 3-year-old Madeline from Greater Vancouver sent me a postcard with a carrot drawn on it. And Lisa from Saskatoon sent a card back saying, "Local vegetables, hooray." So there's lots of support from that perspective. There also is a lot of support from other organizations, including provincial governments, Mr. Speaker. Starting with the British Columbia Minister of Agriculture, Lana Popham, who sent us a letter saying, "I'm writing in support of Private Member Bill C-281, an act to establish a National Local Food Day. The establishment of a National Local Food Day encourages Canadians to choose local food products and supports our farmers, ranchers, fishers, hunters, and food processors, while also promoting healthy living." So that's from Lana Popham, Minister of Agriculture for British Columbia. From Minister of Agriculture and Forestry from Alberta, the Honourable O'Neill Carlier, the Government of Alberta recognizes the tremendous contributions that the local food sector makes to a strong and diversified economy and the quality of life of Albertans and Canadians. I have written a letter to the Chair of the Standing Committee on Agriculture and Agri-Food expressing my support for your bill. I look forward to further opportunities for provincial and federal governments to work together to support our local food producers and processors and recognize the contributions that they make to the economy, the environment, and the health and well-being of all Canadians. So that was from Alberta. And then from Manitoba, the Minister of Agriculture, Ralph Eichler. This letter is to express Manitoba Agriculture's support for your private member's Bill C-281, an act to establish a National Local Food Day, which would designate the Friday before Thanksgiving each year as National Local Food Day. Having a national designated day to focus awareness of food produced in Canada, especially at a time of giving thanks, so near Thanksgiving, is an excellent way to celebrate food and recognize the hard work that goes into its production. And that came from the Minister of Agriculture from Manitoba. And from across Canada, Mr. Speaker, other supporters include the Canadian Horticultural Council, Canadian Agri-Food Policy Institute, Canadian Produce Marketing Association, the Canadian Federation of Agriculture, Canadian Association of Fairs and Exhibitions, Chicken Farmers of Canada, the Canadian Meat Council, Egg Farmers of Canada, Turkey Farmers of Canada, Restaurants Canada, Food Action Coalitions, and farmers markets, and the list goes on. Now, there are a number of food events across Canada, and of course we encourage every riding, every province to celebrate food locally as well. So I just want to list some of the ones that are currently occurring in Canada. So National Local Food Day complements the many local and regional farmers markets and food festivals that already take place across Canada. There are many organizations that promote Canada's culinary wealth, including World Food Day on October 16th, National Food Day, Feast of Fields, the Nelson Garden Festival, Taste of the Danforth, the Shediac Lobster Festival, and many more. Canadians love locally produced food, and we're proud of the world-class excellence of our products. We need more opportunities to celebrate local food. I know each member of this House is proud of the growers, producers, and harvesters in their particular part of the country. In order to help shine a light on their important contributions to food security, a healthy environment, and a healthy economy, I'm asking that you continue your support for Bill C-281 and let it move on to the Senate. So let's join together across Canada and recognize the Friday before Thanksgiving each year as National Local Food Day. I very much appreciate all the support that we've had to date and look forward to that support continuing. Thank you, Mr. Speaker.
Questions and comments? Question commentaire? The honourable member for Edmonton Manning.
Well, thank you, Mr. Speaker. I congratulate the honourable member for what he's trying to do and what he's trying to submit. The question is how much of a capacity we have in Canada, and specifically in British Columbia and in the prairies, to be able to produce enough food for on a number of Canadians. If we were to take that calculation, have he's done his math to be able to advise us on what will be the capacity of the food locally produced in Canada?
Member for Kootenay, Columbia.
Yeah, thank you, Mr. Speaker. You know, I haven't actually done the calculations. I just know that across Canada, as local food grows in importance, we are going to be better and better at ensuring food security for the future. And I'll give one example. When I was mayor of Cranbrook, we started to have a look at what kind of opportunity there is to use our vacant lots in communities themselves. And virtually every city does have vacant lots that are currently empty, and instead turn those into gardens to help with local food. When I was in Korea, again, when I was mayor, we had a friendly city relationship. We stayed at a hotel in downtown Wonju, South Korea, and the entire city block was vacant. The entire city block was covered in vegetable gardens. So we can certainly do much better to ensure that we have food locally, and of course, if we have extra, we're always happy to export it.
Some comments. The honourable member for Malpeque.
Thank you, Mr. Speaker, and I really appreciate the honourable member's efforts in this regard, because I think what it would do is recognize farmers and producers for what they do in their own local areas, but not only in their own local areas, but for the economy generally. And I've always found it strange, Mr. Speaker, that often we'll be producing food in one area of the country and they'll be producing it in another, and two trucks will be passing each other on the road going different directions because of the brand that's on the label, so that one of the change stores can sell that particular product. I know of situations, Mr. Speaker, where you couldn't buy Nova Scotia corn in Nova Scotia because the chain stores had a contract to bring in Ontario corn. What sense does that make? This would be not only recognize farmers, but if we could have people buy local more often, it would actually lessen the trucking, it would help the environment, it would do any other number of things. So I really appreciate the members' efforts. I think, number one, it'll recognize farmers locally for what they do. It'll show people in the local area the quality of products that they can get from their local farmers, and that's all to the better. So I just want to congratulate the member on his effort.
For Kootenay, Columbia.
Yes, thank you. And you bring up an excellent point. Again, when I was mayor of Cranbrook, I met with the president of Save On Foods, which is a BC company that is in many of our communities. And I asked him that question. I said, if we ended up developing a greenhouse operation in Cranbrook, and produced vegetables locally, would you buy them locally? And he said, absolutely, that's the preferred way to do it. So, I mean, they save money doing it that way. It cuts down on environmental costs, but also on actual costs for companies if you get it growing locally. So the more we can grow locally, the better it is. You need to have, industries or stores that absolutely are leaders in their area to do that. But absolutely, we need much more.
Time for a short question. La députée de Rimouski.
The honourable member.
From Malpeque almost stole my question, but I will be asking it anyways. I heard a story, it might be apocryphal, but in Spain and France there were two trucks that actually faced and had a head-on collision. One was bringing tomatoes from France into Spain, and one was bringing tomatoes from Spain into France. I think it shows the absurdity of the situation. I would like to have, because you asked me for a short question, I would like to ask the members for his comment for this very unusual situation.
The honourable member for Kootenay, Columbia.
Yeah, an unfortunate situation from many aspects, of course. But again, it just shows that if we can grow more food locally, I think most stores would be happy to carry that food and sell it locally. It would save on transportation costs. It saves them money, saves the environment, and also you wouldn't have situations happening like that, which is unfortunate for the people involved as well as the concept.
Resuming debate, the honourable member for Miramichi, Grand Lake.
Thank you, Mr. Speaker, and I really want to thank you for the opportunity to talk about this important private members bill. And I just want to maybe comment on the last question. I can assure you that my tomatoes will never collide with anybody else because I sell them locally.
Yeah, very good.
So on that note, Mr. Speaker, I applaud the member for Kootenay, Columbia, for introducing this excellent private members bill. Actually, I was proud as chair of the Standing Committee of Agriculture to have all the members in our committee give unanimous support when it was presented last June. Our government recognized the contribution of agriculture in local food and regional economies. We also recognize the importance of strengthening connections between consumers and producers of food and the capacity of local food system to offer distinctive, high-quality food choice for consumer. This debate has prompted some members to share their experience with local food. Monsieur le Président.
Mr. Speaker, I've always been a local producer my whole life, but things have changed a lot. In the beginning, when I started, there were a number of small and medium-sized grocery stores and retailers and wholesalers and markets where I could bring my organic tomatoes, cucumbers, flowers. But then there was a concentration in food markets which changed things for myself and other producers.
More directly with the consumer. And through my direct market called Mr. Tomato in Rogersville, New Brunswick, we were able to connect directly with the consumer. They came to our place to buy our product. But also, I was a founding member of the Really Local Harvest Co-op. This co-op has about 30 members within a 100-kilometer diameter, and it permits us to network and also to sell our product. And with that co-op, we became the manager of the Dieppe Farmers Market, where over 7,000 people every Saturday come up there to buy their food, but also to talk to the farmer. And that made a big difference. It managed to keep some farms going because a lot of farms were closing down, and this permitted our farms to stay connected with the consumer. Because food is close to our heart, sorry, Mr. Speaker, yeah. And as they say, home is where the heart is. Depuis la fraise cueillie directement en champ en Ontario.
Now people can pick their own strawberries, there's craft beer, and the food that we love the most is food that is nearby. If you look at trends in 2018, those trends published by Loblaws, more and more Canadians want local feed. Now, of course, we're all local residents of somewhere. And what this says is that we need a solid agricultural sector throughout Canada so that all Canadians can buy local food, that they can also share with the whole world to help feed the growing population with sustainable foods. And that's why the new partnership, the agricultural partnership, is being established for long-term sustainable production in Canada. It represents a new, brave vision that will help the agri-food sector to innovate, grow, and prosper. On the 1st of April, ministers of agriculture from throughout Canada launched this partnership as a common vision for the future of agriculture in Canada. Over the next 5 years, our government will invest $3 billion in that partnership. Out of that investment, more than $1 billion will be used to support federal agricultural programs. These programs will support 3 important things. First, expanding access to market and innovation and growth in the sector and supporting diversity. Canadians want to make enlightened choices when it comes to the food they consume. They want to be able to trust that they are eating quality food. The Canadian Partnership for Agriculture is the first strategic framework to explicitly recognize that that public trust is a priority in our agricultural sector. A new agri-insurance program will also help and strengthen this system and the public trust.
Producers tell customers about the great things farmers and food processors are doing to grow safe, high-quality food, care for animals, and safeguard our environment, so that customers, whether they buy local or international, know that the red maple leaf is a symbol that they can trust. Our new $20 million agri-competitiveness program will also help organizations raise awareness of our world-class agricultural industry among Canadians. This will reinforce the public's confidence in Canada's food production system and promote public trust. Partnership programs are also breaking new grounds with strong focus on diversity. The more perspective we have in agriculture, the more dynamic the sector becomes. So through our new $5 million Agri-Diversity program, we will reach out to women, Indigenous communities, and young people. It is important that we remove any barriers that are preventing these groups from taking up leadership role in that sector. The diversity helps give local food system the capacity to offer distinctive, high-quality food choice to consumers. Of course, when it comes to agriculture, we are a trading nation, and partnership is geared to opening markets. We export half of all our agricultural output, and the government knows that trade also drives jobs and economy. Alors voilà pourquoi notre objectif est de faire en...
And that is why we want our exports to achieve $75 billion by 2025. Our partnership program will help the sector to promote Canada as a producer of high-quality food that presents no danger to our health. Our producers and processors will be able to sell more products from here throughout the world. That will strengthen this local food movement, and it will also help food tourism. Mr. Speaker, Canadian agriculture has a bright future ahead. We have many high-quality lands and many microclimates. You want ice wine? Our ice wine is some of the best.
Target of $75 billion in agricultural export by 2025. For top-quality grains, look no further than the prairies. In fact, a public-private group in Saskatchewan was selected as one of the 5 new superclusters under our $950 million investment in budget 2018. Alors, je crois que nous sommes tous d'accord.
I think we can all say that tasting local food is a very good way to stimulate the economy.
Even more of our prairie grain into high-quality plant protein to feed the world. With the new programs available under the Canadian Agriculture Partnership, we are giving farmers and food processors the tool they need to keep agriculture diverse and vibrant right across the country. A yearly National Local Food Day would be an opportunity for Canadians to take a look near them and see what's growing. So once again, I would like to thank the member from Kootenay, Columbia, for all his hard work on this bill, and I certainly look forward for the bill to pass before the end of this Parliament. I hope it does, and we are certainly proud to support it. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Lévis-Lotbinière. Thank you, Mr. Speaker. It's a great pleasure for me to rise today and speak to Bill C-281, an act to establish a National Local Food Day. I'd like to salute the initiative of my colleague from Kootenay, Columbia, in this House, and I'd like to take this opportunity to point to how important it is to honor women and men who devote themselves day in and day out to provide us with healthy and local food. I'm pleased to see that the trend is that there is a Canadian trend to know where the food we eat comes from the gate to the plate. We should all keep in mind this saying for the benefit of everyone and all families, because these local foods are good and they are produced nearby. Mr. Speaker, this is a getting back to basics, which is to know what we're eating, where it comes from, and who is producing it. The lucky ones among us are those who know they're lucky farmers. These farmers are the masters of their craft, and they can share their passion and their know-how. By maintaining this relationship, we're helping guarantee abundant harvests and the satisfaction of knowing that we are eating high-quality foods. By buying at local markets and in public markets, we can help support in a very real way our local economy as well as our environment. When we bypass various steps in the food production chain, we help to reduce greenhouse gases, and this also supports the new generation of farmers and the local economy. Mr. Speaker, I'm proud to say that in Lévis-Lotbinière, we support local products and artisanal products. Here is your proof, Mr. Speaker. And in passing, I'd like to thank all the organizations who serve local artisanal foods from Lévis-Lotbinière by incorporating them into the dishes on their menus. All you have to do is look at the booths in our markets, the fruit and vegetable stands in our riding, and you can find fruit and vegetables throughout the summer and fall. They taste so good. They're so delicious. We should all be aware that every time we buy local foods, besides supporting our local producers, we're actually investing in our own food security for today and for the future. Here in this House, we can do more and we can do better by taking steps to expand this local production initiative. We can invest in innovative new products, new cultivars, new strains of fruit and vegetables that are more resistant to weather events and pests found in nature. We mustn't forget those who work in the food processing sector, Mr. Speaker. I'd also like to draw your attention to the fact that for 20 years now, in my riding, we have been trying our constituents to eat local. I'd like to talk to you about a specific organization that really stands out. It's called Goûter Lotbinière, A Taste of Lotbinière. This organization has grown over the years, but it started in January 2000. The purpose of this gathering was to pool the experience of everyone in order to be able to better meet the needs of the producers and processors in Lotbinière.
They wanted to pool their efforts to promote and market local artisanal products from the RMC of Lotbinière. Since 2000, several other organizations have come on board, including the Centre Local de Développement, the RCM of Lotbinière, the Desjardins Credit Unions, the Union of Agricultural Producers, and the Canada Deposit Insurance Corporation. From year to year, the groups who form a taste of Lotbinière have participated in various activities in Lotbinière. In fact, these activities have taken place elsewhere in the Nouvelle France Festival, the Quebec City Old Port Christmas Market. They took part in special activities involving the Quebec-Lévis Ferry and many more. Many businesses have benefited from the services of this organization, which is growing, and that's why it is perfect timing to have National Local Food Day just before Thanksgiving. It's the right time to raise awareness about the agri-food sector and the role it plays in our lives. We need to buy their products, which are very good. Perhaps this way we will discover new success stories in our own backyards. And that way, perhaps one day we will say, I was there at the beginning, or I was one of the first to have bought these products. I encourage all producers and processors to take part in contests to find out where your food comes from. In fact, Canadians are very positive and enthusiastic when it comes to these efforts. So I invite all Canadians to make a list of their local producers and processors and then go out and buy and savor their local products. You will contribute to building strong relationships in the interest of growing economic prosperity by buying local. In fact, there's another thing I'd like to talk about. It's a new national and international phenomenon, farm tourism. More and more people want to take part in agro-tourism. They will buy agro-tourism maps, they will visit farm museums, or they might simply visit many of our farms which offer pick-your-own fruits and vegetables options. These farms attract many foreign and local visitors. And this is a way, again, to encourage people to eat local. As well, Mr. Speaker, some people organize their holidays around lodging and restaurants offering local foods. They are interested in certain cultural and sports and educational activities which take place in a rural setting. So, Mr. Speaker, we're talking about global health, physical health, environmental health, and this is a good thing. So it's up to us to shape the fate of our regions, and I encourage all of my colleagues to support Bill C-281. Thank you, Mr. Speaker. Resuming debate, the member for Saint-Hyacinthe-Bagotte. Mr. Speaker, it's with honor that I support the bill to create National Local Food Day. In fact, creating this day is something I care about because I represent Quebec's agri-food technopolis, where agriculture truly is the driver of economic development in our region. In the riding of Saint-Hyacinthe-Bagotte, we know just how important local agriculture is for farmers and consumers. In fact, on November 18th, there will be a large citizens' march in Montreal under the theme, Our Pantry is in Danger, to help protect agriculture at home. I invite all of you to join us and show your support for our farmers who work hard to feed us and to guarantee good products on a daily basis. These are tough times for farmers, and we really have to get together and help them. Bill C-281 is a bill which would bring together producers and consumers who care about eating local. We have to show our gratitude and support to local producers who work tirelessly on behalf of all of us. Putting this day on the Friday before Thanksgiving allows us all to celebrate together, local producers and citizens. Local food, or rather, eating local helps producers to gain a better income and helps to build relationships with consumers. For consumers, the benefits are fresher in-season food and better traceability of their food. More and more people are aware of what is in their plate and of the importance of supporting neighboring farms. People have had enough of excessive packaging. Eating local is something good for the planet. The David Suzuki Foundation has the One Nature Challenge, which lists buying local among the top 10 most effective ways to reduce our environmental footprint. On average, a farmer feeds 50 families, uses less land and less water. So choosing to buy local is the right choice, and obviously so. A study carried out by Toronto Food Share even showed that local farmers market food travels on average 101 kilometers, whereas an imported food product travels on average 5,364 kilometers, which produces 100 times more greenhouse gas emissions than if a person bought locally. Buying locally helps to reduce plastic food packaging, which is often used when bringing products to market. Let's not forget that this packaging represents 70% of plastic waste in the world. The flavor and the quality of Canadian products are upheld under federal production standards, including in Quebec. And these standards are a guarantee for us consumers. By fully supporting our producers, or rather, when we fully support our producers, it supports them. It's even more important since we've opened our borders to American farm products. Quebec's food products must meet certain standards not required of imported products. Local producers can be at a disadvantage because imports can be less expensive as they may be produced using inputs banned in Quebec. Buying local means stemming the flow to these imported products and supporting our own producers. Quebec products are labeled, and it is possible to trace their origins. For instance, we are able to know which farm their eggs come from by looking up the egg.ca code printed on the shell. Local Food Day is a strong symbol which we can share, pass on to our citizens. It's an excellent way to, it's an excellent way to support citizen initiatives in the legislation and encouraging the development of family farms who have been left somewhat behind by big farming operations. It is important for us to add this day to our calendars. National Local Food Day will raise awareness about how difficult it is for many Canadians to gain access to safe and affordable food close to where they live. I am proud to represent in this House the riding of Saint-Hyacinthe-Bagotte and to be the voice of our producers who work hard every day. I would like to thank them today, all of them, for their involvement and their contribution in making the riding more dynamic and in growing its economy. Local agriculture is part of our identity, and we're very proud of it. Throughout this country, we have to pay tribute to all of these farmers who work hard in order to ensure our food autonomy and to feed all Canadians. Today, more than ever, we have to point out that it is important to buy local in these difficult times for our farmers. I would like to recognize the RCM of the Mascoutin and the UPA Montérégie, as well as the farmers in the Montérégie Est region. I would like to thank them all for their excellent work and their ceaseless defense of the interests of our farmers. They ensure the vitality and the importance of the Montérégie, which is the pantry of Quebec. Eating local guarantees our food autonomy, maintains our local know-how, and the revitalization of our farmlands. It also creates jobs. It is an issue which affects all of us. The citizens the people of Saint-Hyacinthe and Acton Vale never stop telling me how important local farming is to them, how it is important to protect them and to pay tribute to these farmers. Bill C-281 would be a complement to the National Agricultural Day, which is held in February, by focusing on local production and related sectors such as the restaurant industry and local artisans. Food is a necessity, and it is very important that people have access to good food in the interest of protecting public health. Bill C-281 is a way for us to pay tribute to our local producers, to show them that we are grateful to them as they work hard to feed all of us. They help to put Canada on the world map thanks to their hard work and their commitment. Since 2011, the NDP has supported the Canadian Food Strategy, which ties together objectives related to the environment, health, and food quality throughout the country. Access to healthy, affordable food is a priority for the NDP. We therefore have to support our local agricultural markets. I have the honor of representing a very fertile riding where the soil is rich, and the citizens of Saint-Hyacinthe and Acton Vale can meet their local farmers at the public market in Saint-Hyacinthe. There are all kinds of stalls, and I would also like to highlight the various activities such as the Agri-Food Fair in Acton and Les Matinées Gourmandes. I would also like to thank the restaurants who which use local products in their menus, and supermarkets which make place on their shelves for local products. I would also like to thank the directors of the Saint-Hyacinthe Technopolis, which sells our local products in the tourism information kiosk in the convention center. It is a wonderful way to showcase these products from our region. In these many places, the citizens of Saint-Hyacinthe and Acton Vale can find wonderful products: cheese, milk, eggs, all kinds of fruits and vegetables, and more. We are all very proud of these products, and producers are very happy to have relationships with their consumers. So, Mr. Speaker, I fully support my dear colleague for his bill, which will create the National Local Food Day. It's important to celebrate local food as much in British Columbia as in Quebec. Thank you very much, Mr. Speaker. Resuming debate, the Honourable Member for Saint-Jean. Thank you, Mr. Speaker, and thank you to the member for Kootenay in British Columbia for having introduced this bill to create National Local Food Day. In my view, every time we talk about farming and food, it's a good day in the house. Farmers and food processors in Canada work hard every day to produce the food which ends up on our table, and they contribute to Canada's food autonomy by ensuring the safety of our food supply. It's a privilege for me to speak today to underscore their contribution to our great country. And this is why I enthusiastically support Bill C 281, a bill which our government is also happy to support. We cannot insist enough on the importance of food and agriculture to the health of our citizens. I would also like to say that the safety of Canada's food products is recognized throughout the world. From the gate to the plate, our food and agri-food system generates over $114 billion of our GDP. The Canadian farm sector is growing, which is being noticed. The Economic Advisory Board, chaired by Dominic Barton, recognized the huge potential of this sector. And this advisory board, in fact, believes agriculture is a key growth sector of our economy. This sector can help ensure a prosperous future for the economy, the middle class, and our country. World demand for food is growing at an unprecedented rate. It is estimated that farmers will have to produce as much food over the next 45 years as they have over the last 10,000 years. Not only is demand for food growing, but it's growing for the type of quality food which Canada's farmers produce, which is why the government has given itself an ambitious goal, which is to increase these exports by $75 billion by 2025, and we're on track to meet that objective. Even though Canada can play an important role to feed the world, new markets are also emerging closer to home. Our local producers and processors are drivers of economic prosperity, which is why I'm happy to speak on behalf of the government and say that we support this bill. National Local Food Day will be an opportunity to recognize the contribution of food and the agri-food sector to local economies. It would also be an opportunity for Canadians to learn more about the food that is in their plates and how it actually got there. But National Local Food Day would also be an opportunity to recognize our producers and processors. More and more Canadians are buying local. Based on a study conducted last year by Restaurants Canada, local foods are one of 5 major restaurant trends in Canada. Many provinces have already launched local buying initiatives, and these initiatives help to highlight local products and attracts tourists as well. These initiatives bring together restaurants, chefs, farmers, and help to grow the economy. These initiatives also help to grow sales in the tourism sector, and local producers will therefore be able to know which products sell. We can also increase our food exports when a region is recognized as a provider of choice of certain foods. When consumers choose to eat local, and when there are special markets and local food supply chains, it benefits small and medium-sized enterprises. These enterprises can offer various choices which integrate local flavors. In the riding of Saint-Jean, there are local products found everywhere in the region, and consumers are happy to buy local at the local market. In Saint-Jean-sur-Richelieu, at Sainte-Brigille, the Odia Gardens produce excellent ciders. Saint-Grégoire is known for its orchards. Denis Charbonneau and Léo Boutin produce apple ciders, or ice wines. There are also dairy producers who are well recognized. Certain cheese producers have won major prizes in Saint-Brigille. Elsa in Saint-Jean and Stéphane Blé in Lacolle produce much-loved cold cuts. In L'Acadie, the Mas des Patriotes, and in Saint Blaise, the 1282 Vineyard are all recognized for the quality of their products. In Saint Valentin, the City of Love, Louis Hébert has pick your own strawberry fields, and people can even process these strawberries into other products. A successful local food business is something that we should apply across the country as it benefits all Canadians. Provincial governments have a role to play in terms of the importance of their products. And all provinces can work together in this regard. In fact, many provinces and territories are implementing local food production strategies. For these strategies to work, however, they need provincial support and good structures so the food ends up in the plates of consumers. The provinces and territories are working with federal government to fund various local food production programs, and under the former agricultural program, investments were targeted to meet local needs. Therefore, the government could provide local farmers the tools they needed to remain competitive and innovative and to enter new markets, including markets for local foods. For instance, in Quebec, we have invested $5 million to develop local markets. The initiative was entitled Programme Proximité and encouraged farmers to take advantage of local business opportunities. The funds were used to integrate many farm products into food markets, restaurants, and stores. There is also a program to improve food products in New Brunswick. It supported farmers to help them find new local, national, and international markets. Mr. Speaker, let us bet on a new Canadian partnership for agriculture. Let's make this a 5-year project. The federal, provincial, and territorial governments will invest $3 million into this plan to ensure the growth of the Canadian farm sector. This program will set aside $2 million in 6 programs and activities which will help to strengthen the sector and make it even more innovative and sustainable. $2 billion are available across the country at all levels of government, and the provinces and territories will therefore have the margin, or rather will be able to help their local markets. Mr. Speaker, farmers benefit from the support of Canadians as well as from the support of this government. We're there to help people in all sectors to become farmers. We're there to support them by providing programs and services within the Canadian Agriculture Partnership to help them grow their businesses. And the government is there to help defend them around the world, to help a growing world population. We are therefore happy to support Bill C-281 because when Canadians buy local, they inject money into their own communities and they help to create jobs and create sustainable economic development. And by buying local, we are reducing our environmental footprint. This is a wonderful way of growing our economy. Thank you very much, Mr. Speaker.
Reprise de débat. Accordingly, the honourable member for Kootenay-Columbia will have up to 5 minutes for his right of reply. The honourable member for Kootenay-Columbia.
Thank you, Mr. Speaker. Clearly, local food inspires. And I'd like to start by thanking my constituents from Kootenay, Columbia, for inspiring me to move Bill C-281 and for building our local food economy. I'd also like to thank my colleagues in the House for all of their inspiring speeches. You could see how excited they are about local food in their particular ridings, as they should be. So why should we support local food? Well, first of all, as you know, it's healthy. You know where it comes from. You know who is producing it. It's important for the economy. It puts millions of dollars into the local economies. It brings tourism to communities. I saw that in the farmers markets that I visited this summer. And of course, it's also important for farm stay tourism and restaurants. When people travel the country, they look for local food in local restaurants. It's environmentally friendly, reduces carbon dioxide and the use of plastics, provides community food security, and it keeps farmers farming, which we absolutely need to do across Canada. And it brings together families and communities. Healthy local agriculture also means a healthy local environment. You need healthy soils. You need healthy pollinators to make farming and local food work. It leads to protection of water and watersheds, and it protects agricultural land from development. So how can we encourage local food? Buy locally, support local growers and farmers, ensure healthy local fish and wildlife populations and the opportunities to harvest them in rural areas. Ask your local mayor and councils to provide vacant city lots to be made available for agriculture right next door. Look for ways to remove any barriers from farm to fork, and encourage all levels of government to focus on local food and local food security. And lastly, encourage your senators locally for people around Canada and for people in the House here, if you know people in the Senate. Talk to your senator colleagues and support the timely passage of Bill C-281 in the Senate, so that all across Canada we can celebrate local food on Friday, October 11th, 2019, as part of National Local Food Day. Thank you, Mr. Speaker, and thank you to all my colleagues in the House.
The question is as follows. Mr. Stetsky, seconded by Ms. Sanssouci, moved that Bill C-281, an act to establish a National Local Food Day, be read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes? Yes. Agreed? Carried.
Third reading of this bill.
Et maintenant, à ce moment-ci,
And now, at this time, pursuant to Standing Order 38, a motion to adjourn the House is deemed to have been moved and seconded. Consequently, the question is as follows: that this House do now adjourn. The Honourable Member for Saint-Hyacinthe-Bagotte. Mr. Speaker, I rose in the House to ask this government to act so that the 1.2 million children living in poverty have a fair chance. This week, the Minister for Families moved his bill to reduce poverty in Canada and to help, and I quote, 650,000 people out of poverty. This document only has 6 pages. This bill, this is a government bill, does not have any funding, and it has no programs outlined in it. There's nothing for affordable daycare throughout the country. Nothing to make sure that our seniors and families have access to the medication that they need. Nothing to make the guaranteed income supplement automatic for all seniors. Nothing for dental insurance for those who cannot afford it. Nothing for social housing, nothing for affordable housing now. Nothing to set up a guaranteed minimum income program. Nothing for our low-income workers who sometimes work 50 hours a week and still have to use food banks. And I could go on, Mr. Speaker. With 1.2 million young people under 18 years old, 20% of the children of our country living in a low-income household, Canada has truly not improved the situation of vulnerable children over the last 10 years. Other than First Nations, or rather including First Nations, child poverty affects immigrants, recent immigrants, and single-parent families. Natalie Appleyard, a spokesperson for the Campaign Town 1000, a Canadian coalition including 120 organizations that fight poverty, decries the lack of ambition in the bill. She indicated that if we were to reduce poverty by 50% by 2030, there will still be 600,000 children living in poverty. That is significant for a country as rich as ours. And that's what we see when sending checks by the mail, such as the Canada Child Benefit, that this does not get rid of poverty. I said yesterday at a press conference that the bill was not going to get a single child out of poverty. People who are poor today will still be poor tomorrow. Campaign 2000 adds that this does not offer a great deal of comfort for children who do not have enough to eat now and who don't know where they're going to live next month. Because yes, poverty almost always goes with food insecurity. Many children from poor families do not have access to the nutritional resources that they need. How can we accept this? And how can we set up a bill without any measures or funding? Mr. Speaker, we must also target a population that is particularly neglected, which are Indigenous persons. They are the most vulnerable among our most vulnerable. Throughout the country, 38% of Indigenous children are living in poverty. Campaign 2000, which represents 120 organizations, proposes solutions to eradicate poverty, and I invite my honourable colleague on the other side to hear them. They're asking for the Canada Child Benefit to be increased, to improve the employment insurance program, and to set up a universal daycare system. And so, on behalf of the 120 organizations that Campaign 2000 represents, but especially on behalf of the million people who are living in poverty, when will this government increase CCB benefits, improve EI, and set up a universal health care program? Thank you very much, Mr. Speaker. The Honourable Parliamentary Secretary to the Minister of Public Services. Thank you very much, Mr. Speaker, and thank you to my colleague. We often talk about other issues that deal more directly with my department, but I'm very pleased to rise this evening to speak to the subject that has been raised. This is a crucial subject. We need to eradicate poverty. Mr. Speaker, our government, since it took power, has been working very, very hard to reduce poverty for everyone throughout Canada. We've set up initiatives, set up real measures to reinforce the middle class. We've emphasized especially helping those who wish to join the middle class. Soon after we took power, we increased, of course, taxes on the wealthiest 1%, but we took all that money and we used it to cut taxes for the middle class. We also added on to that. We made significant investments for children, for seniors, for lower wage workers, and for other vulnerable Canadians. These investments are having significant impacts on reducing poverty and making a difference in the lives of people.
The government has invested $22 billion toward eradicating poverty for all Canadians. We're making solid progress, Mr. Speaker, in programs like the Canada Child Benefit, more generous benefits for seniors, early learning and childcare, and housing. Investments that I will note that were, unfortunately, all opposed by our friends in the New Democratic Party. By 2019, these investments will have helped lift more than 650,000 Canadians out of poverty. Cette semaine, nous avons déposé le projet.
This week, we tabled Bill C-87, the Poverty Reduction Act. This fulfills a promise that we made as part of Canada's National Poverty Reduction Strategy that was announced by my colleague during the summer. This legislation will implement 3 key elements that demonstrate our government's real commitment to be a world leader and a full partner a progressive partner in the fight against poverty.
Poverty reduction targets that will help Canada achieve its lowest levels of poverty in history within a decade. We're going to establish Canada's first ever official poverty line so that the fight against poverty can be guided by statistics and data instead of partisan ideology. And we're going to appoint a National Advisory Council on Poverty through our open, transparent, and merit-based appointment process to ensure that people with lived experience have a voice in the decision-making progress. The Council will also provide annual reports telling the government and Canadians how we're progressing. And these are critical tools because our government understands that poverty is a complex issue requiring a multifaceted approach. Monsieur le Président, nous sommes conscients que les autres...
Mr. Speaker, we are aware that the government, all levels of government rather, have essential roles to play. I am confident, however, that progressive measures that help to unite political stakeholders will be able to help people work together to fight poverty in Canada and offer real solutions. Thank you, Mr. Speaker. Mr. Speaker, the HUMA Committee conducted a lengthy study on poverty and published its report. We received the government response to this report. However, the legislation tabled this week does not even go as far as the government response to that report. Yes, there's targets and an advisory committee, but there's no definition. Did you know, Mr. Speaker, that in Canada we don't actually have an official definition of poverty? We don't know what we're talking about. Also, when it comes to research, there is nothing available to tackle the fundamental root causes of poverty. Several researchers have said that we need to conduct research. Yes, we talk about partnerships, but it is not written in the law how important it is to work with the various groups in Canada. They have all said that cities, provinces, territories, Indigenous persons, and the federal government all have to work together. And to conclude, Mr. Speaker, lovely words are not enough anymore. People who live in poverty need action. The Honourable Parliamentary Secretary. Thank you, Mr. Speaker. We know that we have to unite all of the players, all of those who mobilize in Canadian society to lead this endless fight against poverty. On that, I have a difference of opinion with my colleague. I will say that we have taken real steps, tangible steps. We've invested real money that will reduce poverty in the most significant way since the beginning of the establishment of our state. The Canada Child Benefit helps our families every single day. The Guaranteed Income Supplement helps seniors every single day, Mr. Speaker. The tax credit for low-income workers helps people to overcome the barrier of social assistance and reintegrate the labor market. Our efforts in matters of poverty reduction are substantial, and they will continue, Mr. Speaker. Thank you.
A motion to adjourn the House is now deemed to have been adopted pursuant to an order made on Friday, September 21st, 2018. This House stands adjourned until Monday, November 19th, 2018 at 11 a.m. pursuant to Standing Order 28-2 and 24-1.